Amit Bansal is about to reach in the next 4 to 5 minutes. So in the next 3 to 4 minutes, we'll be starting officially with the conference. Thank you all for joining in on this Saturday morning. And it is wonderful to see the energy in all of the crowd. Thank you very much.
Good morning, everyone. So, I would just like to request you that during the conference, we request you to keep your phones on silent and please avoid getting eatables such as eatables and any liquids inside the conference hall. That's all we request you. Thank you. Please welcome our chief guest for the conference, Honorable Justice Amit Bansal, sir.
Good morning, esteemed guests, honorable speakers, distinguished colleagues, industry leaders, faculty, students, and fellow innovators. It gives me great pleasure to extend a warm welcome to each one of you to this conference on standard essential patents. SEPs have assumed critical importance today, particularly as next-generation technologies such as IoT, 6G, and autonomous vehicles increasingly rely on standardized systems. This conference seeks to provide participants with practical and actionable insights to effectively navigate the complexities of SEPs in today's globalized and rapidly evolving market landscape. With that brief, may I now invite our esteemed panelists for the inaugural session on the dais, please. Honorable Justice Amit Bansal, sir, Judge, Delhi High Court. Mr. A.K. Mittal, Director General, Telecommunications Standards Development Society, India. Mr. Amit Datta, Co-Chair, FICCI IPR Committee and Managing Counsel, ADP Law Offices. Ms. Payal Malik, Visiting Professor, Career and former Advisor and Head Economics, Competition Commission of India. Mr. Praveen Anand, Member, FICCI IPR Committee and Managing Partner and Head of Litigation at Anand & Anand. Thank you for gracing the dais with your esteemed presence. May I now request Mr. Praveen Anand to felicitate Honorable Justice Sir with a small token of appreciation. May I now request our co-chair, Mr. Amit Datta, to please felicitate Mr. A.K. Mittal. Thank you, sir. I now invite Mr. Amit Datta to deliver a welcome address, please. Sir.
Good morning, everybody. Mr. Justice Amit Bansal, Mr. A.K. Mittal, Mr. Anand, Dr. Malik. Welcome to colleagues and friends. It's a pleasure to welcome you all to this important conference on standard essential patents, a subject, while you can make out from my little nervousness, which is alien to me, largely, a subject that, while deeply technical, holds immense strategic significance for India's innovation future. I have to confess, as I've already done so, I come from largely the world of creativity, where the word standard is not always seen in the best light, where the creative industries tend to rebel at standardization and thrive on the unique, the expressive, and the unpredictable. If something is standard, we usually look to break it on the creative industry side. But yet we are here gathered to celebrate the very idea of standardization, and rightly so. Because in the modern digital economy, connectivity and cross-border interoperability, being standard is not ordinary, it's essential. The intersection between innovation and enforceability, between open markets and proprietary technologies, is precisely where standard essential patents reside. As India charts its vision for Viksit Bharat at 2047, SEPs will play a pivotal role in ensuring that our enterprises are not merely technology adopters, but also standard setters, making meaningful contributions to the global IP landscape. India already has established itself as the world's largest startup ecosystem with over 100,000 or 1 lakh startups recognized by DPIIT and a thriving base of more than 100 unicorns. This vibrant entrepreneurial landscape is reshaping innovation and unlocking opportunities across diverse sectors. There is an urgent need to build awareness on intellectual property rights as well as SEPs, particularly within the research community and among techpreneurs with a special focus on the startup and SME sector. FICCI has consistently championed the cause of building a balanced and forward-looking IP ecosystem. This conference is a manifestation of that commitment, providing a platform for constructive dialogue among innovators and implementers, academia and industry, as well as regulators and right holders. A special thanks to our partners at ICRIER and to all the esteemed speakers and participants who have joined us from the judiciary, from academia, government, industry, and the bar. Your insights today will help shape a robust roadmap for India's SEP engagement, one that is fair, globally harmonized, and innovation-friendly. With that, I would like to welcome my colleague and co-panelist, Dr. Payal Malik, to share her opening reflections. Thank you so much.
Thank you, Dr. Amit Datta. Good morning, everyone. On behalf of ICRIER, I welcome you to this conference on India's Cellular Standard Essential Patents, SEPs, Innovation Ecosystem for a Viksit Bharat. This conference has been organized at a very opportune moment to explore options that strike the right balance for all stakeholders involved and has a right mix of instrumentalities, including policy, regulation, and judiciary. India is the second largest telecom market in the world, a position of immense strategic significance. Under the transformative national missions such as Make in India and Digital India, we are not only consolidating our status as a global manufacturing hub, but also aspiring to be a leading innovator in technology development. Among our ambitious goals is securing 10% of the world's 60 patents and playing a constructive role in shaping the standards-making process for this transformative technology. In frontier sectors such as telecommunications, artificial intelligence, semiconductors, and IoT, India's startups and SMEs are already shaping solutions that may define next generation of global standards. Yet, without an enabling ecosystem that encourages patent creation and active participation in global standard setting, India risks remaining a net implementer rather than a technology creator. The global economy has shifted towards a mode of production in which knowledge is a key input. And at the core of the knowledge economy is innovation. The ability of an enterprise to translate knowledge into innovation and commercialize it determines its competitiveness. This holds true for nations as well. Policymakers around the world are thus laying greater emphasis on creating an ecosystem that encourages innovations. The discussions today, and we hoped chose to partner with FICCI because of the FICCI's inroads into industry and many other stakeholders, so that we get information from the ground and get participation from the ground, also comes at a moment of shifting global innovation currents. India has already taken commendable steps from establishment of the Anusandhan National Research Foundation and a proposed 1 lakh crore Research and Innovation Fund. Yet, our private sector R&D investment remains below 0.3% of GDP. And total R&D expenditure has stagnated to 0.64 for over a decade. Addressing these gaps requires a strategic shift, and this means addressing structural failures in the innovation ecosystem. This includes not only market failures, but also fragmented coordination amongst actors, weak absorptive capacity in industry, and the absence of a coherent long-term policy which is consistent and predictable. Innovation is endogenous and not a byproduct of industrial growth. Hence, we need a modern industrial strategy that embeds ex-ante incentives through a robust IPR regime and promotes an innovation culture and supports programs that incentivize the same. Our geopolitical environment adds to this urgency. Strategic moves that strengthen the innovative capabilities of Indian firms are now a national imperative. As India seeks to leapfrog development stages, it must remember that one cannot buy or expropriate its way into the future. Rather, it must invent and innovate its way in. It is in this backdrop that ICRIER's work on India's cellular SEP ecosystem becomes especially relevant. As a concluding installment of our three-part research series, our forthcoming report offers a comprehensive analysis of the SEP innovation landscape in India, drawing from extensive consultations with SEP holders, startup founders, academics, and policy makers. While international debates such as the European Union's proposed and later withdrawn SEP regulation highlight the complexities of regulatory intervention in this space, our challenge in India is both direct and pressing. We must develop a framework that is tailored to our economic realities, aligned with our legal structures, and consistent with our global aspirations while also remaining informed by international best practices. If I want to filter one single question which should be deliberated throughout the day in the various sessions, is the natural question is will such a framework look like? Would regulatory intervention or market-driven mechanisms be more effective in governing cellular network SEP licensing in India? In many ways, the deliberations we take today are directed at answering an overarching and critical question: whether private ordering instruments, that is, negotiations and contractual arrangements between parties, provide a balanced and effective solutions to potential inefficiencies in the SEP licensing ecosystem, leaving the dispute resolution to the courts to address the inherent complexities of this domain. If our discussions do reveal that there are frictions in the system, the task before us will be to identify solutions that can reduce these frictions with the least possible distortion, ideally without resorting to intrusive regulatory intervention. In the absence of empirical evidence regarding the SAP licensing and innovation ecosystem in India, it is difficult to define the contours of an optimal policy response. Against this backdrop, a forum such as this is both timely and necessary. The questions which we'll be exploring in this forum are not a mere academic exercise. For India, this is a matter of strategic importance. They are rooted in the real and pressing need to create policy recommendations that incentivize the participation of startups, SMEs, both as creators of SEPs and as implementers of standardized technologies. The Indian IoT startups are already involved in integrating the hardware that contains standardized technology covered by SEPs. In the absence of these technologies, the Indian IoT industry would have not been able to emerge due to the virtual absence of advanced hardware design and fabrication industries in India. A greater share of the key SCPs in critical technologies will strengthen our technology sovereignty and enhance our geopolitical positioning. Looking ahead, our emphasis must be on building institutional frameworks that are capable of supporting the monetization of undervalued patents, offering accessible and predictable channels for dispute resolutions, and creating long-term pathways for converting academic and industrial research into market-ready intellectual property. Streamlining enforcement mechanisms and reducing the transaction costs would also be crucial to enable innovators with limited resources to engage meaningfully in the SEP ecosystem. With these words, on behalf of ICRIER, I welcome all of you and look forward to the discussions that will follow. Thank you so much.
Thank you, Ms. Malik and Mr. Datta, for your thoughtful remarks. May I now welcome Mr. A.K. Mittal to deliver the inaugural address, please.
Namaskar, good morning everyone. It is really encouraging to see a full house on a Saturday morning, and that too. When I arrived, I thought I may be one of the earliest, but there were already people here enjoying tea and coffee. So it's really encouraging to see the interest. So I am from TSDSI, which is full form is Telecom Standards Development Society India. Just briefly introduce you with this organization. We are the only telecommunications standard organization of India, recognized by Department of Telecom, and we work as a non-profit society driven by members. And our membership includes anybody and everybody from telecommunications industry, whether from research or development or manufacturers, service providers, solution providers, and even the users or the vertical industries who are the users of the telecommunication facilities who provide inputs for service requirements. They are our members. Currently we have 100 plus membership, and these are the people who drive standards formulation process in our study groups. So there is a whole detailed setup, so I will not go into that. So but I think before that I should have thanked FICCI and ICRIER to have invited me here to be part of this conference. I am really happy to be here and privileged. Patents I am seeing, and you must be seeing that for last few years there is a lot of discussions which are happening across industry segments, in government, everywhere about patents. So what is so new? The patent laws have been in place. If I remember correctly, 1970, the patent laws were made. The importance of patents were recognized as far back as 1970. They are in place, the infrastructure, the patent office, everything is in place. But last few years, we see there is a lot of debate and discussions everywhere about patents. I think this is indicative of the penchant for innovation, which is all across visible over last few years, and awareness that these innovations, what we are doing, the industry is doing, is something which can be monetized. Earlier we filed the patent and we never knew when and how to monetize it. And especially in telecommunications, the sheer volume of patents which are being generated, I think there is the opportunity is very well there. We have a startup ecosystem, we have MSMEs, we have large companies. There is an ecosystem available. Only thing is that the topics which are going to discuss today here or which are being deliberated, certain solutions and certain enabling framework which is required for furthering the development of patents and their monetization. And this technical prowess which is developing in India, how to channelize this into standards. And now, and why only in standards? Why should we call something as standard essential patent? See, telecommunication by far is the most organized standards development industry. Other industries, I'm not sure, but there may be small efforts. But in telecommunication, most organized way of developing standards and inclusion of technological solutions for giving desired features is something which is happening in the standards bodies. And as already mentioned, interoperability of telecommunication systems is something which is most essential. That if you can't work in monopolies. There was time in telecommunication when monopolies were in picture, they were monopolistic systems. But then with innovations happening all around and seeing that interoperability is a must. All that has gone, and now it is the realization that collaboration is something which all the industry segments have to do to arrive at standards which are interoperable. So the best way to monetize the patents is standards, because when you have standards, the equipment will be made to comply to those standards and the patents will be implemented. So everybody with their patents, they don't go with the patents, they go with solutions which are patented. Now, here lies the complexity. When you go to the global standards bodies, especially if you talk of mobile communication, 3GPP is the body which is responsible. The de facto standards for mobile, they are coming from 3GPP, and 850 plus companies from across the world are members of 3GPP who come with their proposals inside 3GPP for creating standards, whether it is 3G, 4G, 5G, or now 6G work has begun. And all that which is taken to 3GPP is not something, do we expect that everything will be accepted? The answer is no. Whatever you take, majority of it is not accepted there. And acceptance or non-acceptance is not somebody's whims. There is a process which is set for submissions. But beyond the process, there is something where you need collaboration and networking. If you go alone and say that, okay, I will fight alone and get my proposal included, it is something which will never happen. There must be supporters for your proposal, and they must see advantage in what you are saying to themselves. And in the initial phases, this approach of acceptance of proposals, actually in initial stages is created certain kind of clubs inside the standard bodies. Okay, you accept my proposal, I accept your proposal, or we work together. The overall game and focus energies and see which are the areas where we can pool up our energy in India, do some hard work and take some solid proposals so that hard work pays. piecemeal work will never pay. So there is a challenge to the companies who or R&D organizations or whomsoever goes there, at least from India, because our system is all just in a beginning stage. It has moved ahead, but it's still in the beginning stage. So there are challenges of submitting contributions to the global bodies and getting them accepted, and ensuring that those patents which go there, they actually really become standard essential patents. Standard essential patent, as the name implies, is that when you implement the standard, that patent must be essentially implemented to realize that equipment. So some patents may be there, but they may not be necessary to realize the equipment. They may not be monetized. Or if somebody does that, then you have a chance to monetize. So standard essential patents. So starting from your innovation to submission of contributions to the standards, and then getting standards published and seeing that whether they are converted into SEP or not, it's a long cycle. And finally, added to it the implementation finally. So we have to be prepared for that and identify challenges for the industry. And the other challenge comes is from patent licensing. Licensing is one of the areas where lawyers play a big role in filing your patents and seeing that when you license, you have a good terms which are agreed. And then there are courts, because there are lots of litigation which happen, and there can be two reasons. At one end, there is a user of the license or the user of the patent. Other end is a licensor of the patent. So the licensor may have a tendency to get maximum price out of it, and there can be a patent holdup, that they don't grant license till they arrive at a price. On the other hand, there can be a user who just starts manufacturing on a patent and infringes. The infringement happens, and then the license holder, patent holder, then has to find a way how to enter into an agreement and monetize it. So all these two situations, both of them can lead to litigations. And there is a battery of cases and large number of books you will find on different kinds of patent litigation and the reasoning the courts have given to arrive at a fair pricing, and whether to grant an injunction or not, because some business is going on and something is being implemented, when to grant injunction, not to grant, how to arrive at a fair value. So there are interesting judgments all across the world on this, but this is a challenging area. And then if you enter into litigation, the implementer and the license patent holder both have to incur costs. So this world is really amazing in the sense that there are innovations, there are people who want to implement, but then either there are challenges on how to bear those costs and be able to really achieve those goals, and other is when you actually implement. So, and unless a company or organization has patent innovation in its business plan, it will not be realized. You can't do it in piecemeal basis. It has to be a part of business plan that, okay, this is the area of technology I will work, create patents, and this is the way I will take to the global bodies, fight it out, create networking, or whatever is required to be done. So I think we can go on and go on to understand whole of this business. I will not go into detail. I think that today's conference is well designed to do manthan on key aspects of patents. It's very nicely designed, and there are experts who are there who will give their views on this. And I hope that out of this manthan, some Amrit comes out of this Amrit Kahal. And we really have some good results which can go to the industry and the government, because government is a big stakeholder in the entire thing, and there is a lot of willingness from government side to support this activity. So I hope that this will be a very successful conference in arriving at inputs. Thank you so much.
Thank you, sir, for that inspiring address. This indeed gives a much needed direction to our event. A judicial perspective is essential at a conference on SEPs, for courts are the final arbiters of licensing and enforcement disputes. We are indeed fortunate to have with us Honorable Justice Amit Bansal, sir. His Lordship has served 2 terms on the IP Division of the Delhi High Court and authored India's first post-trial judgment on telecom SEPs in Lava International versus Ericsson. For this seminal contribution to the global SEP jurisprudence, His Lordship has been recognized by Managing IP as one of the 50 most influential people in IP for the year 2024. May I now request Justice Sir to deliver his address, please.
Distinguished colleagues from the bench and the bar, esteemed policy makers from DPIIT, leaders from the industry and standardization bodies, and our hosts here at FICCI and ICRIA. Good morning, everyone. At the outset, let me acknowledge today's excellent program. The lineup right from the various addressees to the focus sessions on demystifying SEPs, standard setting, and listening and enforcement promises a practical end-to-end conversation for India's innovation journey to Viksit Bharat in 2047. At the outset, let me clarify that SEPs are too often treated as a telecom topic. In truth, if the multi-sector digital economy is a train, SEPs are the rails it runs on. And in many ways, the fuel that keeps it moving. They power the codecs that carry our voices and music, the security protocols that protect our payments and devices, and the connectivity that lets factories, cars, hospitals, and farms talk to each other. The architecture of SEPs is horizontal, so the value created in one layer, say radio access or compression, spills over into sectors as diverse as fintech, media, mobility, and public services. For instance, a phone built in Noida connects seamlessly in Nairobi. A 5G module used in ambulance, a tractor, or a point-of-sale terminal just works. A song recorded in Mumbai streams instantly to millions worldwide. That cross-sector, cross-border compatibility has unlocked a whole industry's digital payments, telemedicine, remote education, smart manufacturing, because everyone can innovate in common rails rather than rebuilding the track each time. The horizontal diffusion of SEPs is precisely why a sound, predictable SEP framework isn't just a legal necessity, it is a development imperative. From the bench, each case is a classroom for me. One matter may turn on an antenna arrays and channel models, another on a psychoacoustic masking in audio, a third on key exchange, certificates, and secure enclaves in mobile security. The law is constant, technology is not. Adjudication, therefore, became a continuous learning process, a recurring exercise in reskilling, so I could ask the right questions, separate engineering signal from the noise, and deliver orders that are both principled and practicable. India's journey from DVD player era to 5G class dispute shows how far our ecosystem has traveled in both legal and technical sophistication. Personally, for me, this journey of adjudicating SEP cases did more than clarify telecom standards. When I first began hearing my first SEP case, I did not know what SEP stands for or what FRAND is. You just make a deep dive into it and learn across the way. And I think in Delhi, at least in Delhi High Court, we are very lucky to have a great bar which constantly educates the judges on such topics. But it gave me real confidence in handling deep tech patent cases across domains, mechanical engineering designs and tolerances, biologic drugs and their pathways, nanotechnology and material behavior, where the technical substrate is just as demanding. India's own trajectory from the DVD player era to 5G class disputes shows how far our ecosystem has traveled in legal and technical sophistication, and how adjudication itself can be a powerful engine of judicial upskilling. After looking over global jurisprudence on SEPs, I firmly believe that Indian courts have aimed for the balanced center line when dealing with cases involving SEPs. We have been firm about rights, yet realistic about remedies. Consider our approach to pro tem deposits, limiting them to India component rather than insisting on global bank guarantees that are difficult to enforce across complex corporate structures. This is a small design choice with large practical consequences. It reduces friction without diluting enforceability. We've also asserted jurisdictional sovereignty where needed. The anti-suit injunction in InterDigital versus Xiaomi was not just chest thumping. It was a court ensuring that patents granted under Indian law are not rendered illusory by foreign proceedings. In a globalized litigation chessboard, this keeps India a credible venue while respecting comity of courts. And at times we have engaged proactively to foster settlements, inviting parties to consider global FRAND determination when India is the pivotal market. The very fact that most SEP disputes resolve shortly thereafter is a reminder that pragmatic judicial nudges can catalyze commercial outcomes. Globally, the policy weather keeps shifting. Europe's regulatory debates, especially around injunctive relief, have ignited foundational questions about incentives and enforcement. US has been evolving jurisprudence on anti-suit injunctions and continuing ambiguity on exclusionary orders at the ITC. These are not academic footnotes. They shape bargaining, behavior, and forum choice in real time. India must absorb these lessons while charting a route that serves our market, our manufacturers, and our innovators. Speed with substance should be our watchword. Summary style adjudication within commercial courts, testing a limited set of witnesses and bounded patent set aided by modern courtroom tech has shown promise in highly technical disputes. Live transcription and digital workflows have improved clarity, reduced contest over the record, and kept proceedings intelligible for all stakeholders. We should do more of what works. In my view, the future of SEP litigation lies in a hybrid model, where courts and arbitral tribunals front-load structure, facilitating focused negotiations, taking narrow issues first, and reserving full trials only for what truly remains. Our courts, bar, and expert community have already shown the discipline and imagination to make this work. From my time on the IP division, and through exchanges with judges at international forums, I have found segmented approach compelling, beginning with the FRAND phase, including the option of an arbitral FRAND rate determination, and then move on to the validity and infringement. Knowing the likely royalty encourages principled compromise and clears the fog that too often stalls talks. It also equips the court to manage deep tech disputes with confidence and care. I first mooted this idea at a USPTO SEP conclave, and I'm heartened that ICRAER has since examined it as a practical pathway for resolving global SEP disputes. The endorsement reflects a growing consensus. This is not a flight of fancy. It is an idea whose time has come, and India has the talent and institutions to lead. In practice, the track is fast and disciplined, tight timelines, panels that blend judicial temperament with technical and licensing expertise, consolidation to avoid serial proceedings, reasoned awards enforceable under the New York Convention, SME-friendly cost controls, and transparent methodology, even if the record remains confidential. The payoff is predictability, fewer forum races, fewer anti-suit skirmishes, and more room for commercial solutions. If we can leave today with a model clause and a short procedural playbook to pilot within the year, we can turn friction into flow, keeping justice in the courtroom, economics at the table, and innovation firmly on the rails. I'm optimistic we will do just that. For everyone in this room, founders, counsel, engineering, policymakers, I hope today gives you three things: clarity, a path forward, and a confidence to act. Clarity through plain guidance that tells SMEs and startups exactly what to do next. meet the right standards, decide when to take a license, and align your plan with India's 6G roadmap. A path forward by setting out who does what in standardization, standard bodies, patents by setting out who does what in standardization, bodies, patent pools, licensing groups, regulators, and by showing simple ways for Indian firms to join early in the standards work rather than arriving late at the licensing table. And confidence through step-by-step explanations of licensing and enforcement, diligence, deliberations, and dispute resolution in court or arbitration with realistic timelines, costs, and case management that lower uncertainty. If we leave with shared understanding and a few firm commitments, innovations will not be a slogan. It will become our daily practice, shaping not just our professional work but the way we think. I believe such an outcome is achievable because of the coalition in this room: industry, academia, SDOs, the bar, the bench, the government, and the FICCI's convening ICRIER's scholarship, DPIIT's policy leadership, and the participation of standardization and 6G initiatives that make this right table for hard problems and honest solutions. In conclusion, in SEP case, every order we pass is a small step for law, but a giant nudge for innovation. The judge's craft is to keep learning, the system's task is to keep improving, and the market's duty is to keep innovating. Let us use today not only to argue our positions, but to align for a design fast, fair, and future-proof. Thank you very much, and I look forward to conversations that follow.
We are truly grateful to your Lordship for sharing such deep insights and formally opening the conference. Your words have given us much to reflect upon as we continue our deliberations. May I now invite Mr. Praveen Anand to deliver the plenary address, please.
Good morning. Can you remove this? Go ahead. That's for shorter people. In the language of Dr. Mittal, I welcome Justice Amrit Bansal. Dr. Mittal, Amit Datta, Ms. Malik, ladies and gentlemen, and my dear child. The first time I've had a child audience. This is very, very encouraging. I would request you not to, well, this is my personal feeling, not to say SEP, but to say SEP. And I'll tell you why. When WIPO, people used to call it WIPO, the Director General once said that WIPO reminds him of a detergent. And frankly speaking, I have a very bad cough. SEP reminds me of a throat lozenge. The Viksit Bharat doesn't need definition. It's basically to try and achieve development or becoming a developed nation in the next 22 years. What does that mean? I don't know if you can see those slides because they're divided into 4 quadrants for some reason. And the dividing lines kind of blur some parts. But technology in 22 years is going to leapfrog. And I don't intend to get into this in any detail, but to say things like, particularly for people who've got a kidney problem, you will have lab-grown kidneys. And the humanoid robos like Tesla's Optimus are already being manufactured, and the vision of Elon Musk is to have a humanoid in every home. And of course, robo-taxis are actually running in several states in the United States. So we've kind of starting to reach there. But that's the state of technology in 22 years. And it's very important to think of us. If we want to be a developed nation, we have to think that that technology will be or should be here. What is our vision? So there are countries who have 100 years vision. But even if you take a 10-year vision, we are talking about leadership in 6G. And China is already testing 6G satellites. And so DOT has a plan, 10,000 6G patents in 5 years, and greater presence in standards. And though Dr. Mittal painted a realistic picture of how difficult these standard setting conferences are, we have to get there. It's not going to be an easy road. China, for the road, silk, whatever it's called, road that they forced countries on the way of that pathway to adopt their telecom standards. And so that's the kind of pain that countries have to go through. 10,000 crores has been set aside for 6G R&D, which sounds good. Is it enough? I'm not sure. But the point is, we really need to have many more patents in the field. And of course, some people are saying, even like Starlink, we need an Indian version, and we need, like Baidu, giving examples of Baidu's Ernie, we need large language models and a Bharat cloud for building our own cloud competence, and indigenous technologies like defense and aerospace and Aadhaar, semiconductor chips, greater number of joint ventures between companies like Reliance and Tata, where they have to joint venture with NVIDIA and TSMC, or examples of Tencent and their investment in WeChat are given as strategic acquisitions in cybersecurity. That's the kind of level at which India has to think if we have to have a 10-year vision. Now, I'll give you just one small example of a World Bank study. I'm sorry, there's a little bit of a disconnect between what I'm seeing in front of me and what's there, so I have to keep turning back. Sorry about that. This World Bank study on South Korea is important. These slides will be circulated, but it's important because it shows policy and regulations come first. After you have a correct policy and innovation and regulations, then you have to research. You have to have inventions. And then, of course, you have to prioritize investments in R&D, strengthen your national standardization bodies like BIS, and talent building and all that. And we can learn a lot from looking at how Korea leapfrogged into a standard, from a standard adopter to a standard setter. Now, why standards? Now, I can give you hundreds of examples of incompatibility and what it leads to. But I think one of the best examples that I like is the one that the Mars Climate Orbiter in 1998 suddenly burnt out when it tried to enter Mars' atmosphere. And it burnt out, why? Because NASA and Lockheed Martin were collaborating. And NASA used the European imperial units, and Lockheed Martin used metric, or the other way around. NASA used metric and they used another unit. There was no standard exchange between them. And because of that, NASA ended up losing 327 million US dollars by that one mistake. Similarly, in 1904, the Baltimore fire is an example where fire tenders were brought in from neighboring states, but the hoses did not fit the hydrants because the threading was not of a standard. And so 1,500 houses burnt down as a result. That's when the world realized that it's not just the discomfort that you travel to London and you want to give a presentation and your plug doesn't fit in, or your cell phone has a problem. That's, of course, a big major source of inconvenience. But here it could be a matter of life and death. When in an operation theater something like this happens, there's incompatibility, it could lead to disaster. So standards, everybody realizes, are critical to our living. Now, FRAND. What is FRAND? I don't need to go into that, but to say that there are cases which have kind of given it a short definition, like fair is equitable, reasonable is not exorbitant. Erickson versus Lava said that. Non-discriminatory terms, the Unwired Planet case said, terms need not be identical. It's roughly so. Roughly in the neighborhood of. They need not be identical. That's important because a lot of people think that non-discriminatory means that the terms given by a licensor to a licensee, to all licensees, must be exact. That's not true. It's a two-way street. Intex versus Erickson said it's a two-way street, which means whenever there is a negotiation between a patent owner and an implementer, then both the parties must make the effort to get a license. It's a two-way street. It's not as if only one party must push the other. Then Siswell versus Hire was a perfect example of you can seek an injunction, and seeking an injunction is not against the concept of FRAND. It's not being unfair, seeking an injunction. Now, SEP law, there are some things which have already been settled. For example, SEPs have been recognized as a different class of patents. They're different because you can't just get an injunction easily. And you are obliged to give a license to anyone who asks. You can't say, you can't decline like in pharmaceuticals. And you are obliged to give a license on terms which are FRAND, which means even your right to decide, the freedom to decide terms is taken away. So they are restrictions on SEPs because they are essential. And everybody must use that technology. And so, because there are restrictions, similarly, they are a class and therefore they get a certain privilege in return. Privilege of how you prove infringement by contrasting your patent to the defendant's product to the standard. The moment you show that your patent conforms to the standard and the defendant's product conforms to the standard, then A is equal to B, B is equal to C, so A is equal to C. The law of transitivity kicks in. And that's how you prove. It makes proof easier. Then FRAND is a range. FRAND need not be one number. It's a range. Unwired Planet Health said that. There's a burden on exhaustion is on defendants. There was a case, Phillips versus Bhagirathi, which said that. Then considerable analysis is done in these cases on the conduct of parties. The conduct must not be dilatory. If it is dilatory, then the defendant may be held to be unwilling. Confidentiality clubs, national courts can set FRAND rates if the parties are unable to agree to them, and comparable patent license agreements are relevant. So there's a tendency for the plaintiff to produce the licenses that he has in order to show that this is roughly the range of terms, royalty terms, or royalty rates. Interim arrangements which are made like a pro tem deposit of security, that is not the same as FRAND determination. That's important because a lot of people think that that is FRAND determination. FRAND determination is done at the end of the trial. Now, what I've tried to do here, and if you take the slides, these are 10 top cases. And what I've tried to do is to put just one point, bullet point for each. So, Huawei versus ZTE, which is a case of the CJ, the European Court of Justice, that came up with a FRAND dance. An offer is to be made by patent owner, a counter offer has to be made, so it's an up and down of, they called it a FRAND dance. Siswell versus Hire for unwilling licensees, if there's dilatory tactics, then Unwired Planet, global FRAND rates can be set by the UK court. Intex versus Ericsson, our Indian case, where interim injunctions can be granted. And the court emphasized this concept of a low judge population ratio. And a low ratio means that it's very difficult takes a lot of time for an injunction to be decided. And if that takes so much of time, then it may be unrealistic to go for an interim injunction and more realistic to get a security deposit and a fast trial. So that's the kind of thinking that this judge-lawyer ratio is troublesome for injunctions. Judge-population ratio. Then the Nokia versus Oppo said on pro tem securities that you can go by the last paid license fee if there was a previous license. So it gave a way of calculating what that pro tem deposit ought to be or could be. Like this, there are other cases. I'll just deal with two more. Ericsson versus Lava, where past damages, where Sir gave the decision, Justice Bansal, fantastic decision, where past damages were awarded, that is even prior to the date of institution of the suit, from the date the notice was given, and not from the 11A publication date, but from the date the notice was given. And Sir came up with 7, what do you call this? Sampas. Yeah. And those were the 7 pillars, which are very, very important, and you would all do good to read those, understand them in moving forward. Then you have another Indian case, Dolby versus Lava, recently given on pro tem security deposit, where the court emphasized that the standard for pro tem is not the same as the standard for an interim injunction. You don't have to go into merits of validity of the patent, essentiality of the patent, infringement, and so on and so forth. So it's a different standard. Now, SEP challenges. There are several challenges. Concepts like pro tem, confidentiality clubs, etc., anti-suit injunctions, these have been decided by so many cases, but in each case, we find that the same arguments are repeated. So there is a need to fix these principles so that we don't keep repeating the arguments ad nauseum in subsequent cases. Exactly the same arguments that have been, let's say, rejected by a division bench. Then that's one challenge. Then SEP jurisprudence needs greater emphasis on technical aspects rather than only on commercial aspects and interim orders. You need to go to trials. Unless cases go to trials, the principles do not become precedents, because a lot of Supreme Court judges will say that an interim order is not a precedent. And so it's very important that these cases go to trial and they go more technical than only arguments on what is friend. Adopting best practices from foreign courts, we are already doing that, but we need to do more of that. Need for shorter negotiations. Today, the period of negotiations can get as much as 8 years. And it's almost like the courts are saying you need that. But that's not true. You shorter negotiations, and therefore, once you've had 4 years of negotiations and nothing's happened, the 12A becomes meaningless. What is the point of a pre-litigation mediation after 4 years of negotiations have failed? Roster changes are one of the biggest disruptive things that can happen to a plaintiff, to the lawyers, to everybody. It's something that needs to be addressed at a serious level. We need more judges, as the courts themselves have said in Nokia versus Oppo. The judge population ratio is very low in this country, so you need more judges. We are the second largest market in this field, so I think we really need more judges here. And time limits need to be imposed. That's very important. Now, in multi-jurisdictional litigation, SEPs normally, multi-jurisdiction, I have about 2-3 minutes more. In multi-jurisdictional litigation, the biggest challenge is the chance of conflicting decisions and the race to judgments. Everybody is trying to get there quickly. So there's a case in UK, there's a case in China. They want to get to the China court quickly so that their implementers want to do that, and right owners want their case in a developed country like Germany to go faster. This is one challenge. Invalidity of a foreign patent, if you're suing in the same family of patents in India, then invalidity of a foreign, some courts say it's important to have a look at that. Some courts say irrelevant, because the scope of the patent may be different in different jurisdictions. Bank guarantees given in one country may just not work in another country. Or ASI, first there used to be a problem of anti-suit injunctions that was neutralized by anti-suit injunctions. So that's not such a problem today, but new problems have arisen. One problem is, even if an injunction is granted in, let's say, UK or Germany, and the party says my sales in these countries is so low, I'll quit the market, but I won't take a license. So the injunction doesn't result in a license. Or the new concept in England of interim licenses is the next big challenge, where an implementer goes, files a suit for declaration and asks for an interim license, and the court says, okay, these are the terms on which a license can be given, and then, but you must stop proceedings, halt proceedings all over the world. And Some may do that, some may ignore that. Other jurisdictions say, why? Why should I stop the proceedings in India? And that might go against the party that doesn't stop the proceedings in the UK jurisdiction, where this has been so declared. And in the meantime, implementer keeps manufacturing. If the plaintiff decides to give the license on those terms, then it gets the royalty. If the plaintiff doesn't, the plaintiff may be held, the licensor may be held to be unwilling, an unwilling licensor. So this is a new problem that has arisen in SCP litigation. Indian jurisprudence has been, in the meantime, quite encouraging because, as I've said here, recognizing SCP cases as a special class of cases, conduct of the parties and pro tem orders have all encouraged settlements. I won't go into this, and I'll conclude by saying that education and awareness is a very important component here. And I'll just give the example of a recent organization called GLIPA, the kind of work that they're doing. In 1 year, they've taught more than 6,000 students and teachers all over the country. And they're doing some absolutely amazing work on standards and on artificial intelligence. And with that, I'll conclude by saying that firstly, we have achieved changes. Let's recognize that there is an innovation policy that we have. There is a patent office reforms have been carried out. Our startup culture is developing. A Commercial Courts Act and the IPD have streamlined litigation. But SCP law is relatively new, and we need more principles to be culled out, frozen, and finalized. And for that, you need to legislate faster. Legislation in our country is abysmally slow. Way to do that would probably be through secondary legislation if the Constitution so permits. But once you legislate, you would put the new law into motion, into practice, see the flaw, and you need to have the ability to quickly amend the law. We do not have in our country, if we want to be a developed country, the ability to amend a flawed law. We have so many examples, such as 115 of the Trademarks Act, which for 25 years has been seen as a bad provision, but it's not being amended. So we don't have in this country currently the ability to amend laws. Then the assistance to judges by technical members, very important. Also, my last points, judges' exposure to R&D culture. Judges must know the kind of pain that a pharmaceutical company takes to build a molecule, or the kind of effort to set a standard. Unless they know that, they need to know that. Also, judges' exposure to the kind of damage that can be caused if an injunction is not granted or an appropriate order is not passed, how it could be the lifeblood of a corporation. And patent filing needs to go up, but with numbers, we've got numbers, but a lot of the numbers are research papers by universities. They are not patents. So quality needs to be also brought in as a balance. STEAM education. Now A has been added to STEM, which means arts along with science, to develop new creative products that will do well on the market. The chambers of commerce and industry need to unite on principles. Today, they do not see, all of them don't come on the same platform. FICCI goes one way, CII goes another way, like that. If they come together, the same voice, they can tell the government to change the law. And then the government will listen. Then we have inventors associations, and we have an overwhelming number of lawyers associations. We have APA and AIPPI and LES and INTA and FICCI, but these associations need to collaborate with each other. And finally, these success stories need to be told. And we need to celebrate the World IP Day, the World Copyright Day, the World Innovation Day. They're all separate, but we need to really celebrate creativity, innovation, and invention. Thank you very much.
Thank you, sir, for sharing your valuable perspectives. So I am thankful to each one of you. We have an overwhelming participation. There are some people who may not be, we may not be able to accommodate in the room, but we have a live streaming on the second floor conference room for your convenience. As we draw close to this inspiring inaugural session, I extend my sincere gratitude to the dignitaries on the dais and invite them to join us for a group picture, please. Aman.
Ladies and gentlemen, may I request you to be seated? Yeah. You want to announce?
Ladies and gentlemen, I request you to please be seated as we are starting with the next part of our conference. You can call.
So after that invigorating session, it is my pleasure to welcome you to a series of sessions which form part of this conference on standard essential patents that I hope will be invigorating and stimulating for all those present. Session 1 is titled Demystifying the Standard Essential Patent Ecosystem, and this session will offer an introduction to SEPs and examine their growing relevance in the Indian innovation ecosystem. It will explore the extent of SEP adoption and the prevailing licensing practices among Indian enterprises. In doing so, the session will consider how India's evolving SEP landscape can support its strategic ambitions, particularly in emerging technologies such as 6G. I now request the moderator, Mr. Rajesh Kumar Pathak, Director General, Bharat 6G Alliance, to join the stage. Mr. Pathak. I also request the panelists to join us on the stage. Dr. Radhakrishna Gandhi from IIT Madras will be joining us virtually. Dr. Rajiv Kumar from the Department of Science and Technology will be joining us in person. Mr. Rajiv Kumar from Jio will also be joining in person. Mr. Nitin Sharma from Qualcomm as well. Mr. Amit Kumar from Tejas Networks and Dr. Sonali Garg from HDFC Limited will also be joining in person. HFCL Limited. I now hand over the dais to Mr. Pathak to begin moderating the session.
Hello. नमस्कार सभी लोगों को। आप लोग सेटल हो जाएं क्योंकि पहला सेशन काफ़ी अच्छा रहा है और जो चीज़ हम लोग को लगता है कि दिन भर बात करना चाहते हैं वो फर्स्ट सेशन में जस्टिस बंसल साहब ने और प्रवीण आनंद साहब ने सब कुछ बता दिया। तो सेशन का नाम स्लाइटली आई डोंट ऑलवेज एग्री, सो इट्स स्टैंडर्ड इसेंशियल पेटेंट, जो कि अभी है ही नहीं कल्चर इंडिया में। सो आई थिंक वी हैव टू वर्क ए लॉट। आई मीन हम लोग कह सकते हैं कि हम अभी इन्फेंसी स्टेज में हैं। सो मैं इसको कहूँगा कि इट्स आई थिंक वी हैव टू discuss on innovation, how we can do the create R&D ecosystem within the country, when our academia can join hands with the industry, startups, and naturally government has the very pivotal role presently, because without government it's not possible. So how can they bring, they all come together, and even today I have in my panel those all present. Once we do a lot on R&D, then comes the standard. Standard is a business. So you have to be a business person. If you are thinking that you will contribute in standards, people confused with the research and development in standard. Both are different wings, one can say. So all these companies, bigger companies, because startup they won't be able to do it, should have a standard division, R&D division. Both are separate. But as a scientist, I can do some research, but how to convert in a standard, how to participate in standard, how to write a patent. Even writing a patent is an entirely different subject. A startup, a scientist won't be able to do the justice with this work. So this, I mean, this is not aware of. People feel that no, I have R&D persons. He don't know what it is, because this then comes the some lot of from the councils here present. They know attorney that how to make your research and innovation a true, a meaningful patent. Which can create the value. And then the last comes the patent part. So patent is a derivative. So it's not a standard essential patents. Essential is just, I mean, something which is always interoperable, or without that you can't work. Then only it becomes SEP. Otherwise it's all patent. So we have to think in India a culture when we produce patents in kilos. अभी चिंता मत करो. People feel that why he has created so many patents. No, let them create it. Now comes and what I would like to listen from Professor Ganti, who has been the young scientist from India. I'm sure that he might have joined. Yeah, I think I can see you, sir. So even he was
Yes, sir, I am enjoying.
so even he was awarded also last year by, I think, Bhatnagar Award. So welcome him also. So how can academia and industry work together to convert whatever is coming out of academia? Right now, academia is more active in India, especially in wireless communication technology. And then what are the various actions needed to do that? So my thought process will be that how can we create pools, because right now we have just fragmented patents. So one of the options can be the patent pooling, another can be the sovereign patent fund. So though that has been a failed case in so many countries, but whether that is a fit for India. So these are the various thought processes on the subject. So I will ask all the panelists to give their views, keeping one line very clear that all is not well. So don't say all is well, otherwise you won't be able to paint the correct picture what is needed for India. So with this, I think I welcome first the Dr. Radha Krishna Ganti, a professor, CVIT, IIT Madras. And I think he don't need introduction, but perhaps I see him that he is from only BTech and MTech from IIT Madras. Otherwise, why I am saying so? In most of the cases, whoever comes from IITs, they go abroad and they never come back. So welcome you back, even though you're online. And he has been so many awards to it credit, and in Department of Telecommunication, I belong to Bharat 6G Alliance. That is a new baby for bringing all ecosystem together. So I think would like to hear him, and he is awarded the Vigyan Yuva Shanti Swarup Bhatnagar Award for the year 2024 in the engineering science by Government of India. So let us welcome the first Mr. Radhakrishnan Ganti. We call him Ganti or RK. So over to you now.
Thank you, Patak sir. Thank you for the warm introduction. I hope I'm audible.
Yeah.
Yes, sir. Okay. Thank you for having me here. So it's a very interesting conference. I'll just take about 4 to 5 minutes and give you my views. So initially, I used to be very skeptical about patents and standards. I'm from an academic world. In academic world, you write papers. Patents are something that maybe one or two patents a decade is what generally faculty write. Patents are done. Okay. So with that background, from the last few years, I've been working with 5G and other things, and I started writing patents and understanding all these things. So whatever views expressed here are my experiences over the last over the 5G journey. So I believe that standards are also both a boon and a curse. From a consumer perspective, at least it's claimed that they help in creating scale, create seamless global products. I mean, while this is all debatable, but this is what the telecom industry is doing, and this is what it is going to do for the next foreseeable future. Okay, but if you go to the other side of things, okay, if you look at the not the so good thing about standards. So once standards go over a larger scale, as in once standards become bigger and bigger, like what is happening in telecom, with huge amounts of revenue, it actually becomes very, very difficult for smaller incumbents to get into this game. Okay, it's not at all easy. People can claim otherwise, but in India, I have seen companies struggle from 10 years, 15 years, not getting into this game because one of the major impediment is SEPs and the standard barriers that have been created. Okay? So India is precisely at this point. Okay, I mean, we are exactly in this juncture where how do we get into this 3GPP club and get our ideas and standards into our technology into these standards and get SAPs. How do we do this? And what does it even mean to get into this club? Okay. So to understand this, we have to understand the cycle of technology in telecommunications. Okay. So between every generation, there is about 10 years of gap. Okay. 4G to 5G is 10 years, 5G to 6G is 10 years. Okay. I mean, when it's implemented in India, it's a different issue, but this is standard 10-year gap. So every generation takes about 10 years. So the technology development for the standard, actual technology development for the standards happen in the first 3 to 4 years, or actually even before the 0th time. This is where the raw technology is developed. Okay, the key technologies that go into any standards are developed, and the patents that you file for in these raw technologies are what are called as tier 1 patents. Okay, so these are the things that actually run your system. Then around the midpoint of the decade, so in 2025, for example, now is when FICCI standardization or study items, what they call, are happening, right? Or next week is what it's going to happen. So at this point, people start thinking about how do you change the technology that has already been done? How do you modify that to fit into a standard that can be used by all these devices and this thing? So these are the tier 2 patents. Okay. And once it crosses a few years, 2-3 years into this cycle, that's when you start looking at more finer things, smaller things on how do you put this bit, how do you put that bit, how do you flip this bit, and how do you frame this data and all things. These are the tier 3 patents, okay, in the standards part. And outside all this are the implementation patents. Okay, so if you want to build a product, I mean, it's just not that standards are, standards only tell you about how do you transmit data. They never tell you about how do you receive data. Okay, that's how standards are made. So there's a lot of implementation patents that are there. So when we talk about SEPs, so SEPs mostly are tier 2 patents. That is when the standard is happening. That's where tier 2 patents happen, and some parts of tier 1 patents. So if we want to get into this SEP business, essentially we have to be in all these patents. We should have them. Okay, we can't leave any of these things. Okay, so currently, as I was telling you, we are now in the form. Everyone, most of the people, most of the players across the world are in the phase of doing the tier 2 and tier 3 patents. So the question is, how do we achieve this in India? Okay, one is we have to file patents. We have to file patents. So this is something that at least academicians are getting educated. Smaller companies are getting educated. It's a very, very new thing in India. Okay, it's not as pervasive as that is there in the West. We started filing patents, but one of the issues that we find is, since this is there are lots of lawyers and legal people in the conference, I want to say this: the quality of patent drafting. Okay, at least if you pay moderate, not too high money. If you pay a lot of money, of course you can get a lot of good lawyers and everything. But in the moderate costing, the quality of patent drafting is not so good. Okay, this is one thing that we have found, and most of the times it turns out that when I write a patent, when I go to a firm and they write a patent, it turns out that I sit and edit that most of the times, which should not happen. If you want to scale this to 10,000, 20,000 patents, this is not something that can be scaled. Okay? And to file SEPs, so what exactly is SEP, at least from a technical perspective, how we understand SEPs is, SEP is, you get an SEP when the language of the standard meets the language of your patents. Okay, effective, that seems to be one of the very basic tests of, that's how at least initially we think about SEPs. Okay? So the second part of this whole puzzle is, we have to go to standards. We have to go to standards and start contributing to the patents. Okay, so this is where strategy is required. This is where Bharat FICCI Alliance, TS and all this come into picture. And how do you include your ideas into standards? And this is where you should ensure that your patent languages in some sense matches to the language of the standard. Okay, so one thing is, people say this is like a legalist document, but if you read a standard is much more worse than that. And until unless you work in the standards for like 20 years, you never understand a standard document. It's almost impossible. I have gone to so many standards meetings. Why do you write this? They write the standard in such a terse way that no one understands just because it's linked to SEPs. Okay, unfortunately, that is the way it is. If you give a standard, if aliens come and look at our standards, they will not understand any of that. I can assure you that. The next question is, the third point is the most important thing. So after you finish the cycle of patents, how do you identify what is an SEP? Okay. This is a very, very complicated thing. And it takes enormous amounts of time and money and effort on this. Identifying SEPs. Okay, so and one thing that we realized in the last few years is that there are again not many firms who can help out identifying SEPs. You have to do this homework, or you have to pay really large sums of money for someone to do this. Okay, fortunately now some AI tools are coming. which can help in this. Okay? I'll just take 1 more minute and close this. So the fourth point is, how do we monetize this? Again, this is a very big gap. So if you're a big player, it's all easy. Okay, so you cross license and you have enough mechanisms to do this. But if you're a small player, okay, if you're a small player, what do you do with all this SCP? What you claim as patents? What can you do with it? Okay. It's not a healthy habit to put injunctions at every product that is there. That's not the way to go ahead. So what do you do with this? So some kind of framework and some kind of strategy has to be developed. So we are claiming that we'll get 10,000 patents. Then what do we do with those 10,000 patents? That is something that we should think about. So there are a few more points, couple of points I want to say. So patent turnover rate in India is improved quite a bit. Okay, it used to be like 10 years. So there are some, our initial 5G patents took about 10 years to come, but later 5G patents took about like 2-3 years we were getting. I think it should speed up a little bit more. The second thing I want to point out is if you want to file 10,000 patents, it's not only technical people. We require people who understand the law, who understand, who are experts in drafting this, who understand SCP terminology, who help out all of this. Okay, so both of us to sit together and do this. It's not like a single technical thing. So as one of the previous speakers was pointing out, he said that lawyers and judges should understand the technical issues. I would say the other way around also. Technical people also should understand the legalese, should understand what a patent entails, should understand the patent law and what an SCP means. Otherwise, we're going to make a lot of mistakes in this journey. So I'm going to stop at this point. Thank you, sir.
Thank you, RK, for bringing very important that I think I can see people here from the law only. Most of them are here. So, how can we do the patent drafting? What are the various things required? How can they work closely with the academia and industry and naturally the technology? So, I'll ask questions subsequently because I think let us just give 5 minutes each and then invite questions from audience because then that will be the right for this panel. So next I invite Dr. Rajiv Kumar, Scientist F from NIDHI. They work in the entrepreneurship development. So government has very liberal funding and sometimes we put conditions that you have to produce patents. So mostly we feel convenient to funding academia and they produce some patents. But they never think what will happen to those patents because that was told by DST, DOT, and that's why they come up with the patents. So I think there something is missing. So industry or startup or whether it was applications, whether something came out or not. So I request Dr. Rajiv Kumar because he is from the Department of Science and Technology and they are, I think, the first and most funding liberal organizations to share his thought process, how can we do other than whatever is being done and what are the various other initiatives from the Department of Science and Technology. So over to you, sir, welcome you and you can share your views.
Thank you, Rajeshji. So I belong to Department of Science and Technology and my role in the department working as a Technology Translation and Innovation Division is how we can help industries or the startups or academic researchers to file the patent and then monetize. Because in India we know the goddess Lakshmi and Saraswati, they don't talk each other. But it's the role of the division, our division's role, how we can bring the knowledge and wealth together. So first creation of knowledge, filing the patent and then monetization. So that way in 2016 when the Startup India initiative was launched, the department launched an initiative that NIDHI we call, NIDHI also Dhan, wealth. So National Initiative for Developing and Harnessing Innovation, through which we nurture the startup ecosystem within the country. Because a startup, they come with a crazy idea. They don't think whether this idea will work or not. So we provided them the incubation system, where we provide them the mentorship, not only the technical mentorship, but the legal mentorship also. And then later on we provide the financial support. So the legal mentorship means whether the knowledge they are generating, that could be patented or the useful patent can be generated or not. So that's the first idea where the mentors in the incubating system, they guide them. They judge, they advise them, and then later on they help them in filing the patent. Because the next round, when they go for seeking the funding, the investors or the government agency also, they ask whether you hold the patent or not, whether the patent what you are holding, that's useful or not. So that's the crucial stage where the government and then mentors, they intervene and encourage them for filing the patent and monetization before the investments from the private sector or the government sector is made. So for that reason, the department launched one Nidhi Prayas initiative, where we encourage the startup to first develop the POC, go for patenting, and then seek the investment. So that's the crucial initial stage where our mentors or the legal experts within the ecosystem, they can support the startups or the industries to judge whether the kind of work they are doing that could be monetized or not. If yes, then go for filing the patenting, and then after the filing the patent, they need to advise them how much they need to hold or when to go for the commercialization. So that kind of aspects we have been trying to support the startups. And now recently you must have heard the Government of India has launched this 1 lakh crore, the Research and Development Fund, RDI fund, which we are going to pump within the system for developing and commercializing the technologies within India. So already in this year's budget, the Finance Minister has announced 20,000 RDI crore RDI fund, and then Anusandhan Research, National Research Fund, ANRF, has been mandated to implement that. So we are in the process of developing the policies, how we can fund the startups, industries. So mostly what we are thinking that there would be 3-tier structure, like one is giving the loan to industries, where the industries can put the similar kind of funding, the 50-50 partnership, the loan zero, either maybe up to the 0% loan also we can give them, and the gestation period could be the 15 years. They can develop and commercialize the product, go to the market. The second stage, we are creating that funds of fund, where, because it's very difficult for one industries to match the funding. So we are trying to create a pool of funds where many investors can create an alternative fund within the incubator, and then government can match and they can go for the investment model. So that's the second fund. Third, we are thinking of having the financing of patent. So because in academic sectors, many patents have been created. They don't know whether that patent is convertible to the wealth or not. So on that way, we are trying to push that funding so that the technology which have been developed in academia can be monetized. So these are the new initiative government has taken. I'm sure that would be helping to the industries, not only for the telecom industries, but for quantum technology, IoT, and other sectors. Thank you.
Thank you, Dr. Rajiv. In fact, that's what I'm saying. There is a 1 lakh crore fund available. And I just came to know that even they can give on the zero interest for 10 to 15 years. That will be the right approach. I am sure that since this is not still in the public domain, so if you can work with the forums like FICCI and others also, that you even Nidhi Prayas, even I was not aware of. So there is a more requirement that we come closer to the startups and others also, because then only we can rightfully utilize our funds. I would like to thank, then I invite another Rajiv Gupta, and he is a graduate of IIT Kharagpur. So being engineering, and then he comes to the patent part. I mean, as a ISM Hyderabad, is specializing in intellectual property and legal contract IP strategy. So I think we need more persons like him. He is right now heading IP division of Geo platform, I am sure. So I think you also share what is specific actions being taken by Geo, and especially how can you bring together startups? Do you have something related to startups as well? So, and what is your thought process on this innovation and R&D ecosystems are supported by the government?
First, thank you so much.
Thank you, FICCI, for inviting us out here to hear our views. Also, first, I think clear the myth around implementers and innovators. I think both have got the innovation aspect of it, and Geo has been the largest startup in the ecosystem, and we have driven innovations right from the root, and have provided the lowest cost of digital services in the country. Obviously, to add to this, because we are talking about standard essential patent, and as Mr. Pathak mentioned, that all is not well. So we have to talk about what is not well actually in the industry. But just to give you a big background about what in fact we support in bringing out new startup ecosystems, and also we have a very dedicated team which really looks into startup ecosystems, and we support them. We also help them to find out the right, you can say, path forward for not only providing the correct innovative problems, but also providing them the innovative solutions. But coming back to the subject that we have talked about here is this with respect to the standard essential patents. So standard itself, what Dr. Radha mentioned about, is a very complex area. And complex area in terms of taking it forward right from the conception part to your not only filing the patent is one part, but from the prototyping to proof of concept to validations, and then finally taking it to the environmental validations and commercial deployment. So there are various stages to it, and various stages adds lot of innovations at every stages and every points. Now when we talk about the standard essentials out there, or the standards essential patents out there, so within the TRL levels that we have from 1 to 9, so at every level we have innovations coming out there. But what Dr. Radha also mentioned about is the core features. So when we talk about the core features, whether in terms of 4G or 5G, which are purely the essential patents, those are obviously initially conceived and have to be filed at the right time. So when we talk about the standard essential patents, the transparency is one issue that has to be really analyzed and has to be tested at every point. So in fact, when we talk about the standard essential patent and the technical essentiality, the SSOs are the main body which really takes up the standards, and the right from your the TR documents, the technical specification documents, the TDoc documents, and the final declaration that happens to the standard setting organization, that has to come in line with what the data integrity actually is out there and is being disclosed out there. So initially it might be just a technical requirement document, and there are a lot of phases through which the final technical specifications comes out there before the standard setting organization. And as rightly pointed out in the morning that by Dr. A.K. Mittal, that these are closed collaborations and closed door meetings that happens, and finally the standards are accepted with mutual agreements by the parties. So in the standard essential patents, when we talk about the data integrity part is very important. The technical essentiality of that part, how the standards gets mapped to the patents is something what has to be really found out. And due to that, I think the proverb that you used out there is all is not well. I think that has to be really cleared out in terms of transparency. The second part is with respect to the royalty part. Now, what we could understand from the lot of discussions that we have had, there are a lot of supply chain within this whole when you implement the technologies. Now, within the supply chain itself, it might be, for example, if you take a phone, you have a chipset, you have other vendors, and also you have, a lot of other systems, integrators, and there are a lot of subsystems within that. So during the supply chain, at which point is the royalty charged and how it is charged is important to understand. So this is also another aspect of transparency that has to be brought in. And if from point A to point E, there has been charges at every point, then there has to be transparency in also in bringing out those before the public. Because at the end of the day, the consumer faces the royalty challenge. If it is an aggregated royalty, the consumer has to pay. So if you are voicing out for digital services that has to be at the lowest cost, then we also have to have transparency in that ecosystem, because ultimately the consumer is paying for the entire aggregated royalty. And also I think with respect to section 107A, which talks about the exhaustion principles, the aspect of the consumer voice in terms of what exactly he is paying, he should also know. So these are 2 points. The third point I would like to make a small comment on is when we talk about the core features within the tier 1 or you can say the implementation patents which are part of the tier 2. Now any device may have maybe around say for example 2000 features or 3000 features. There has to be a set number actually. It can't go beyond that. And every technical feature is mapped to a particular patent. So when we talk about features and when we talk about patents, they are mapping to each other. Now how come in the world that there are lakhs of patents mapped to a particular device which are standards in nature? The question comes on transparency in this part, and this is where I think I have highlighted this. So with the business environment in uncertain environment, how do we really propel the adoption of technology, as well as build something what is core required for the industry and which creates certainty in your business functions. So uncertain environment in an uncertain policy environment will lead to chaos. So this is what I wanted to submit at this point of time, and I have a way forward. I will come on that part. Thank you so much.
Thank you for giving the practical experience. Now the next speaker is Mr. Nitin Sharma. So like Intel Inside, Qualcomm Inside, we have this one. So he represents Qualcomm here, and he mentors technology startup through programs like Qualcomm Design in India, Qualcomm Women Entrepreneurs in Technology, and promotes IP education through sessions for startups. I just realized that he is associated with GLIPA also. GLIPA, actually, I just came to know today, GLIPA. So I think I need more, because I am advocating such institutions or something should be there for this awareness and education, because that's is very much required. And he is recognized by IIM Strategy 300 as one of the world's leading IP strategy in 2023. So welcome you, Mr. Sharma, and you tell us that what a country, I will say laggard country like India has to do, because we are at very initial stages, whether it's that's maybe in the creating our education and awareness or it's technology, in both the cases. So what can be done for a country like India, and what's the more role you feel of the government, because they have to enable this ecosystem. They are thinking that it will come from industry, but I think they have to enable. So what is your role here and your thought process?
Good morning, everyone. And first of all, big thanks to ICRIER and FICCI for inviting me here. It's so good to see the great work being done by Professor Ganti, Rajiv, and sharing the great stories about the kind of research and initiatives that are being done.
to Dr. Rajiv, I would recommend including Lord Ganesha, because he represents both wisdom and the money part. So I think that probably would help us get there as well. So I'll give you a little background to indicate where my comments are coming from. So as Mr. Mittal mentioned, as part of our different programs like Qualcomm Design India Challenge program, we have worked with a lot of startups, about 120 plus, which have generated about 700 patents. Out of them, a large part is Indian patents. We also have a program called Women Entrepreneurship Program, wherein women in technical startups who are led by women, we mentor them and all that. There's also a semiconductor startup program wherein we work with startups who are into semiconductor stuff. And apart from these formal initiatives, I also part of some venture funds and also work with T-Hub, T-Work in Telangana and help startups build IP strategy. So we heard about all is not well, which is one side of it. So I'll probably take another side of it and say that all is not unwell as well. And let me share why I say so. Right. So in my experience of working with more than 150 startups, what I found is the SEP issue has never come up. Having said that, what has really come up is there are a few startups who are pretty good about managing IP and understanding of IP. But there are quite a lot of startups, and that also goes with some of the institutes, academic institutes who are into research, R&D, which also we try to help in setting up tech transfer, etc., is a lack of awareness of IP, right? And that's where I think the biggest challenge lies, because you can't talk about the nuances of IP before even understanding the IP part. So that led us to create a partnership project with NLU Delhi, DPIIT, CPAM and Qualcomm, and develop a platform L2 Pro India, which provides a 3-level of education, basic, intermediate and advanced, which covers not only the basics of patents but also covers how do you navigate through the different aspects of it, including infringement. There's a module on SEP, standard setting organization, etc., and all that. So education is the key. I think one of the problems that we have is the lack of awareness of how do we handle IP, right? And I think that's where I think the first intervention that we need from government, right? Wherein we have to spread awareness, not just giving the goals that we need. Let's say every institute should have a patent, etc., but also how do you basically go about developing a good IP strategy, right? So that's one thing. Now, we have heard a lot about generating patents and goals and all that, but I think what is IP? Let's take a step back and understand, and I think that also answers partly to what Professor Ganti has also said about how to get into standards and all that. How do you take your things into standards, right? So what is IP? IP is classified as an industrial property, which means it's a business property, and also Professor Pathak and Ms. Pathak and Professor Mittal has mentioned in the beginning. So you have to create something which is of business value. It's just like any startup or any product that a startup is building to sell in the market. Now, what is patent? Patent is actually a protection mechanism for innovation. So you cannot talk about having a patent with a SEP of whatever goal you have without talking about innovation, right? So if you really want to make you create a meaningful patent, whether it's SEP or non-SEP implementation, you really have to see, does the market need it? What is the market potential of it? Because it's a product which you are going to sell it. It's a business product, right? So unless we create something which others want, I can create thousands of patents with no value. Your one product could be such a valuable product as compared to 1,000 other products, right? 1,000 may not sell, but one will sell and give you all the money, right? So the point I'm trying to make here is we need to bring in the conversations around where are we focusing our innovation R&D efforts into? Are these into right direction, right? So that's the key. I mean, you cannot talk about patents without talking about innovation, R&D efforts, and then having all the business angle associated with it, right? If you are taking your patents to standardization body, right, it has to be acceptable or sellable or valuable for a plethora of organizations, right, or stakeholders rather, in different jurisdictions and all that, because everybody has to agree to it, right? So we need to, how do you get there? Just imagine, how do you create a product which is sellable in every market? That you study the market, you understand consumer preferences and all that, and then you go about marketing that. Same principle applies here. You need to understand who are the stakeholders here, who are the operators, what are the challenges of operators. We could bring a great technology from one user point of view, but is operator okay to accept it? Because operators have different constraints, right? Likewise, different geographies may require different things, different industries may require different things. So how do you make everybody agree to your solutions? It's a challenge. And that's where you need effort. And that's where I think Mr. Mittal and Mr. Pathak earlier highlighted very beautifully that standardization is a tough problem, or is a tough exercise, because you need to make it work with everyone. It's just like a coalition government, right? You need to take everybody together and make it work. Sometimes, and we have examples from technology wherein not the best technology survives, right? Sony had came up with a very beautiful video technology, but VHS survived because it was more acceptable to the market. You cannot do an SEP or a IP or a product for that matter, generic product, forget about patents, without market acceptance. So are we looking at that perspective, which is very, very important, right? So going back to the original problem, right? Yeah, all these other things are operational challenges that we need to create a separate organization, just like I need to create a marketing guy, a sales guy to go into a particular market and sell it. I need a standards organization in my team to go and work with the standards group, because we need to work with them, right? So I think in the interest of time, maybe I can stop here. There's very interesting conversation, a lot of topics, but I think we really need to step away from just making patents as a goal without including innovation in it. Patents will come, right? Money will flow. Commercialization will happen. I'll make one last comment before I leave. It's in the interest of SEP holders to license and see that the licensor is successful. I tell that to all the college guys who are doing R&D and trying to do tech transfer thing. In fact, we are trying to see if we can create through GLIP or any other thing wherein we can do a tech transfer module to teach. See, who's the client here? Who's the customer here? It's the technology. It's not the implementer or a holder. Technology has to succeed, because if the implementer is not successful, do you think R&D person will be successful? No. So it's never an interest of a licensor to see licensee fail. We need to really appreciate the effort that has gone into R&D, into standardization and all that, and understand the whole mechanism. Because if you don't understand, and if you say, hey, these guys are bad, this approach is bad, we need to fix this, how will you learn and be part of it? As our Prime Minister said in this Independence Day speech, you don't need to spend your effort on reducing the length of the line. You need to make your line effort bigger. I think the same applies here. We really need to see how we can focus on R&D. What is the useful R&D areas where we can focus on? How do I market myself, just like I market any other product, right? So I think it's not all bad out there. People or both the parties have a genuine interest to see that technology is successful, it's useful in the market, and everybody gets benefit out of it. But we need to understand both the sides of it, that yes, there is a strong effort, there is a strong technology which has been created, which is now making such a wide use case possible that can be applied across the industries, in fact, every industry in the world. We should appreciate that and work towards it. And I think if we collaborated, we have seen the startups which has opened up and collaborated well, they have become from a startup to an implementer and now standards contributor. And those journeys are in public domain. I mean, in this time, we'll stop here, but collaboration is the key. You cannot create the boundaries and do it. So I'll stop here and we'll take it further.
Thank you. I think you have, rightly pointed out that we do say startup MSME, because as a government we feel that to them we can do a lot. but they never face such challenge. It's the once you become bigger, then only it comes. But definitely, I think from the very beginning we have to be aware, and we have to make these companies big. So then our next speaker is the same, who graduated from startup to MSME, and now one can say a bigger company. One can say Tejas. So we have Mr. Amit, legal head of Tejas Network. So I think he might have seen the heat when you transfer. I'm from MSME, and you become a fifth supplier of the world of 4G technology from India. So I think he will share his maybe real perspective when he started growing. Then what are the various things, and how a company, big company like him, should also take the actions.
Thanks, Rajiv sir. And first of all, I would like to thank FICCI to give me an opportunity here to speak on this serious topic, which entails the industry's pain as well as industry's future, what future foresightedness as an industry we should have. Now, coming to this discussion, whatever we are having here on the standard essential patents, I agree on the divergent views spoken in this session and the previous session. What Nitin said just now before me, that we should, as a country, if we want to grow in a longer run and for a future long term, we should focus on innovation. There is no denial about it. We should focus on innovation. We should invest in innovation. We should develop good patents which has market acceptability, which has essentiality, and which caters to the need of the industry, and ultimately it solves human problems. Whether it is in a telecom domain or on the pharmaceutical side or any side, it solves human problems ultimately. Now, coming back to that, see, Rome was not built in a day. Qualcomm was not built in a year. Neither Nokia or Ericsson was not built in a day. Any R&D organization to succeed, or any company to succeed on the R&D front of innovation of what maybe Qualcomm, Nokia or Ericsson has succeeded and what they have or YZT has in their pool is not made in a day. Now, coming to the India story, that what Indian industry should do, what Indian industry expects from the government help, and how we should collaboratively work together so that no one is a villain here. So that ultimate story should be that no one should say that ACP holder is holding out or ACP implementer is holding out. So that situation should never arise. So in all earnestness, what we should, as an industry and as a government, industry should focus on real development of a standard essential patents, innovation, and education also. I also take leave from Nitin that he said that there has some initiative with NLU Delhi. I am also a graduate from Gujarat National Law University. I also visit other national law school for different associations. So currently in India there are 29 national law schools. IITs maybe more than 15 or 16. Now I think that this level of education should not only rest with few institutions. This level of imparting education's awareness on IPR, the IPR module that you see, that we see in a law school, the IPR module that will be taught in an IIT. I don't think that at this level, what we are debating here and discussing on standard essential patents is taught in a law school or in a IIT while you do engineering, a BTech degree or an MTech degree. It is not. So the thing is that we should take a step by step. It is high time for us, be it from a government point of view, from an institution point of view, or from industry point of view, that any innovative thought into the mind of a human being should be put at very early stage, and be it innovation should be taught from school level, right from the school level, because there is where a young mind stays and where it can bring a change in the country. So that is one thing, and it should be that it not only few institutions should benefit of it, it should go to the entire institution so that everyone is benefited out of it. Now from the government point of view, so that why I said that Rome was not built in a day, and if we want to catch up with, so that industry doesn't die, so that industry remains industry, and innovation is also encouraged. So we need, rightly pointed out by colleagues over here, that there are certain funds allotted. So funds should be rightly used for innovation. That fund should also be used in a right manner for right innovation, for a valuable innovation. Second thing is that as an industry we need, there are startups, there are small, big players, they need support from the government as well. And then what thought that as a policy we can also think around how we can structure sovereign patent fund, telecom patent fund concept on the innovation, and to bridge a gap and to catch up on the level of innovation. I'll rest my viewpoint here and will over to you, Rajiv.
Thank you for sharing your views. So there should be like entrepreneurship development, there should be IPR module also in the engineering colleges and other colleges as well. I mean at all, even including medical and all these things, because IPR does not belong to engineering. So it's all the places. Next I have the Dr. Sonali. She is Pepsodent for engineering. She always fights for technical reasons, that's why I always say her. So we should hear her views also, that a young leader, she has just, I think, started going for 3GP others for the past 2 to 3 years now. So what is her thought process on this journey? Over to you. And be brief, because I think we want to take certain questions. We have been given just maximum 10 minutes.
Thank you, Pathak ji, and thank you everyone for the opportunity. I'm not going to look here because organizers are giving me looks. So, I will try to not repeat what has already been said. But I would like to put up a perspective from the young, engineer or a young standards person sitting here, giving a perspective of when I entered that market, what I felt and how I was treated there. So very gladly I can say Professor Radha is there in the panel, Pathak ji is there, I'm very fond of Mittal ji is there in the audience, Sandeep ji is there, and there are many senior authorities, people have supported me in this journey. Dr. Brajesh Mishra is there. So one thing is, we are talking about patents, we are talking about innovation, but we cannot forget about the youth contributing to it. Once you trust your youth, you give them the platform to speak, you give them the platform to contribute. Any organization can bring up a change, which is there, but you can add up to that change by tenfold or whatever we can put up a number to. For when I entered into this domain, I realized that these SEPs they are like the plumbing for the product-led innovation. As Nitin sir pointed out that if you are building the base right, for example you build a house and you do not have a correct plumbing to it, you would have to rebuild it again. So why do it again? Why don't we do it in the right way initially? So putting in that perspective, though as we have a very young participant in the audience today, and I'll just maybe he is accompanied by his father. Just to the father I would ask a question. Would you ask your child if he or she is ready to take up a challenge that don't take it? You will say, you will support the journey, you will put up the trust that do it. So that's what we young people expect from the seniors, from the government. When there are call for the opportunities, young people or the people who are new to the market are being trusted, as we are trusted in our homes, we, the citizen of India, are trusted by the government. We can, bring the change. We can be the mind and the eyes to the government, to the companies we are working for. Having said that, I would also say, as everyone has pointed out, collaboration is the key. We have collaborated with, multiple organizations when we contribute to IT or 5D. We represent ourselves as India, and there is no question on putting personal interest there. Then, similarly, in this SEP journey or building the innovation, if we build on this practice, we build on putting our personal interest at the back seat and look at the national interest first. For example, I'll just very quickly point out the HEXA-X funding. It is the European biggest funding, and for 6G, I would say they started on January 2021. The grant, the signatures for this deal was put up on 8th December 2022. January 1, 2021, they start getting funds, and they completed their study June 2023. When IT or 5D, 6G vision document was published, and we are still talking about the funds to be released for 6G. We are getting funds, but getting it at the right time, at the right place is the change we are looking forward from this nation. So that could be one example I can put many, but I'll just, Pathak ji is looking at me very, so but just one last point, that collaboration, trust your subordinates, trust your younger I would say people, so we can bring the change. Thank you.
Thank you. With this, I think as far as my panel is concerned, so basically we are saying that there has to be strategic allocation from research and development to national champions, I mean big companies, and then preferential research and development funding support. No, I won't take questions. If startup, MSMEs and academia lead consortium, focus on acquisition and licensing of patents and provide consultancy services to companies, research institutions about the value of their IP portfolio and IP monetization. That's what IP Bridge of Japan did. And the next lessons, I can say that aggregating patents and licensing them to Indian industry, like IP discovery of South Korea, they did. So, and we have to work closely with the WIPO, and I just saw EU, IPO, they have given so many guidelines. So, in place of be friendly to the industry and others. So, these are my thought process, and I really say Mr. Praveen Anand's those presentations were very, I think, excellent, and we can give our recommendations to the government on the experience he has told the South Korea as example, because those were all the things we have to do in India as well. So with this, I can take the questions from audience. You can just point out with whom you want to ask the questions and briefly introduce yourself. Thank you. Only two questions they say.
Yeah. Hello. Good afternoon, sir. Myself Kapil Parashar from Vyom Digital Services. We are working on the same field. I have a question with Rajiv, sir. That nowadays the passive network is working with like radar. The radar is coming with the passive network. So I think so that there is no SEP right now available. And my second question is that the funds is available with the DRDO and technology development funds is only for the big players. Can it includes the startups also? This is my question to you.
No, I differ with your statement that funds are available for the bigger player. No. Funds are available for starting from the individuals, like the schemes have been announced by the DPIT or by the DST. That's for the individual also, for taking a startup as a career. So like the one scheme is there, entrepreneurship in residence, EIR, where we give the fellowship to students for 1 year. They can avail that fellowship, they can learn whether I should go for the startup business or not. Then I already mentioned the Nidhi Prayas. So these are all for the smaller entity like the startups, not for the bigger player. And so that's why the culture, if you see during last 10 years, we have approximately more than 1,80,000 startups. So startups are not the bigger one; they are all the smaller one. Before 2016, when we launched the Startup India, we had hardly 500 or 600 startups. But during the last 10 years, it has grown to approximately 1,80,000. So that incorrect. But yes, we have to make the balance between the smaller and bigger. How we can make the smaller startup to the bigger company. So that's the government mandate right now.
Sir, my question is a little different. I am asking only the passive network for the leaders because this is not for the
Yes. Sir, my name is Rahul Ajachatra. I'm an IP lawyer. My question is, in your experience, Mr. Kumar, that when young innovators come and they innovate, what kind of a entry barrier do they have to become part of the standard? Because according to me, standard essential patents are protecting few suppliers who have invested and innovated and got patent, and they will collectively control the market in a way who will supply and give the license. So could you reflect that? Has there been instances where small innovators who probably have invested and innovated in technology can contribute to the pool, but probably they lose out?
मैं बताता हूँ.
So what is the philosophy of SSOs, which should be it should be exclusive or inclusive when it comes to small innovators? And now we're protecting small innovators.
सर मैं इसमें बता देता हूँ आपको, क्योंकि जब TSGSI हम लोग बनाए थे 10 साल, तो काफ़ी लोग नहीं चाहते थे कि TSGSI बने, जो मित्तल साहब ने शुरू में बोला था. और वहाँ पे स्टार्टअप के लिए 10,000 की केवल एंट्री वो रखी गई है मेंबरशिप फीस. और याद रखिए कि स्टैंडर्ड डेवलपमेंट ऑर्गेनाइजेशन में स्टैंडर्ड शुरू में नहीं बनते हैं. They are being decided at 3GPP, third generation partnership project, for which you have, if you want to become an individual member, because you have the IP, so you can't speak in public. You have to go and only during the meeting you will tell your problem. For that fee is 8 lakhs right now. So that's what I think I told, that government has to fund first your funding of 10 to 20 days for any startup. They can't bear. So right now, MIT, DST, DOT is giving you, whenever they give the fund, then that includes the cost of your IPR, all those things. But I think it's the right approach that you, generate certain persons who will be attending your standard meeting as well, and it's long drawn process, not in a day one. You can't do in a one meeting, but a series of meetings, and the person has to be established as a innovator. So that's take lot of time and efforts, not in day one or in one meeting. और कोई एक आध इस साइड से
hello esteemed panelist, I am Shautik Shamui from, I'm pursuing MTech in computer science and technology from JNU, and also I'm doing internship in Bizamica consultancy. So my question is, can the formal legal recognition of paralegal works bring down the time of the resolution of ACP related cases, and also how ACP can put an end to the piracy?
नहीं, ये हम लोग बता नहीं पाएंगे. अगले क्वेश्चंस आगे होंगे, मेरे समझ से वो लोग देंगे.
Sir, in the interest of time, I think we can take the rest of the questions offline.
या मैं भी यही चाहूँगा. अच्छा, बता दीजिए आप.
IPR matters only. My question with Rajiv ji. Rajiv ji, I am also a member of the board of governance with the Nidhi project of the Government of India, Nidhi DSC project, where we are helping the incubators, the startups which come to the DTU, Delhi Technological University. I agree with Mr. Nitin Sharma where he says that awareness is the biggest issue. So at one stand, when the Government of India is providing funds under the Nidhi, wonderful scheme, because individuals come from every part of the country and we are dispersing funds when the session happens. Now the difficulty which comes before us is they don't realize whether they have a patent or whether they can get a patent or whether they are eligible for a patent. So I see a gap where the ministry is doing a wonderful job by providing funds to even single individuals from each and every part of the country. But on the awareness aspect, there's nothing. So is there any scheme, or are you doing anything to create awareness or some kind of a module where these people who approach for funds, at least they have an idea where they can commercialize their patent or can get a patent?
Sir, we fund these startups through incubator. We don't fund directly to the startup. So we request where the startup comes to incubator, and it's mandatory for incubator to hire a legal experts, legal mentor who can guide them. So we keep on it, like the DST has established about more than 150 incubator, then Atal Innovation Mission also establishing. So we are mandating that there should be a legal experts or mentor who can monitor or guide them on the patenting issue, because whether patent is viable or commercializable or innovation is really needed or not. So that kind of mentorship they are providing. We are paying to incubator, and it's their role, and we are monitoring that yes, they should have the right people, right mentor kind of thing. So when we do the evaluation, we see the profile of incubators also. You must be knowing there are a few incubator, those who are doing very well, like the IIT Madras, IIT Delhi incubator, they have very right kind of expert. But yes, it will take some time for government to reaching to all incubator with the same kind of manpower. So yes, we treat like one tier 1 or tier 2 kind of incubator. One has mentors, so that's why we launched one new initiative, mentoring the incubator. So like the first tier institutes incubator, they will mentor to second tier, that experts will move there and then mentor them. So we are taking care of that, but it's not one day we can solve all problems.
Thank you. I think lunch हम
That's
बात करेंगे अभी या अब आपको.
That's
Thank
all
you.
we have time for. Thank you, Mr. Pathak and the panelists, for a riveting session. It set some much needed context for this conference. Now I request you all to oblige us with a group photograph. After that wonderful session, I'd like to move on to the second session. Ladies and gentlemen, if you would oblige us and stay in your seats. So the second session in this conference is titled Decoding the Dynamics of Standard Essential Patent Development. This session will delve into the procedures involved in standardization before standard setting organizations or SSOs. It will map key stakeholders, including SEP holders, implementers, regulators in this ecosystem, and explore how Indian firms can increase their presence in global standard setting processes in line with our national aspirations to increase India's share in SEPs. Some housekeeping rules for this session are that I'd request all panelists to stick to their timeline so that we can take more questions from the audience. I now request the moderator for this session, Professor Manveen Singh, Professor and Associate Dean, Jindal Global Law School, to join us on the stage. Thank you, Professor Manveen. I'll also request the panelists to join us, starting with Dr. Brijesh Mishra from CDOT, Department of Telecommunications, Dr. Igor, who will be joining us virtually, Mr. Nishant Sharma from Dolby, and Mr. Sandeep Sharma from Tech Mahindra. I now hand over the dais to Professor Manveen. Also requesting the audience to please take their seats for this session. Thank you.
I request everyone to please be seated so that we can start with the next session. I would also like to thank everyone for the wide participation that we have received. I think even when we were planning the organization, we wouldn't have imagined that on a Saturday morning we would have a packed crowd. So thank you all for the participation. So with that, I shall hand over the baton to Professor Manveen Singh, who will moderate this session.
Thank you so much, Aman. Very good afternoon to everyone who's joined us for this session. I think the stage has been set pretty well in terms of taking forward the discussion from the previous session and what was spoken about in the morning. The title of the session is Decoding the Dynamics of Standard Essential Patents Development. Now, to set the context for this session, let me say that the entire standard setting process is spanning from the very initial stage of the SSO starting the standard development process to the phase where the work on the standard is being carried out, to the ex post stage where the standard is set and the real, and I use the word very carefully, game begins. And I think I don't need to explain why the word game is used here, because that was already spoken about earlier. Why we say that that's the time where the game begins is because that's where the negotiation is going to take place. The licensing negotiation between the two most important stakeholders in the entire standard setting process. And these are SEP holders, or let's say licensors, and implementers or licensees. And I want to focus on the term implementers because since morning, the term implementers has not been referred to. The term that has been referred to is licensee. But if we are talking about SEP licensing, let's be honest, we need to get these terms spot on. It's SEP holders on one side, implementers on the other. And of course, over the course of the next few minutes, there'll be more on the lines of what exactly is expected of the two. To begin with, I would just like to check with Dr. Igor Nikolic if he can hear me. Igor, am I audible?
Yeah. Yes, I can.
Hi, good morning to you and good afternoon to everyone who's here because the time difference. Igor, let me start off with you. We often talk about SEP licensing as a concept, and we talk more so about FRAND, fair, reasonable and non-discriminatory rates. And of course, there'll be, more on that in detail shortly. But one thing that is often neglected is what exactly is happening at standard setting organizations. What is going on behind the scenes? Which technologies are making their way into a standard and how? Which then, makes us wonder that what is the role of a standard setting organization? And from a personal standpoint, because I am a student of law, yes, I teach, but I am a student of law at the end of the day. I often get this question from my students, my IP students, and that is, what exactly is the role of an SSO? What are they doing? Because if the licensing is supposed to take place between the SEP holder and the implementer, and the SSO is not really getting involved, then what are they doing in this entire scheme of things? So, Igor, according to you, how important is the role of SSOs in the development of standards, and what exactly goes on behind the scenes at SSOs in terms of the processes involved and the procedures followed? Could you please throw some light on that?
Yes, thank you, Professor Singh, for this good introduction and for organizers for inviting me to these conferences. I'm sorry I'm not able to travel to Delhi this time, but I hope next time I will be in person. If I'm not audible, so please somebody say something about SSOs, or I prefer to call them Standard Development Organization, because this is actually their work. So with big international standard development organization like ITU-T, IEEE, ETSI, they all work based on WTO principles, and these are transparency, openness, impartiality, and consensus. And what does it mean? So it means that everyone can get information about standardization process, they can get access to the standardization at different points of the development. Meaningful opportunities are provided for all members to contribute to open standards. And there is decision-making by consensus, meaning that all views should be taken into account. And finally, standards that are developed there are available to others, usually on friend terms. And if you look at behind the scenes, this is a process driven by engineers. And the process starts first by formulating a technical problem that needs to be resolved. For example, how do we want to envisage 6G in the future? What kind of problems we want 6G to solve? And then once the problem is defined by engineers, then it is breakdown into different smaller pieces and handled by different working groups. And again, company engineers are working in those working groups, trying to find a technical solution to the problem. And they submit technologies that they own, and companies vote which technologies should be included into a standard, which not. And finally, once the working groups conclude their work, then the standard itself as a release should be adopted by the whole SDO. So generally, as the process of SDOs and their work is about developing the best possible technical standards, and the process is driven by engineers. They're not made with licensing in mind. And one last point I want to say. So this is where we talk about open international SDOs. They allow all companies to participate. And it's a good opportunity also for Indian companies, because the process is open, everybody can get on board. So this is the way how different companies from different countries can get their technologies implemented in future standards. And it's also important to say that there are other closed standards developed, proprietary standards developed by closed groups of companies that don't follow these WTO principles. So that's a distinction to keep in mind. And I'll conclude here.
Thank you, Igor. I think that's quite insightful, because it's important to realize that participation in SSOs or the standard development process is not something that is difficult. Rather, it's pretty straightforward, as Dr. Igor has mentioned. Yes, there are finances involved, of course, and it was talked about in the last session. So we wouldn't dwell much on that, because we already know where we stand in terms of the financial backing, and that's something that every participant has to consider. But having said that, of course, the next stage, once the standard has been published, is the licensing stage. And over the last few years, I would say, a mechanism that has increasingly gained some sort of a recognition and acceptance at the same time is that of patent pools, which again is not something that is talked about much, at least as far as the telecom sector is concerned. But in other sectors, we are seeing, especially in the auto sector, a massive amount of, or a massive number of, let's say, licenses being granted to millions of vehicles or vehicle manufacturers out there in terms of the connected technology that we use in our cars, which we very commonly know as connected vehicles in today's date, as the generic term I'm using. So coming to Mr. Nishant, and of course, he's here on behalf of Dolby. So Nishant, my question is, given this acceptance on the on the part of the industry vis-a-vis patent pools, even if we see this outside of the domain of the telecom sector not so much, how do you see this emerging emergence of patent pools playing itself out in the era of IoT and 6G? Because that's where we stand at this point in time. And it's a very crucial juncture. So your views on that.
Right. Right. First of all, thanks FICCI and Manveen for calling me on this session and enabling me to share my views. I come from Dolby. I represent Dolby. I handle patent licensing and litigation for Dolby in India and Southeast Asia. And Dolby is a company which is primarily dealing into audio visual technologies. We have standardized technologies which we license out bilaterally as well as through pools, and that's the reason I'm here to share my experience, in a way Dolby's experience on pools. Talking about pools, I think Dolby has a fair bit of good experience in licensing the technologies through pools. We are part of pools which are dealing into audio and video technologies, standardized technologies. What we have observed is the audio-visual pools have in general less friction as compared to what it is in the other sectors, maybe the wireless sector. Pool is like a one-stop shop wherein different licensors on a particular technology come together and offer a combined license on all their combined patents. So you have one-stop shop, you go to a place, take a license and be relieved that you have a license on a particular standardized technology, and you can very easily, safely sell your devices, market your devices in the market. Pools are known to solve the perceived problem of royalty stacking, though there is no empirical data as such supporting that there is royalty stacking. But I would still say that pools offer that benefit in the sense that since all the licenses are there, there is a combined royalty fee for the entire pool, and you don't have to go to each and every license or discuss a license, negotiate a license, and then be subjected to their own individual terms and maybe pay an amount which is probably more as compared to what a pool is offering. So if you aggregate all the amounts, it would be amounting to something more than what a pool would be offering. So that's one part. As I said, it is economically efficient. You don't have to go to each and every licensor who has standardized technology or patents on that particular technology to negotiate a license. And negotiating a license, by the way, is a very costly affair. Apart from the fact that it brings in my salary, but the point is that it is very, I would say, excruciating in terms of the financial aspects. You need to spend at least 3 to 4 years, negotiating a license, and then in case that doesn't turn out to be a license, you have to litigate. So it is a costly affair in terms of you go to a pool, take a license on all the technologies in one go. You don't have to go to different parties to get a license. The other aspect I would say is it can also take care of the individual dynamics of the different licensors. So each licensor may have a different sort of vision, different practice about their own bilateral programs. But when you go to a pool, they are working together with each other, and you have to comply with the basic rules of the pool. So in a way, the pool takes care of all those dynamics, individual dynamics. Only thing you have to deal with is the pool administrator when you are taking a license. So in that sense, I would say this is our experience. It has been on the audiovisual side. I think the same model could be replicated in the other technologies, as you talked about IoT, maybe the wireless technologies as well, and it could, in our opinion, work out to be an efficient manner of getting and taking licenses.
Thank you, Nishant. I think one thing that is clear is, of course, that the pools do offer something for the implementers, at least in terms of the timeline that is involved in negotiating a license. Of course, there's always a split opinion in terms of whether you would want to give into a pre-decided rate. But then the upside or the bright side to this entire bargain, so to speak, is that you don't have to spend time in negotiating individually with every single SEP holder that is involved. Although there may be a situation where some of the SEP holders are not a part of the pool. So you will still have to go to them individually. But those who are a part of the pool, and that's a decent number, if we at least see the auto sector as an example and Avanci, it makes a lot of sense if you take a pool license. But then again, it's up to the implementers to take a call on that. Moving on, of course, that's as far as the SEP licensing bit is concerned. Now, where we are positioned at this point in time is the 6G standard that is staring us, in the next 5 to 7 years. Now, in the context of SEP licensing vis-a-vis, the 6G standard, there are likely to be different challenges. But before I get to the challenges, I would like to ask Mr. Sandeep, who is here on behalf of Tech Mahindra. Sandeep, how is the 6G standard different from its predecessors, or let's say the previous iterations in terms of 3G, 4G and 5G?
Thanks, Mavneen. It's working now. I need to press it for a long time? Great. The mic, so still I'm thankful. Oh, it's working fine. It's like one at a time. It's like one at a time. Okay.
Just pressing it once it is stay on.
Okay. Thank you. Is it fine now? Everyone can able to hear me? Yeah. So let me start again. Hope it works this time. Thanks for having me here. If you look at the question from Avneen is how 6G is going to be different. For most of us, you feel like 6G is going to be another generation of wireless communication. But if you look at deeply how the generations evolved over time, like 2G, 3G, 4G to 5G, there are a lot many technology development that happened. And technology development not only from the standard perspective or patenting perspective, it's how consumers are evolved who is consuming these technologies. 6G is going to be much more drastically different. The more we go into standard, then we realize it. But broadly speaking, from the perspective, first, the technology ecosystem is going to get more diverse. Till 3G, 4G, we normally talk about connection, mobility, data. But with 6G coming in, we'll integrate multiple other things. AI is an important part of it. So 6G networks are going to be AI integrated or AI native, as I say. Sensing, I think till now we only thought of sensing as a radar technology, but integrated sensing in communications. Similarly, other perspectives around security and all will get involved into it. Once multiple other technologies which were existent parallelly for a long time get included in the standard, I think there will be a diversity of ecosystem from the partners who participate into it. So negotiations will be much more multi-diverse, multi-company, multi-standards as well. Thirdly, the licensing part of it. If you look at till 2G or 3G, the licensing was mostly done how they change the charge the royalty from the perspective of how many devices are being using it. Then we evolved to, okay, devices is a pretty broad phenomena. Let's bring it down to chipset level. But if you 6G is more like service-oriented thing. Licensing will evolve to a service. When service level licensing will evolve, it will require a multiple series of IPRs. And that's where the pool will come into picture. Then the pools like Avanci will be much more relevant in the 6G era because you need to have a pool of licenses so the end licensee should not be worried about for which service how much licensing fee has to be paid or with whom he has to negotiate. And lastly, policies and the regulations. Till 5G, it's more like a standard that are happening, but in 6G, it is more a strategic set that every country is creating around it. And there'll be more dimensions around it, strategic importance, and geopolitical importance as well. So we look FICCI as broadly in terms of differentiators that provides from the diverse technology ecosystem, the diversity of areas where it needs to be negotiated, and its strategic importance as well. Thank you.
Thank you, Mr. Sandeep. I think that speaks a lot about the dynamism of the 6G standard, and of course, the task is absolutely cut out in terms of how we intend to draft the policies vis-a-vis 6G standard or the regulation of 6G standard, and that's where I would like to bring in Dr. Brijesh, who's here from DOT. Dr. Brijesh, we of course cannot deny the fact that from a licensing perspective, SEP licensing in this particular case, policies and government initiatives occupy a very important role. And therefore, a lot of talk has always revolved around why we need to revisit some of the policies that are already existent in India, and I'm taking India's case, and how that can spur the next generation of innovation, innovators for that matter, especially when we are talking about a certain share in the 6G standard. So what are your views on that?
Am I audible? Yeah. Thank you, Professor, and I'm grateful to the organizers and audience for patiently listening to us. Now, I am coming from CDOT. Right now, I am posted in CDOT on deputation, and I'm looking after collaborative research programs of CDOT. And I have been also assigned the role of IPR front ending. This role was given by Department of Telecommunications to CDOT. And let me tell you that mostly this IPR front ending role is restricted to awareness side only. Means it's a huge responsibility, and this is something which cannot be done by one organization. It has to be done by all the stakeholders which are involved in this process. Now, the role of government, whether it is any developed country like USA or a developing country like India, is very, very important. Innovation will always remain very important, and that's why it is very important to strengthen the ecosystem, innovation ecosystem in any country. Now, coming to your question, it is why it is important to promote innovation for any government. Why at all government should bother about all these things? Why it can't be left to the market? So first thing is, if we consider all the growth theories, economic growth theories we have, particularly the regional growth theories, the models proposed by Arrow, one scientist, and Romer, another scientist, and so both these models somewhere they have established that technology created and adopted play a very, very important role in economic growth of any country. So this is something, innovation is not a choice for any country. If we want to become a developed nation, then we have to remain innovative and we have to promote it. And then secondly, that innovation is also a must for development of indigenous technologies. We cannot just keep on depending on foreign technology, importing technology and solutions. And that's where it becomes important due to strategic reasons, for national security, for reducing stress on the foreign exchequer. And thirdly, very important point is that if we want to meet or if we want to address the Indian specific requirements, or any country wants to meet its own requirements of its own society, rural areas, then this is the area where it has to take care of the innovation needed for that. And now, as you ask, that policy they cannot remain static. They are to be revisited again and again, and for doing that, the best advice, the best suggestions come from the society. So if we are interacting in a session like this, means if policy makers are a part of these kind of discussions,
stakeholder consultation, then it always enriches them for coming out with a better policy. And let me tell you that there are different ways, different modalities of regulation. For example, code modality, then control, communication, coordination. So these are, and then these are very, very important. And now if you also consider this collaboration is also a mode of governance. So you can say that whatever funding support is coming from government, in a way it is a collaboration happening between industry, academia and the government. And it is very, very, very useful. And this SPF in particular, call it sovereign patent fund, I would like to call it a strategic patent fund, is a step in that direction. And I will like to take it up in the next round. Thank you.
Thank you, Dr. Brajesh. I think that kind of sums up what we really, ideally would want from the government in terms of some of the initiatives, or let's say at least a constant relook at the policies that are in place. Because if this field is dynamic, if standards are dynamic, and we have a certain shelf life for every standard, then it is also required that the policies are revisited from time to time. You cannot have policies from the British era dictating what's happening today. So there needs to be a constant revisit of what are the policies in place, or what are whether the laws actually require any kind of amendment. On that note, I would actually like to go back to Igor. Igor, am I audible? Yeah. So given India's goal of contributing around 10% SEPs to the 6G standard, and your rich experience in terms of SEPs reading on the telecom standards, can you throw some light on the kind of policies that a country like India could adopt which may help in realizing this goal? I mean, what would you objectively view as policies which are a must for a developing economy like India?
Thank you very much. So first I would like to say is that I already see there is a lot of telecom R&D happening in India as we speak. So for Nokia, for example, our largest R&D centers are in India, actually, in Bangalore and Chennai. And we employ around 9,000 engineers and are working already on 5G and now on 6G development. So, and I understand other companies also have their large R&D centers in India that are doing groundbreaking research. So I believe that the brain power is already in India. And the question is now how to translate this into more Indian patents and into more Indian companies participating in standard development organizations. And just before I go to some policies that may be useful, just to say as a background that Nokia is in a unique position because we are both implementer and an SAP holder. And actually we are larger implementer than SAP holder because we produce mobile networks and equipment, and we also have a factory in Chennai. And actually the large majority of our revenues come from selling systems based on standardized technology. So our dual role as both the developer and implementer of open standards, we believe, give us a unique and balanced perspective. And my kind of ideas how to innovate more and how to help Indian companies produce more patents and participate in SDO is actually to focus targeted work in SDO participation, and participate in SDO meetings and working groups. And that may come, government may also help there by giving education and knowledge, but also by grant for companies to participate in those meetings and supporting companies participating in those meetings. And that would help because participating in SDOs, in 3GPP, which is now working on 6G, is open, as I said. So, but companies need to follow and need to participate and need to travel. So there are some costs involved. And after that, I would say the second is to cultivate a climate of strong IP protection and enforcement. Because once companies obtain patents and they invest in R&D, and to give you an example, in Nokia, we are annually investing around 4.5 billion euros, which is around 20% of our revenues. So around 20% of our revenues goes into the R&D. And many of those results of R&D are standard essential patents that are declared at various SDOs. And in order to get a return on investment, we need to license on brand terms. And we really rely on efficient licensing. So, and it's also important to keep in mind that this business of licensing is not really that easy and not really that profitable to begin with. So first, as standardization, it takes time until you reach the final version of a standard. And if you apply for a patent now, it may take 10 years until there is a final version. Then you need to wait for products to appear on the market, another few years, then go into negotiations, as Nishan said, so another few years. So already, once you start negotiating, 10 years of your patent has expired. And after you negotiate for a couple of years, you get 3, 4, 5 years expired. So what we are seeing generally is the problem of holdout, and that companies are intentionally delaying or avoiding licensing. And I understand this. So from their perspective, they're using standard already for free before having a license in place. And that's possible because, as I said before, standards are open, transparent, they're accessible to everybody, and companies start using those products. And from their company perspective, when they think about, okay, maybe this SAP portfolio has 10 more years until it expires. If I delay and not negotiate, maybe I can just get away without paying anything. But then from our perspective as an innovator, that destroys this, we call it virtuous circle of innovation. So we invest a lot of funds into R&D. And in order to invest into future standardization, we need to obtain revenues, we need to obtain return on investment, we need to obtain royalties from licensees, and those royalties are then reinvested again into future R&D. So that's kind of a virtuous circle of innovation. So I think also Indian companies that are contemplating whether they want to enter the market, whether it's profitable for them to spend millions and millions into R&D. They're also calculating what is the return of investment. And if they have weak IP system, if they see that it takes a lot to get licensed, then the courts are looking hostile at them, that the government is looking hostile at them, then they may get a rational decision not to enter the market. So the climate is very important, and also the government policies are important in that respect, to incentivize companies, to show them that they can, that it would be profitable and their IP would be protected. So a little bit about the sovereign patent fund. I believe if properly structured, it may incentivize and bring benefits for Indian SAP holders. For example, we have experience with patent funds in other jurisdictions, and what they do a few things. One is R&D support, so they finance R&D projects which they believe would be profitable, and they also may help with the licensing. So they may act as a pool and then help companies to license their patents to others. And that may be a winning formula, I believe, how to incentivize Indian SAP holders to appear. One final thing I would like to note is raising awareness on SAP licensing and standardization ecosystem. That was talked a little bit in the previous session, so I would also like to emphasize it's important to educate companies and educate both implementers about the importance of SAPs, that there exists an SAP ecosystem, that these technologies are available on friend terms, educate them how to negotiate, what are the international standards about that. And there are also kind of works by UK IPO, which produced SAP Resource Hub and WIPO section on SAPs. So that may be looked as an example in which way to go. And I'll stop here. Thank you.
Thank you, Igor. I think one particular thing that stood out from your remarks was the fact that this entire licensing process is both cost sensitive and time sensitive, which is what brings me to the next question, which is of course, Nishant, to you, that concerns involving transparency and royalty determination, have been regularly flagged by implementers. And amidst all of that, we suddenly had the emergence of pools. So how do you assess the patent pool's role in addressing some of these concerns? Because for implementers, this is the most important aspect of any licensing negotiation. And transparency, of course, is something that has time and again come back and been the center of discussion. So from an SEP holder's perspective, and I'm taking the liberty to kind of point that out, what are the factors likely to be considered while deciding on whether to join a pool or not? Because at the end of the day, you did mention that you are a member of some of the pools, whereas not of the others. So what dictates this choice?
Right. Coming to the first question about the issues, and I think I'll refer to Rajiv on that. He pointed out the aspect of lack of transparency in all these, most of these licensing discussions. So I think pools take care of the issue of transparency in a very efficient manner, in the sense that I'll just give you an example. There is a AAC Advanced Audio Codec pool, which is called the VIA AAC pool. And if you go on their website, you will see they have published a list of patents, published a list of licensors, licensees, their rates as well. So talking about transparency, you have everything that you want available to you in public domain. You can go access their website, see who are the licensors giving out licenses on their patents, which of the patents, what rates, and just get a license from them. Just go and take a license. So that's one part. The other aspect is third-party essentiality evaluation. So most of the pools would carry out an essentiality analysis, and this is an independent essentiality analysis, wherein before taking any patent into the pool, they'll conduct an independent third-party analysis, wherein the monies are paid to these law firms or service providers who will analyze the patent claims and map it onto the standard and certify that okay, these patents map onto a particular standard. Again, this again refers to what Rajiv pointed out, that there are issues related to determining whether there is essentiality or not. So I think if you go to a pool, you are ensured that okay, the essentiality issues have already been taken care of. I need to discuss maybe the rates or taking a license, what are the terms and conditions I need to take a license on. So it takes care of most of the aspects that you may face when you have a bilateral discussion. Again, the other aspect is most of the pools would have a large licensee base, which in a way corroborates the frankness of the rates. So there are 1,000 people before you who have already taken a license. So and I think Mr. Pathak also mentioned that not all rates are same. Mr. Anand mentioned that all the rates need non-discriminatory doesn't mean the rates have to be same. It would always be a range. So you can go have discussions and get a rate which is in the range that you should be offered or you should be paying. So a large licensee base establishes the frankness of the rates, and you can rest assured that whatever you are getting, others are also paying the same. Apart from that, in terms of, I already talked about the economic benefits of negotiating with a pool. So not going again on that aspect. Apart from that, the pools also benefit MSMEs. So of late, I've been hearing a lot about SEP licensing affecting MSMEs a lot. So in a way, MSMEs, by the way, are not at all affected by SAP licensing reach outs because they do not qualify the minimum threshold volumes that are actually required for making it an efficient and economically efficient transaction or an engagement. So the licensors would also look at an engagement which brings in money and not expends money in terms of negotiating. So what happens is most of the pools would have a threshold volume range wherein if you are selling devices in a particular range, only royalty fee would apply only when you go beyond that range. So say a threshold level of 100k units or 500k units. Most of the MSMEs would be selling below that threshold range. So in a way, they are using the technology without a license. They do not need to take a license. Of course, when they reach that threshold or cross that threshold, they would have to pay a royalty fee. But that takes care of the initial boost that an MSME or a small company needs. And I'll also refer to Dr. Ganti's comment wherein he said that individual innovators or maybe small companies do not know what to do with their patents. So some of the pools also have these MSMEs, universities as licensors. So in a way, they become a part of these pools, offer their licenses for licensing, get revenue out of it, and then use it for further R&D. So that's how pools can be beneficial for one and for all. Yeah.
Thank you, Nishant. I think that sums it up pretty well. So of course, it all boils down to licensing and how patent holders view this entire transaction. Of course, we are looking at the implementers side of things as well, but just focusing on the India specific situation at this point in time, and there's been talk of sovereign patent fund, which Dr. Brijesh actually recoined as strategic patent fund, and we would want to know from him why that is the case a little bit in detail now. So it started about almost a year and a half back, if I'm not mistaken, somewhere close to the general elections last year, that this talk of sovereign patent fund came up, and then there wasn't much heard about it or in terms of the developments on that particular matter subsequent to the election result. And we still, of course, continue to talk about the sovereign patent fund and the kind of impact it may have. Now, against that background, Dr. Brijesh, I would like to know, what kind of impact do you see government initiatives in general and the sovereign patent fund, I'm also beginning to now say strategic patent fund, sorry, so sovereign patent fund have on the SEP ecosystem in a country like India?
Thank you, Professor. So to answer to your question, I think yes, it was in news a few months back. I mean, more than 1 year, and it was taking shape. I will not say that it's still there, very much there, and as you know, it may take some more time to take final shape. Now, if you allow me to express my personal opinion, I look at it means how it will how this SPF in particular, where contours are not well defined. So say for other schemes of government which are say related to R&D funding, and for those things, for example, Telecom Technology Development Fund, or many other schemes, PLI of DOT and MIT, and MIT has also a lot of number of R&D funding schemes, and similarly we have many schemes coming from DST. So when it comes to R&D funding, things are very clear, because
they follow some set of guidelines, and guidelines are mostly available to the in the public domain. Now the problem with SPF is that things are still, I think, under discussion, and that's why it is very important to now. It means we have opportunity to shape it properly, and that's why if we want to shape it properly, then we should be ready to answer to a few hard problems, and I would like to follow that route. For example, first question may be, should India go for SPF at all? What should be its timing? And opinion of subject experts. We have a lot of good subject experts in this matter. And then means of course this may be just for record only. Means we should answer this question: should India go for SPF or not? What should be its timing? And then there will be supporters of this question. Means somebody may say yes, it should be done immediately, and then say there may be some stakeholder who would like to say that no, let us have some caution also. So timing means somebody may say that timing is ripe, as India is increasingly seen as global innovation hub, and if we want to be early adopters of emerging technology, make in India, realize the make in India things, then we should go for it. So here I'm not expressing my personal opinion, I'm just saying that it is a hard problem, so opinion will differ. Second problem or second issue which must be addressed when we are trying to give it a shape is, what can we learn from past global experience? We have many success stories, many failure stories, and success story, I think Japan, South Korea can be categorized in that. Failure story, I think Brazil is a good example which faced misaligned goals, basically. So there was some misalignment, and then lesson for India is that we should build a flexible SPF. If the first question is yes, so we should build a flexible SPF that should support innovation while being industry driven. It should be driven by industry. Let us not expect that government will do any justice if it decides to drive it. It should be driven by industry. Of course, government should be there as a support mechanism. And then definitely we should avoid over-regulation, and we should engage both private and public stakeholder at the earliest. Then third question will be, should it be comprehensively covering all the sectors or restricted to a critical technology active sectors where technology play a major role, or it should be for ICT sector, or it should be only for telecom sector? So the question is, again, so just imagine, it's not an easy problem. Now, if in the interest of time, my personal opinion is that we can start as a sector specific approach, and then we can widen it. Fourth question can be, who and where are the targeted audience? Means if we are going to create SPF, whom we are targeting to serve? That is very important. If you are not having clarity on this question, where are the stakeholders? Where are the targeted audience? So this is important, and that's why if we identify those stakeholders, let us make them part of this decision making process. Otherwise, we will say that we have covered these audience, but they will not be satisfied, and they will, the moment some guidelines will come, they will say, no, these guidelines need to be modified. Next question will be, what should be the scope of SPF? What are the activities which we would like to cover under SPF? And then, so there should be a list of activities, and then we must prioritize those activities, because government or any SPF will not have unlimited resource at its disposal, and we have to prioritize activities. And that decision should come from stakeholder consultation. So, for example, let us, if I just say that, okay, one of them can be patent awareness, means we can use it for promotion of this awareness and all those things. Then, and then somebody can say that, okay, IPR life cycle management can also be one of its activity. Then technology transfer, legal and technical assistance. See, the problem here is that that different stakeholders would like to look at it as in a very limited manner, which benefits their own interests. So here we have to optimize their expectation. Now, next question will be how to administer SPF. Should we use existing institutions or should we go for creation of new institutions? I'm saying that if we don't plan end to end, if we say no, let us just go for SPF, let us have this much amount dedicated to it, then this will not work. Next question is, what are the possible pros and cons connected to SPF, and how to means pros and cons. We should definitely have a relook. What are the pros and cons associated with that? And then last will be that what are the critical points on possible use and scope of SPF. So we may list out those critical points which the decision may take into consideration overall. And one of the activities of this SPF may be that it can be used to map patents and SEPs in the standard space, in the technology space. Means mapping is a very crucial activity which is required by the implementers, so this SPF can be used to bring some clarity on this account. So thank you.
Thank you, Dr. Brajesh. I think I'd like to take a cue from the point that you mentioned regarding learning from past experience. Now, the fact of the matter is that we have actually seen what transpired with 4G and 5G. And with 6G, we probably shouldn't be repeating those mistakes. And there are examples such as those of South Korea was talked about in the morning, but even Japan and China. I mean, Huawei, ZTE, Oppo, Vivo, Xiaomi, together, you look at the number of SEP families they own with respect to 5G. So out of the 64,000 odd SEP families, it's just a kind of a rough number I'm saying. I may not be correct in terms of the accurate number. Majority of these SEP families belong to Chinese companies. So what can we learn from that? Of course, geopolitical situations aside. But coming to my last question to Mr. Sandeep, you talked about the uniqueness of the 6G standard. Now, in light of course, what we could learn from our past experience, how do you see India's push for inclusion of a certain number of Indian origin SEPs or patents? Of course, we can't really dictate whether they will become SEPs or not, but we have to try. So, Indian origin patents as a part of the 6G standard, what kind of approach and in terms of innovation and subsequent patenting of technologies needs to be adopted in a bid to have these technologies eventually making the cut when it comes to that competition at SSOs, which we did talk about earlier. Igor threw some light on that, because you are competing with Chinese technologies. So how do you win this game is my question.
Yeah. So very valid question at the context or the juncture that we are, but we as a nation has committed to be a leader in 6G SEPs. I think rather than looking at what mistakes one has done in the past, look at the positives that we have done in the past. I think in 5G, we are the one who made 5GI as a SEP, as an Indian, meeting the Indian requirements. So there's example already set. So it's not something that India is going to do for the first time. Having said that, getting things done on time is also important. In 6G, as Sonali has mentioned in the start, that lot many fundings in the global arena are already given, lot many innovations already happened. But still, there's a lot of scope that we have in 6G. 6G scope is much wider than 5G. Lot many things can be still be done, and it's a long way. It's not like the first release comes in and SEPs are gone. The 2030 is the first release, and after that multiple releases will come. There's a scope that we need to achieve on. Having said that, just don't boil the ocean that there's a fund, there's 6G coming in, we do all the innovations and bring all the SEPs together. We need to create our own SEP lanes. SEP lanes means find out the things which match the scale and the diversity that we have as a nation, and create those SEP lanes. For example, AI as a coming as one of the component. Think of the things that can be realized and what type of SEPs we should position so that it can help in scaling as well. Secondly, much initiatives also being taken on sensing, trust and security. Use those SEP lanes and focus on that. Still, there's a sufficient scope to achieve that 10%, I would say, vision that we have as a nation. Thirdly, as Pathakji mentioned a couple of times in previous talks as well, SAPs are the byproduct of innovation. So you should be, or we should be positioning more on ideas generation. A factory type of setup is required in the nation where many ideas should be promoted to innovations, to patents, and then eventually going to the SEPs. That will generate more and more potential for the country. And I think Amit from Tejas has mentioned about the lack of education. That is super critical. As I evolved my, I would say, journey, I think more than 2 decades back, I was an engineer. Then I evolved. I realized, okay, I should do MBA as well because business is important. And at this juncture, I feel I should do law as well because IPR is also important thing as well. As you grow in the business, many things are at stake. If your licenses are not secured, your patents are not secured. I think next is, as a nation, we should look at building an ecosystem. Ecosystem in terms of maybe few hundreds or thousands of young engineers who can go and represent in standards, because the standards is a business, right? You need to lobby, you need to position, or you need to get the interest generated around it. At the same time, many test beds are required within the nation as well. Idea generation, getting innovation done to the execution phase, and patents to the patents level. Thirdly, I think many initiatives already in the place, TSDSI, Bharat 6G Alliance, and DOT. I think there should be a combined 6G SEP cell could be created, where small, I would say, startups and individuals can come in, push that pool or use that pool as a medium to promote the innovation that they have towards the standards. Finally, policy as licensing will also needs to evolve as you go further. More and more innovation are there, but the innovator should also know how to defend their innovations as well. They should do law as well. To sum up, I think there's a lot of scope, many things can be done. Space is there, support is there. We just need to create a factory setup where things flow automatically rather than needing people to get worried about or how the licenses will be secured or how the patents could be filed.
Thank you, Mr. Sandeep. I think what we can say is all is not dark and gloomy. There is a bright side to everything, and of course, perhaps as Mr. Pathak was mentioning earlier, all is well is not something we should be saying, but I would draw the line here saying that we are moving in the right direction, and there is light at the end of the tunnel. We just need to continue with our efforts, and if everything comes together, we definitely have a lot in terms of the positives to look forward to. So with that, of course, I conclude this session. I am hard pressed in terms of the time as being pushed by the organizers, although I have stuck to the time. 1 hour we've taken. So we have time for one question. So I'm sorry, but you can always use lunch to interact with all my fellow panelists if you wish to, but I can take one question, ma'am.
Professor Singh. Yes, sir. So we have discussed a lot about how holders and implementers behave, but the relationship between holders and implementers. What about the relationship between holders and holders at SSO or declaration meetings? Number one. And number two, to put India more forward for 6G, for example, have you considered, or in fact, what is your opinion on using blocking patents? Not necessarily SEPs, but using blocking patents to place India in a more forward position. Thank you.
SEP holder relation.
So I think on the SEP holder thing, I think most of that interplay comes into picture at the SSOs or when you go into a pool. And again, it all depends on what is the common vision you are looking at. Sometimes you compromise on your maybe practices at times, not entirely, but yeah, some of it. So as to give a vision to a particular pool or maybe to a particular standard, and you come together. But obviously, your own your company's vision would always supersede everything. But as I said, in sometimes you make those compromises so as to get a efficient system working.
Can I have one question?
We have a bonus time for one more question, please.
This is maybe for the panel or Nishant. It was a wonderful panel. My question would be, how are SSOs different from that of the patent pools? Like, who decides the patent pools, whether it would be residing with the SSOs, or else in terms of the license negotiation groups, which we had mentioned, how are these different, more in the Indian context, like we have Autumn, RTTP, license, LES and other things, how are they different? So if you can just put some sheds on the patent pools in Indian context and the groups of other license negotiation, great.
So I think first thing you asked about was the difference between SSOs and pools and who decides. So pool is basically a private setup, though SSOs are also a sort of private setup and a consortium of industry. Pools is more directed towards the licensors who come together, who think that they can work together, a solution, provide an efficient mechanism for licensing. So it all depends on the alignment between the different licensors who come together and form a pool. And again, it is based on all discussions. So all licensors have to agree on a particular vision and then form a pool. On the aspect of LNGs, I would say, though we like the pools we are part of, we haven't dealt with LNGs as such. But what I have, the academic knowledge that I have is that LNGs have some sort of anti-competitive concerns associated with that, because the pools work in a different manner so as to work in alignment with the competition laws. But LNGs may have an anti-competitive effect if they are working in a manner where they gain market power. So I'll keep it at that, and maybe we can discuss it in detail afterwards.
Thank you so much. And with that, we'll have to conclude the Q&A session. I'd like to thank all the panelists. Please oblige us with one group photograph before we break for lunch. The lunch for the panelists will be in the council room, so you can proceed directly to the room. And I request the audience to come back to the conference room in half an hour, because we'd like to start the next session on time. Thank you.
लंच हुआ है, लंच का तो अभी
A short lunch session. I'm glad to welcome you back. The third session as part of this conference is titled Navigating Licensing and Enforcement in SEP. This session will examine the complexities involved in negotiating and executing SEP licensing. It will explore how FRAND-related disputes are resolved with a focus on litigation, arbitration, and other mechanisms, alongside lessons drawn from landmark international cases that have influenced the global understanding of FRAND obligations. We aim to provide an insight into the balanced SEP licensing environment that promotes innovation while ensuring fair competition and access. The moderator for this session will be Mr. Aman Sinha, Advocate and Consultant, ICRIA. I request you to join the stage. I also request the panelists to join the stage. Ms. Chitra Iyer from Philips, Mr. Vivek Ranjan from Comet Legal LLP, Ms. Julian George, Sai Krishna and Associates, Mr. Ashutosh Kumar, Singh & Singh, and Mr. Eric Stasik, who will be joining us virtually. I'll hand over the dais to Aman to begin with the moderation.
So welcome back everyone. I hope we have all had some food for thought over the delicious lunch that our friends at FICCI have organized for us. And I would encourage you all to encourage the attendees outside to ensure that they join back for the session. And after the food for thought, have some knowledge for thought by the wonderful panelists that we have, a diverse array of panelists, litigators, in-house counsel, litigators working for startups, implementers, SEP holders, they represent them all. So, and I also wear some of those hats off and on. So thank you everyone for joining us for this conference. So as part of a small overview about how the session will proceed, so we've identified some themes that have been presented as annotations along with the agenda. We will be broadly sticking to those, and we have crafted some questions in which we will be taking on a round basis. So for the first question, I'll start with my right, and on the second question, I'll start with my left, so that there is some balance and no one says that the moderator is being non-reasonable, because of course we all want to be compliant with the FRAND commitment. So with that, that was the short overview. And I really thank both the organizers, FICCI and ICRIA, and all the industry partners, the standards partner. I've been to many SEP conferences, but I don't think there has been anyone as diverse as this till now. With that, I should get to the questions because fairness is needed. So the first question that I want to be addressed by this esteemed panel would be that what, according to the panelists, are some of the capacity building measures that need to be implemented to support Indian firms to move up the value chain from not just assembling standard compliant products, but also participating in standardization. So I would request Mr. Vivek Ranjan to start with his views.
Hello everyone. Thank you very much, Vicky, for inviting me to this panel. And I must also thank Sheetal. She called me that, you're required, I'm busy, and you probably have to take my place today. So thank you for inviting me again. And before starting anything, I just want to say a small little caveat that all the views that I express here are my own. These are my personal views. It doesn't represent any company or client or anything like that. So, capacity building in India for standardization, it very much starts with the research. So that is the first point. Research has to be there. Research is there in India. When you go to any IIT or big research institution, they will always say with pride that this is our library and this is how research goes on, and we have one of the biggest library in Asia or whatever in country. But we have to understand that that will not suffice. Lot of PhDs are sitting in India and their research, their thesis is sitting in that library, In my personal view, universities have become black hole of research. They just absorb research, forget about it. Even upcoming PhD thesis, they do not go back and look at that research. So it has to start from that, coupled with the incentives. You know, in India, typically a PhD is taking 5 to 7 years in technical field. And you would see in IIT, I'm talking a lot about IIT because I'm more acquainted with the process there. They get incentive, a lot of incentive in almost everything. They travel, they attend to the conferences, it is incentivized by the government, by the system. If we are serious about standardization, why these incentives are not placed with these PhD theses? Why can't we incentivize that you make sure that your research gets into some kind of standard? Your PhD will be done in 3 years. You will be eligible to get your PhD done in 3 years. So these kind of incentives, the stipend that we give, that is almost 40,000. Why not to encourage this kind of research which is happening by students? And earlier in the panel, someone talked about that we should start very early. This is the stage we should start. Incentivize it. Make sure that your every research in electronics, in communication, in automobiles, wherever standards are required, it gets into some kind of standard, and you incentivize that. And I am sure, because I am very confident, the kind of brain we have in India, these incentivization will prove that it can be done a lot sooner than we actually are thinking. So it has to start from that level. This is my 2 cents. And
yes. Thank you, Vivek, for those insightful remarks, particularly about how educational institutions need to harp on the bandwagon. Now, with these insightful views, I would now request Ms. Julian George to enlighten us with her thoughts on this subject matter.
I feel, a lot has been said today in terms of how to motivate a more participation by India in the SEP space. But, right now, currently, if we see, India is participating in this space, but more as an implementer or as a licensee. So there are some real challenges that we see happening as a ground reality because of these SEP issues. While there is standardization of technology, there needs to be standardization of licensing practices. There needs to be standardization of rates being sought from all Indian participants. There needs to be standardization even on SEP jurisprudence. Till there is no standardization on all these issues, there is no consensus on all these issues. I believe just simply participating and getting India to be at the forefront of many more patents will not be sufficient, because as you can see, already there is a saturation in every technology domain, right? And India's participation can only be encouraged in future generations of these technologies. Now, to ensure that its position is secured, it's not enough to just get your patents as SEPs, but it's also to have clarity on how these patents will then be licensed. Because right now, the bargaining power is more on the old players who have been in this space, who have set a price for their portfolio based on various factors. But how will India achieve all of this without there being clarity on all these issues? So I would say that we need to really focus, and I think there's a lot of discussion happening on this front, as to what are the steps to be taken so that there is consistency across the board on all these issues.
I really thank Ms. Julian George for her consistent and succinct remarks on the challenges that are in store, and I think this is definitely something that we need to discuss and deliberate about, that what should be the standardized licensing practices. With respect to standardized licensing practices, I think that's the best segue to go to Ms. Chitra Iyer, who leads licensing for Philips in India.
Thank you, Aman. I hope I'm audible. I'm going to take a little step back, instead of getting into the fight that we are talking about, licensee, licensor, what really makes the technology tick, right? I'm going to take a step back from a corporate role and look at what we need to do as India. That's what the aim is today is we want to be Viksit Bharat in 22 years. So how do we get there? So essentially what the corporates that have done well, who are now in the position of licensors, is that they asked themselves a few questions a few decades back or maybe even 100 years back. The real questions are, what are the unmet needs of the people? Like at the end of the day, we all serve customers, we all serve consumers, the people who are using these technologies. If India has to get there, I think the essential question that we should be asking should be on similar lines. What does the customer want? If you look at around 2015 or 20, no, not even maybe earlier before that, 2009 types, when Apple came up with an iPod and the first iPhone, nobody ever thought that music could go into a phone. They were two separate devices, but he found a way to integrate, anticipating that there would be a technological need where these two components, music and phone, can be integrated together. Now, I also heard the comments that there are youngsters here who can actually define the roadmap of how we go forward. You are probably in a better position to judge about what kind of technologies are needed for the future. India should not be constantly firefighting. What we should probably be thinking about is, how do we be leaders in a segment? And to be leaders in a segment, you will first have to see, how do I imagine first products that the customer may want? What are the unmet needs? What are the solutions that somebody wants? Then from there on, bottoms up, start working on technologies that are, you don't have to work on existing standards. They're probably already saturated, with already the current players, as Julian mentioned. We should be actually defining the role, defining out what kind of technologies we need out there, be the first ones to start building standards around that. I think today morning it was also discussed that, we need quality patterns. We need quality patterns, and we need to have high ambitions, difficult ambitions. Do not aim for the low-hanging fruits. Rather, look at something that is more strategic, long-term, that can position us in the position of power in terms of, technology leaders. So your aspiration has to be, I think, on a much higher notch than what we're looking at. Of course, these things will come later, licensing, ecosystem, but those things will be sorted out on their own, I believe, as we move forward. As Indian companies and startups start becoming technology leaders, the whole narrative may change. And I'll guarantee you that maybe 10, 15 years now, we will be talking a completely different language than we're talking today. And I look forward to those days.
Thank you, Chitra, for highlighting what is the thing that has to be seen at a corporate level, and how do strategies actually become made. And I think this could be some guidance for all the SMEs and startups founders who are out here, that perhaps you can also look back. What are the problems that you can solve? That could be you yourself doing some capacity building measures, and for once Chitra will not ask for any royalties from you. So
maybe it may be the other way around. We never know, right?
So with that, I would request Mr. Ashutosh Kumar to bring in his side of the spectrum, as to, considering he deals a lot on SEP litigation, as to what is it that capacity building wise can be done for these Indian companies.
Simple. Innovate. Because if you want to move up to the value chain, it's better that you take that risk of innovation. Become technologically independent. And unfortunately, we have some experience in some cases where there was some confusion about the real meaning of research and development. So we asked a CEO of an Indian company, do you do some research and development? He said yes. We said that we confronted with the balance sheet that it's showing zero. Say no, but the marketing is also research and development. So if that is your thought process, then unfortunately, then you won't move up to the value chain. So if you really want to move up to the value chain, you innovate, take that risk, invest in R&D, and then maybe all the other stakeholders, government, judiciary, we can ensure that to create an ecosystem where the enforcement of that kind of patent right becomes much more easier and efficient. So that the person who is taking that risk investing has some certainty that they can recoup that investment. The property which they have created because of that risk at that exercise has some value in the market. So that's my take on it.
I think I must compliment the panelists. They have been extremely succinct, much different from what is normally assumed from lawyers. So, taking that segue, I would just want to get the perspectives of Mr. Eric Stasiak. Eric, I hope so. Just as a small introduction, if you are looking to get information about SEPs, you should go to LinkedIn and follow Mr. Eric Stasiak. He is the most valuable person on LinkedIn for SEPs. So, Eric, if you could give some ideas to our brilliant audience over here, and I just so we had a packed hall in the morning, and we've almost got the hall packed again after lunch. So, if some insights from you on what sort of capacity building measures can be done by India or even global policy organizations for startups, SMEs to move up the value chain.
Thank you. Thank you for those kind words of introduction. And it's a privilege and an honor to be invited to participate on this panel. And I'll just jump into my answer. Excuse me. I've been working in the SEP space for over 30 years. And one thing that I've always seen is the names of very many distinguished Indian inventors on the patents of non-Indian companies. So the idea that the R&D capability exists, that there are educated people, that the knowledge of the SEP of SEP technologies is in India. It's already there. It's been there for a long time. I see Indian companies now following the trajectory of pretty much everybody else in this space. When Samsung entered GSM back in 1992, they had no patents on GSM, and they were in a very disadvantageous position. So they immediately began to invest in acquiring SEPs, taking those inventions that were developed in Korea and filing them in Korea, and sort of building up their own portfolio. And today Samsung is one of the biggest SEP holders in the world. The same is true for the Chinese companies. Huawei, Vivo, Oppo, when they entered the industry as implementers, they had very small SEP portfolios, if anything. And as a result of that, they realized that they needed to have SEPs that helped them in their license negotiations. So they started to acquire their own SEPs. And now again, you look at Vivo, Oppo, they're major SEP holders. I think the same thing is India is on the same trajectory, that you're moving in as implementers, and you have the innovative capacity. It's just to marry the two together, and for these smaller companies, the implementers, to begin to invest in their own R&D, to acquire their own SEP portfolio. All the pieces are there; they just need to be put together.
Thank you, Eric. So, with this round of very interesting insights and some options that have been presented, and Eric has presented this very important reality that even though predominantly perhaps there are not Indian corporations having SEPs, there is definitely a significant chunk of Indian inventors behind these SEPs. Now we just need to get these Indian inventors back home. And with this, now I will segue into the next aspect that we have decided to discuss, which is on the aspect of taking into the suggestions given by Justice Bansal in the morning, that perhaps there needs to be an alternative to protracted litigation. So with this, considering that almost all of you on the panel, not almost all, because Eric is also a veteran of SEP litigation. So considering all of you have specific insights on SEP litigation, my panelists, so do you think that beyond litigation or the existing form of litigation, there could be some alternate dispute resolution mechanisms for SEPs? And apart, in case you feel that there should be only litigation, any procedural amendments that you would suggest that could make litigation much more accessible or easier for SEPs? So this time I will start with Chitra.
Yeah, thank you, Aman. See, I think, just my personal view, not of my organization, I think we kind of hype up this dispute quite a bit, right? What do we normally do when we have a dispute of any kind, leave alone the SCP dispute? We sit together and discuss it like normal human beings and come out with a solution that works out. So I think there's a kind of a perception that MNCs, so right now MNCs have the bulk of the patent, the way it has evolved organically. They had definitely had a first mover advantage. They've had access to the capabilities, and they built the technologies and they built the ecosystem that's needed for SEPs. That does not mean that Indian companies or anybody believes that they cannot get there. That's not the truth. The truth is that I think we need to be having a balanced view that whatever is happening today with some of the bigger players having the bulk of the patents, over time we will have Indian companies, as so many other people mentioned, that when you are having focused efforts, when you're having solutions that meet global requirement, it is very likely that you will come up with technologies that are also the world leading SEPs in that case. So the question is that why do we then have so much of gap between the licensor and licensee? It's like a regular dispute. What typically happens in the court is sometimes we go to the court, there is no, we send out a notice letter, we are expected to send out a notice letter. Now a normal person would say, okay, let me talk to you about it. The fact is that it's not like the MNCs are here there to eat you up. No, that's not the case. In fact, every licensor wants the licensee to succeed because it's like a win-win. You make money, we also support you to make more money, and you also pay us the royalties. It works both ways, and that's how any licensing ecosystem should work. Doesn't matter who's on which side. But what typically happens in the normal situation is if you have parties who do not want to engage in good faith negotiations, we have no option other than going to the court, because as you all know, there's a lot of expenses that goes into R&D. There's a lot of people, man-hour, technologies, years, expenses for patent prosecution, all of it, that has to be gotten back because that goes back into research. That's typically what really happens. So when you have parties which are not, willing to talk to you, then that's the only thing. But of course, if we have a reasonable party on the other side who's willing to talk and negotiate, like how normal human beings should resolve a dispute, it's very much possible that you can have an ADR mechanism or a mediation. But that's the only situation where, you have, of course, subject to, because ADR cannot give an injunction, for example. For certain aspects, we have to go to the court. But when there are situations where there's a pre-existing contractual obligation, for example, you can go for ADR kind of mechanism, which is maybe more faster, it is more reliable, there's more confidentiality involved. There are a lot of other aspects to it. So I think, I think we need to break that myth that, there is a company out there trying to get you out of business. It is so far from the truth, because it doesn't help anyone when the other party who's going to pay royalties goes out of business. It is not a conducive work environment either, nor economically, nor any other way. So that is just my stake, and yeah.
Thank you, Chitra. I think the biggest takeaway from what Chitra has said is that the relationship between implementers and SEP holders is a symbiotic relationship. SEP holders want implementers to do well so that SEP holders do well. Now I would move on to Mr. Ashutosh Kumar, who has an experience of a hell lot of SEP litigations. Now, does he want anything to change?
No, I agree with Chitra that there is certain hype, because the fact of the matter is that 70% of FRAND licenses are executed without any litigation. So we're talking about 30%, right? Now, having said that, I'll agree that there is some problem, especially a problem of delay when it comes to litigation. So Justice Bansal is right that we should look for alternative dispute resolution mechanism. Now there are two popular method of alternate ADRs. One is mediation, one is arbitration. When it comes to SEP, mediation is, to be very frank, is a relevant exercise, because before SEP litigation starts, both the parties had sufficient amount of time of negotiation history spent between them. So they have negotiated, they have talked to each other, and certainly they are not able to resolve on their own. That's why they have chosen for litigation. Now the only other option apart from litigation is left is about ADR. Abroad, we have seen that there are some success stories. There are certain companies who have successfully conducted arbitration and resolved their SEP and FRAND dispute. In India, there is some legal problem in it, especially when it comes to the issue of validity. Because as an implementer always wants to test validity of few of the asserted patents. That's important from their point of view. And now the law in India, which we have, especially after the Supreme Court judgment in Booz Allen and Vidya Drolia, that as far as the issue of validity is concerned, the arbitral tribunal won't have a jurisdiction. So if any SEP and FRAND arbitration is taking place pursuant or governed by Indian law, then the arbitral tribunal will face a problem when it comes to the issue of validity. And then if we'll see from the point of an implementer, then they will lose one of their argument. So suppose if the Supreme Court can clarify that the reason why the Supreme Court said that the issue of validity cannot be looked in because it's a finding in right in rem. So arbitral tribunal generally does not have a jurisdiction to rule on the aspect of right in rem. However, if Supreme Court clarify that any finding by arbitral tribunal on the issue of validity will only be binding between the parties, it won't be a finding in right in rem. So that I think that can then make it possible for Indian companies also to choose for arbitration when it comes to SEP and FRAND litigation. As far as the question of making any changes, there was an issue of interim relief in SEP litigation, the delay in that. Fortunately, this year we have a judgment by Delhi High Court in Dolby versus Lava, where the court clarified that what should be the legal threshold or test for passing any kind of a pro tem order. You don't have to go into too much detail of validity, essentiality and infringement. Basically, you have to see the conduct of parties and then who has complied with the FRAND protocol or not, and then pass a pro tem order. The other difficulty which we are facing, and I believe Chitra will agree with that, is the execution of decree. In this country, so far we have 3 post-FRAND decree. And one decree SEP owner is trying to execute for past 6 years. So that's, I think, the change which we can make in law is to repeal Order 21 from CPC, because that's the most lengthiest code provision in our civil procedure code, and it's unnecessary in today's time. Decree can be executed within a week. We can learn from Western jurisdiction as well. So I'll say that there is some scope for change when it comes to execution of decree.
So basically, Mr. Kumar is saying, let us remove execution.
No, execution should be there. Remove the process.
Yes, the process for execution of a decree. So
make it faster.
Yes, that certainly needs to be faster, because as we as a country are trying to have ease of doing business, so ease of doing business, an important component of that is also ease of implementing litigation outcomes. If our own country's litigation outcomes are not implemented in India, how can we expect that litigation outcomes of India can be implemented in other countries? So with this slight segue that I wanted to give, I will move to Mr. Ranjan for his opinion on what could be changing in SEP litigation or ADR mechanisms.
Thank you, Aman. I think Ashutosh has pretty much covered it. Yes, I mean, the alternate dispute resolution is a good mechanism, because ultimately SEP litigation is about negotiation and meeting of the minds. So it is important. There are 3 mechanisms: arbitration, mediation, and conciliation is also another mechanism, which is less used, but in my view, that is very important mechanism that can be tried out in India. So arbitration has its own problem, and what I feel is, before going to arbitration in country like India, there has to be a mature reflection between the parties that yes, we should arbitrate, because the reason is the arbitrability of the subject matter. You cannot arbitrate anything. Arbitration can only happen in personam rights, not in rem rights. Now the questions like whether a patent is essential to the standard or it is valid or not, these are in rem questions. It generally affects everyone. In rem means it affects everyone. In personam means it affects the party who is before the court, right? So these questions are in rem question, and these are not arbitrable, because most of the time arbitration has its own rules and procedures of confidentiality, and when in rem rights are affected, it has to be published. It has to be there in the society that yes, public, your rights are affected this way, and therefore, and that's the reason in rem rights are not arbitrated. So when I say that there has to be a mature reflection, the parties will have to understand that, if it's just about the rates, let's go to arbitration. Let's just get rid of the defenses of validity and the essentiality. If ultimately you have to come to rates, then why to fight for 3 years, 4 years, 5 years? So that's the reason at the start of it I said that it has to be about the mature reflection. Party really have to be mature. That yes, it happened in Nokia, Amazon, I guess, and one more case, Philips. I think they went into arbitration. But before going to arbitration, they decided, both the parties, I think Ericsson Lenovo was the case. They decided that, we are waiving off other defenses, we are not challenging essentiality, we are not challenging validity, only dispute is FRAND, so just get rid of this dispute and let's take the arbitration. So this kind of maturity has to come in India to really go to arbitration. As far as mediation is concerned, I will not discount that method of ADR like Ashutosh did. So I'm in slight disagreement with Ashutosh said. Sometimes what happened, and I have seen in my SEP litigation experience, that the party, they don't come to table at all. There is one-sided correspondence and they never come to table. At least mediation can make that happen. You never know, So again, this is again about what parties are thinking, how mature parties are, what probably are they aware of the consequences that lies at the end of the litigation. Some parties don't, right? So mediation is also kind of process which can at least give an opportunity. But yes, I agree. The most of it, when negotiation has actively happened before coming to court, the most of it has already happened. So in some cases, probably mediation can be one of the options. And ultimately, it's not the advocates, but the parties who will have to decide whether they want to go to mediation or not. I have seen parties who have said that we might want to go to mediation. In India, it has happened. Even before the commencement of Section 12A of the Commercial Codes Act, it was there. So some parties have gone to mediation. Now, third is the conciliation. The difference between mediation and conciliation is the conciliator is much more active. So mediator merely facilitates, you please talk, you just remain silent. You please talk, you remain silent. Conciliation is a process wherein the conciliator is between the parties and he actually participates in the discussion. So that leads to the conclusion that, the conciliator should have some kind of knowledge about SCPs. So this is the challenge, that when we go to conciliation, there is an active participation which might lead to the resolution of dispute. But then we have to see, do we have resources, that kind of resources? Who will sit as a conciliator, right? So that is a challenge that is before us. So in overall, my view is ADR is a good option, but India is probably not ready at this stage. I'm not just blaming any one of the parties, it's about both the parties. They really have to understand. It is probably also about the market. The Indian market is such a big market that probably both the parties do not budge and they ultimately fight the complete litigation. But it can be one of the way out. Now, what changes I would like to propose? I think changes were there when Commercial Codes Act was enacted, but we defeated it. So, for example, I remember there is one provision which maintains the timeline between the final arguments and the end of the trial. Probably it was 6 months or something in CPC. I don't remember right now, but it never happened. When we go to Supreme Court to enforce that, Supreme Court does nothing. That it is discretion of the judge. So both the defense tactic will have to be removed, and serious players would do that. And those who are not serious players, they might delay the litigation a bit, but then they will have to face the consequences, as we have seen in Ericsson Lava case. So these are my thoughts about. I hope I have covered everything.
Yes, okay. I think Mr. Ranjan has not just covered everything, but also for the audience who may not be informed as to what exactly are these jargons of arbitration, mediation, conciliation, he has also informed us all. Of course, I personally know that Mr. Ranjan is about to become Dr. Ranjan soon, so naturally. So now with that, I would actually move to Miss Julian George, who perhaps has one of the biggest experiences of ADR in SEP disputes, Because I remember once in court there was, I think, the case of LG versus Vivo, in which from what I recall, there were some 80 odd sittings of mediation that happened, and then the matter came to court. So with that information, I would leave the floor to Ms. Julian George.
Thank you so much. So I have been in the SEP space since 2016, right? And I feel that this problem cannot be solved by one particular forum. I feel the SEP problem is such a dynamic issue, such a complicated issue, that it needs all stakeholders to be involved to really resolve it, and then only there will be an expediting of these issues. Because if you see, so the solution I am proposing is not litigation versus, arbitration or mediation or conciliation. I am saying that the standard setting organizations need to play a more proactive role. Setting the standard alone is not enough anymore, because you see, in every technology domain, there are improvements made, right? There's 2G, 3G, 4G, 5G, now 6G is coming. But all of these technologies are based on innovations that have happened much earlier. And what they are doing is incremental improvements, right? Then these incremental improvements versus innovation has to be identified by the standard setting organization in their technical document itself. That will help the court in understanding if someone is mapping to a particular portion of the standard, is it innovative or is it incremental? Because like today we have been discussing, all of us have been discussing that, we need to have good quality of patterns. But what does it mean on the ground? If the speed of our connectivity is good and it becomes better by 10%, is that innovation or is that incremental growth? And if it is incremental growth, what should be the economics attached to that? So SSOs need to play that role. Secondly, I feel that, because we have government bodies also participating at this event, if today I decide to sell a mobile phone, and like, Mr. Mittal from TDSI was saying, there are 500 participants in a room. So there are potential 500 people who will reach out to me for a license, right? So I do not know ultimately what is my total royalty burden that I'll have to bear on my phone. And this has technologies which are not standardized either. Some are standardized, of course, which is connectivity, Wi-Fi, all those technologies. But there are a lot of non-SEPs also in a phone. So while with non-SEPs, I'll have clarity that, okay, I've taken this product from this particular person, so I need to indemnify that person, or I need to get all those warranties from him. I don't get that opportunity with an SEP. So the government should really come in and have an idea on what that upper limit will be, so that I can take that into consideration while I sell my phones, right? And if the government is involved, obviously the consumer will not suffer. Because if right now it's left to private parties to decide what that upper limit is, then this royalty burden is carried forward to the consumer in the end. We are seeing right now imposing tariffs is the trend. But who is suffering? Because of all these tariffs, it's the people. Because when they are going to be buying the product, they'll have to bear the brunt of that tariff, right? It becomes very difficult for them. So that's where the government needs to come in. From a judicial perspective, there needs to be more judges. Our judges are very overburdened. An SEP matter is very, very technical. In a litigation, minimum there will be 3 to 5 patents asserted. Each patent very complex. Just to understand it will take at least 5-6 hearings if done back to back, right? And a judge on a daily basis hears around 50 matters. That's not an easy feat at all. So while we expect a lot from our judges, we need to equip them to be able to deliver. So we need more judges. We need adoption a lot of standardized technology within the judicial framework to expedite the hearings, to expedite the evidence. And while we have a culture of recording evidence outside of court, I believe it will get more expedited if the judge deciding the matter is hearing the trial as well. It's a lot to ask again of the judges because they are overburdened already. So it comes back to we need more judges. And then if there are early disclosures made on very, very crucial issues of FRAND, many disputes I've seen have got resolved without any interim reliefs being put by the court, only because the court insisted that, Mr. SEP owner, you need to disclose all your comparables. Ultimately, what this matter is about, licensing, is about what is the money to be paid. I don't think anyone is seeing an SEP owner as a big bad wolf. That's not the thing. But the concern is there that, okay, if I pay this SEP owner for 10 patents, I pay 20 rupees. Then another person with 30 patents will ask for more. And the royalty stacking will add up at some point. So earlier the disclosures about what my competitors are paying, that clarity would certainly resolve these disputes a lot faster. So these are my multi-pronged approach to this issue.
Yes. So we've got quite an insight from Julian in respect of what should be done. But something that I would echo my agreement with in 100%, 200% manner is that we definitely need more judges. In fact, before I got accustomed with the judiciary, even I had that notion that perhaps in India judges don't do work. But then reality did bite, and my time away from the office became inexistent. So yes, definitely. Judges, we definitely need more of them, particularly at efficient venues such as the Delhi High Court, which does perhaps one of the best work in terms of the commercial disputes. With this in mind, we do have Eric. So Eric, could you give from a global perspective as to or some insights from global best practices as to what can be improved so in India so that it can become an attractive neutral venue for global SEP dispute resolution?
Oh, that's a difficult question to answer. I don't think there's really any place that's an attractive venue for global SEP dispute resolution right now. The UK for a while was interesting for implementers, then it was interesting for SEP holders. We don't know what's going to happen in China. Insofar as India, it's really difficult to say. I think more judges. I'm not a lawyer. I see litigation as a failure of negotiation. So my approach is always try to avoid litigation. And honestly spoken, I see very few litigated results that could not be achieved by the parties through sort of good faith negotiation. You talk about alternative dispute resolution. I mean, the most recent one we have is Samsung and InterDigital. Samsung is very unhappy with the result of that arbitration. InterDigital is very happy. And my takeaway from that is that Samsung could have got a better deal by avoiding that and by sitting down and negotiating. InterDigital Lenovo, same thing. InterDigital decided to litigate that case, and I think they lost. I think they lost badly against Lenovo. They could have negotiated. Lenovo could have negotiated a deal that would have been acceptable to InterDigital without the litigation. And that's kind of what I see, is that litigation is a way to force parties that are genuinely unwilling to come to an agreement to an agreement. And my way of thinking is that you should come into negotiation with the idea, I have to make an agreement. I'm going to make the most favorable agreement I can. And what you see is SEP holders are very flexible. SEP holders are willing to accept far less in an agreement than they put on the table initially. And it's up for sort of clever negotiators to see that and to work with that and try to avoid litigation and set sort of benchmark rates outside of litigation. And then those become the comparables that are used in other litigations. So that doesn't really answer your question very much, but I don't see litigation as a way to resolve these problems at the end of the day. I think negotiation is always the preferred route.
So there you have it. We have some guidance coming in from Eric that perhaps you should not litigate, but we would encourage you to litigate because we'd be, that's our bread and butter. And
on that, I think every panel member will agree, except for the non-litigators.
Completely agree.
So I just have, what I'll do is, to make it a more interactive discussion, we'll actually have a round of questions just now, even though we have a open house right after the session. But just before that, Ms. George mentioned about some sort of government intervention in respect of rate determination or total royalty burden. Could you just clarify a bit on that aspect?
Yes. So, for example, if there is cellular technologies, right? And with every generation, there's a new technology that's coming in that space. There's improvements being made. If the government at least has a ceiling, because if you saw today, everybody must have said, FRAND is a range, FRAND is a range, FRAND is a range. You must have heard that term being used consistently. But what is that range? Nobody has any clarity on. And a range should have some limits, right? And ideally, in a society where we need more competition, that range should be as small as possible. There needs to be an upper limit on what the kind of royalties that could be charged in a particular domain. And if there are governmental policies on what that upper limit could be, it would be a good boundary for the implementers to know what the burden is for them to carry, take that cost into account while marketing their products, and for the licensors also to evaluate how much they will be able to ask within that range. What is actually fair and reasonable? Because in the FRAND component, what is fair and reasonable depends on the value you have contributed to the standard. Today we heard a lot of discussion about a lot of money being spent on R&D, and because there is so much money spent on R&D, that money needs to be realized. But that's not how an SEP has to be valued. An SEP has to be valued on actual contribution made to the standard. Whether your R&D was ultimately accepted by the standard setting body as a technical solution. Most of the time, you may have done a lot of R&D, but it may not have translated in an adoption. Then keeping that as a barometer, I don't think is good for a competition enabling market, which is what the government always looks for in a policy decision.
Would any of the panel members want to? Yes, I think we'll go with Ms. Iyer
I
first.
would have expected this, but I'll have to say something, When you go and sit in somebody's rented house, the government doesn't intervene. It's your decision that you go and sit there without paying the rent. Okay? When you're talking about SCP, suddenly you want government to come and start becoming the godfather telling you what to do. See, when a party is coming to you to negotiate, you don't respond. What does that show? That you are not interested in discussing any commercial. Very, very clear. So we'll have to see not this as a piecemeal, but have to see generally as a conduct. I think in my total humility, I say that you cannot look at this as a piecemeal. When you're talking about two companies over here, which are talking a commercial agreement purely between these two parties, you agree or disagree, you don't agree, go to the court. What does the government have to do in every single intervention that's there over here? I'm not saying this because now I'm on one side of the fence. I'm just saying for both sides of the fence. The moment you have a third party, you have two cats fighting and a monkey in between. I'm not saying being disrespectful to anybody here. I'm just saying that this is a purely commercial discussion between two companies. What are you going to negotiate? If you had any questions, if you had responded during negotiations, all those questions would have been answered adequately and to your satisfaction. If you don't choose to do that, you go back and say that no, I will not agree with you, I will not talk to you, I will not respond to you. And then once one fine day you say, oh, I want government to come and tell me what has to be done here. That seems so unfair to me at so many levels. Please bear in mind that the companies who are operating in India, for example, also have a lot of other things going on. It's not just one aspect of licensing involved here. Where all do you want the government to intervene, and to what extent, and to what technologies? I think it's being highly unreasonable because this is as Ashutosh mentioned, right in personam or right in rem. What is this? So I'll just stop over there and let others.
I agree with Chitra, that I'm also not the proponent of government intervention in each everything. But government can intervene if once they have crystallized the problem. First, you need to identify the problem. Now, what Julian mentioned about the royalty burden is that the famous problem of royalty stacking, if I'm not wrong. Now, I think it's high time that we start doing the carbon dating of this issue. Royalty burden. I am hearing this since my college days at least. This all started with one theoretical article written by two professors, Mark Lambley and Carl Schurpue. It's a theoretical problem they highlighted. 2013, the Competition Commission of India in this country said that, yes, there is a royalty stacking problem. And the competition in telecom industry in India will be hampered. We are in 2025. 6 more players have entered into the market. India is now the second largest mobile phone market in the world. Indian market has become much more competitive. So I'll say that this empirical data shows that this theoretical problem or this theory of royalty stacking remains a theory. So for theory, government should not intervene.
In respect of royalty stacking, I just go back to the judgment in Lava International versus TLM Ericsson. The question of royalty stacking was decided quite easily. How will there be a royalty stack when there is not even one license being taken? So, Mr. Vivek Ranjan, would you...
we are getting very fact specific. When a policy is decided, it's not decided on a case-to-case basis. Of course, there have been instances where implementers have not responded and have not acted diligently, for sure. That there have been such instances. But when a policy is made, it's made for all. So it's taking into account those licensees also who would be diligent in responding. And there have been such instances. And there have been licenses taken without litigation, where both parties could resolve this issue. But if there is at least an idea, because even SEP owners do not, I think, consult each other always while setting the rate for their portfolio. So that is the concern, that maybe we don't need the government. Maybe we only need all the stakeholders to be involved and reach a consensus on what that figure should be.
So consensus building is the name of the game that has been put forth. So in order to make it a more interactive panel, particularly because this is the post-lunch panel, we would at this stage itself ask if there are any questions from the audience.
Yeah.
So,
Hi, very good afternoon.
Yes, ma'am, could you just introduce yourself before
I'm
asking?
Dr. Vishaka. As the CRISP Innovation Law and Policy Fellow at BITS Law School, Mumbai.
I would just request everyone to ask a question straight away, not to give an extended backstory before the question. That's my only request.
Sure. As I said, I'm the research fellow at BITS Law School, with my research focusing on gender gaps in Indian patent commercialization. I would like to ask, women innovators and startups are already underrepresented in patents and even fewer make into commercialization and SEPs. Across the SEP system, whether in development, licensing or enforcement, what concrete steps can be taken to make the system more inclusive and accessible for women inventors and entrepreneurs in India? Thank you.
I'll take one more question before we... So, yes, the gentleman.
Sir, I have 2-3 points to say.
Sir, could you please limit yourself to a question?
In brief, within 1 minute I will say everything. We are talking about the litigation, more litigation, how to control or how to take it down. But the question is, Arbitration and Conciliation Act still under draft, DPDP still under draft, draft patent amendment rules still under draft. So when the regulation, there is no regulation, no policy, no this thing, what to follow and how to follow. Just recently, U.S. Concerned Trade Relations, USTR, Special Report 2025 placed India on the priority watch list, reflecting U.S. concerns about India's IPR enforcement, loose enforcements, you can say, very serious matter. Now, we are talking about the,
Sir, I think we've got two questions from you. So, I would first ask the panelists if we can take the question on women innovators, and is there a reflection that perhaps women innovators are not able to become part of patents on SEPs? So just for the audience's information, so there have been certain schemes to encourage women inventors in India in general, but women inventors for SEPs, this is something where even I would plead ignorance to and hope to be enlightened by the panel.
I'm sure we have a lot of women fighting for SCPs for sure. In my office, and my previous boss as well, Chitra is here, Julian is here, so that is there for sure. Yeah, I'm leaving
As
the
far as the
question.
litigation is concerned, certainly women are playing a quite important role, and two panelists are, live example of that.
I think I'll just answer that in a more, data. I don't have the exact numbers, but we have seen that in organizations per se, right? It's a ratio thing right from the employment onwards, which is changing a lot with time. But you see, the number of people, women choosing science, for example, it starts from there. But I think once you're in the company, or once you're in, at least for the corporate, I can talk about that. I don't see any unfair deal that they get. They're usually very well represented, and they do come up with a lot of great invention as well. But then on the commercialization side also, I think, how much do these women want to really be a part of it? It's more about a personality thing, because it's not really about gender, I think, after that point. It's more about aptitude of, doing one thing versus the other. It's more about that. So I don't know if I answered the question.
Thank
I
you,
agree
ma'am.
with Chitra that, idea ko salam, right? Patent is all about inventions. So once you have a brilliant idea, whether you are male or female, it really doesn't matter. It gets that recognition. Someone in the room will notice that, yes, your idea is good, what you're saying is good. Only thing maybe we as a society could do is maybe encourage those voices, because to have women speak for themselves sometimes becomes a bit of a hindrance. They censor themselves by personality. They try to think that, okay, I want to make the point only if it's absolutely perfect. So if the people in the room could encourage the women to voice their ideas and then go for it and give them that support, that you go for it, we will back you, and your patents will get recognized, I think there will be more of such participation happening there.
Yeah, and there are quite a lot of startups run by women, and I'm
Yes.
sure the day those startups will become success story, we'll see more and more women innovators who are also at the forefront of commercialization of IP.
Awareness regarding SAP also matters a lot. That is also lacking.
You're absolutely right.
With the women inventors, because I believe that, because since I am taking up the research study, I strongly believe that is where the catch is, and that is the need of the heart now. Thank you so much.
No, but you also see the problem is not that women are not in business. That is not the problem. It may be problem of certain part of the India. Women are in business. There are a lot of startup, as Ashutosh mentioned. But again, I come to that argument that where the technical research is happening. The first question we have to ask is, how many students are there who is pursuing research in electronics, computer science engineering, or mechanical engineering, etc. I don't see personally a lot of women in research. So unless we do not go for the grassroots problem, we will not come to the problem which is at the upper part of the triangle.
Absolutely agreed,
So
sir.
that is the main problem, and then it will automatically will be reflected in the SCP front or any other front for that matter.
Thank you so much.
Before we continue with the discussion, I would like to formally welcome Professor Unnat Pandit to the gathering. Professor Unnat Pandit is the Controller General for Patents, Trademarks, Designs and Copyrights in India. Thank you, sir, for joining us for this session. There was, before I enter into sir's question that had been just asked previously, in respect of the USTR report, I would like to respond on behalf of the panel, if I may be permitted to do so. The USTR report has been labeling India, putting it in the priority watch list since time memorial. At least most of us working on IP enforcement in India would thoroughly disagree with this. It is just a notion that India is not enforcing IP rights. India is perhaps more adept at enforcing intellectual property rights than jurisdictions such as the US. If you see, we do cross-border recognition of trademarks much better than the US. So this is, and in fact, this is one of the views that I have been personally canvassing, that Perhaps if the USTR reports are to be considered, they would label the US Supreme Court in the priority watch list, because
the way it's functioning, they should.
so, and led by the Office of the Controller General of Patents, we are granting more than 1 lakh patents every year. The number of filings are increasing, and people will not file patents if they'll not be
I
enforced.
think it's high time that we should stop bothering about
Yeah,
USTR
yeah.
report, because
Yes. So, yeah.
This is the reason the litigation cases are going up. Now the question is this a civil case or the criminal case? That is also not clear, or both.
So, in respect of clarity between civil and commercial, civil and criminal, there is to a large extent.
so far me and Julian have ensured that this remains a civil case.
And the credit for that goes fully to you, Ashutosh, because you're the plaintiff.
Yeah, I don't know. After this, maybe it turn into a criminal case, but so far it's a civil case only.
But yes. But thank you for both the questions. We'll just take one more question, considering it has been a good interactive experience. We would take another question by the lady.
Thank you, sir. I am an LLM student at Indian Law Institute. My question pertains to, as we mentioned, that arbitration should be a step which is a well thought step by both the parties. My question then pertains that how should we place both the parties at the same pedestal in an arbitration? For instance, if one is an MSME or startup and other is an industry leader, then it there are more chances that the arbitration does not succeed. How do we go about it then?
I think I'll in your question reply, I'll also address a part of what sir has asked. So, see, arbitration or mediation or conciliation, all these processes, it require consent of parties, right? So, first of all, there has to be consent between the parties. The problem is, sometimes some jurisdiction, they want to impose that kind of, coercive imposition of consent. That should not be there. So, I'm sorry, but I am completely against the governmental regulation of SEPs. The reason is that ultimately FRAND is a contract. And in any contract, it is very important that the two parties who are contract has complete liberty to contract the way they want to, until unless it is, against the law. So that kind of intervention should not be there. So again, how these two parties will come to table is entirely between them. That is first. Secondly, your question is also qualified qua MSME. Now again, this is again a problem. Now sometimes we think a scenario which is actually not happening, but we keep telling ourselves and we keep telling public, and there is this narration that builds on that, MSME and a big tech company, they are coming into arbitration, how it will succeed? It is not happening. It is not happening. This question is completely academic. As in my previous panel, Nishant also told, the SEP owners are not behind startups and MSME. It doesn't make sense to them. Ashutosh is an expensive lawyer. Julian is an expensive lawyer. They charge in per hour, So, I mean...
My rates are FRAND.
Yeah. You tell me.
I doubt there will be an agreement on that.
No, I agree with Vivek that it's based the question. I'll say it's though because you're LLM student, you are supposed to ask academic question as well, and it's based on the premise that MSME, but it's also based on the premise that MSME is unrepresented in the arbitration proceeding. That's not the case. No. First, as Vivek mentioned, that commercially it won't make sense for SEP owner to spend that kind of a litigation cost and negotiation, because negotiation also entail a transaction cost when you negotiate with someone. It doesn't make commercially sense for you to go after a small player and entail that kind of a transaction cost and then litigation cost. Plus, even if you're there, if suppose some SEP owner decided to go after some SME, there are legal representation available for them. So it's not that they will be completely unrepresented in those kind of a litigation.
Yeah, I'll
In fact,
just add one more thing. See, when in the real life situation, it's very different. In fact, a lot of the royalties for the SMEs are heavily discounted. In fact, we say you don't even pay us for some time till you are able to, get your business on track. So what is being projected and what is the actual is not very, it's as Ashutosh said, it's a purely academic question. In reality, it's not that way. It is very, very accommodating of, the other party's ability to pay and when they want to pay and what is the current state of business, how much money are they making. Everything is considered when we, go forward.
No, there are, two sides to a coin. Of course, there is this perspective, but there is also the other perspective that, and this has been held in decisions in the UK courts, they have found that, there are two types of licenses, right? There are running royalty rates and there are lump sum rates. And it's often been found by the court based on evidence that running royalty rates are usually charged from smaller entities and they are paying much higher than the effective rate at which lump sum rates are formulated. So I don't think it can be said that it's not happening at all. It's a very party-to-party, fact-centric issue. We can't completely close our eyes to such instances as well.
Perhaps
See,
you can highlight that.
Yeah.
In my view, there's another aspect to it that I wanted to mention. See, again, let's assume a scenario where MSME is, paying the royalty, right? And again, you're an LLM student, and very good question from you, So it probably will clear.
You got the panel activated.
Yeah, you got a panel activated, and probably a lot of things we would say that will make things clear. So let's assume that there's a party which is charging to MSME. Let's assume that for a moment. MSME is paying that, startups are paying royalty. Since they are startups and MSME, if something, if they are paying an additional royalty cost to their devices, while this big techs, mobile manufacturer, etc., they are able to fight it before the court with a fraction of cost, while MSME is paying royalty. Now you tell me, who is in disadvantaged position? If MSME is paying, and who is responsible for this? Who is creating competition for startups? It is big tech which is creating competition for startups, because MSMEs and startups are not able to sell their devices without royalty, but they can hold out before the court. And so this perception that there is a lot of hold up problem, in practicality, even if we assume that it is not a hold up problem, it is a hold out problem, wherein MSME is paying, small industries are paying, and big industries are going before the court and able to stop that royalty for a while, till at least when interim injunctions are decided. So let's just clarify, in your understanding before the schools as well. You really
I
have
just
to
want to add one thing. I think ultimately it's boiled down to everything what Nitin mentioned in the morning, that as a licensor, it's in their interest that their licensee thrives in the market, because that's their source of revenue. Especially when you're in the technology creation market, you're investing into technology creation. The only way you can commercialize it by licensing, right? And if you put your licensing fees at such a position where the licensee will go out of the business, you're killing your own business. So think from that point of view, why a licensor will ask a licensee an amount which will make licensee's business non-feasible, and consequently will also harm the business interest of the licensor.
So with this,
I think I'll come more to this, only, because I have a lot to say, but then, we have limited time.
Yes. So I think with this very engaging discussion that we've had midway through the session, I would come to the next part of our discussion, which we'll of course have for a limited period of time, which would be on the India-focused anchor questions. So we'll probably only have time for one of them, but this is something that I thought we should definitely take. So in almost all SEP litigations, the doctrine of exhaustion as a defense is taken. So from everyone's experiences in law and technology, what should be the evidences or showing that could actually make such a defense viable? And for this round, I will start with Mr. Eric Stasiak in the beginning, considering we have slightly involved him a little less, so I wouldn't want to have a non-Fran declaration on me. Eric, over to you.
Thank you. Yeah, I guess this is The idea of exhaustion is the idea that, hey, I've bought this chipset from somebody, and so I've already acquired all the licenses that I need. And I think in a lot of situations that's true, but in when we talk about 3GPP standards in particular, no SEP holder licenses chipsets at the chipset level. All licensing is done at the end user device level. So this is how they've avoided exhaustion. Even Qualcomm, if you buy a chip from Qualcomm, you have to first take a license agreement from Qualcomm in order to buy the chip from them, because Qualcomm is aware that if they sell you the chip, there may be an exhaustion issue. So in order to ensure that they get their license revenue, you have to sign a license agreement before you buy chips from Qualcomm. I think that's the general approach most of the major SEP holders have, that exhaustion doesn't occur upstream. It happens at the end user device. And so it's a defense that's often raised, but it's one that's quickly taken off the table.
Yes. So there you have it. Eric gives his viewpoint on exhaustion. So considering that we've taken the right and the left, this time I would want to start this round from Julian, considering she is not yet exhausted by taking the exhaustion defense. So over to you, Julian. What do you think can be the credible evidences which could lead to a successful exhaustion defense?
So exhaustion is a matter of policy, right? Like if you compare Indian policy with UK policy, UK policy only exercises national exhaustion, while India, as a matter of policy, has adopted international exhaustion. What does that mean? That means that once you are compensated for your patent or for your IP, then you cannot ask for further compensation down the stream. Just so that I can clarify this, what is international exhaustion to all our participants here? Now here, why do we have this concern? Because when a final product reaches you, there are so many people involved along the way in the supply chain, right? And Manveen was using the word implementer, and he was insisting that that word should be used instead of licensee. But always the licensee is not the implementer. You know, it is accepted within the industry that this technology is coming in through the chipset. So it's not actually incorporated within the device by the person who is ultimately selling the device, right? An OEM. So the chipset ultimately is the one bearing the technology. Ultimately, what is put in that technology is only known to the person making that chipset. So that's where the gap is happening, where there is a disconnect in the OEM selling the product, not knowing exactly what is the nature of technology put in it. You know, in the end of the day, he's just saying, give me a chipset that has 5G capability. That's it. And he's provided that. He takes a license from the chipset manufacturer. Over and above that, whether licenses are required or not is a question that a lot of debate has gone on, you know, in before the courts. And what the Indian court has held ultimately is, you know, our personal views, I don't think matter when there is a decision already in place, right? So as per that decision, the court has said that the chipset manufacturer should completely provide you an indemnity, saying that any third-party rights claimed against this chipset, I will indemnify you. If there is such a particular undertaking given by chipset manufacturer, then the courts have held, yes, there would be exhaustion, right? But if there is no such undertaking given by the chipset manufacturer, then exhaustion, whether it would work or not, I would like to argue is still arguable. As a defendant's counsel, I always try to make all points arguable, right? That's my job. But as of now, the law is that the chipset manufacturer has to give you that kind of indemnity for you to be able to claim exhaustion.
All right. So, Mr. Ranjan, quickly on exhaustion.
Yes, so I think exhaustion is usually brought by the defense counsel, and she has already explained. But just to make you clear in a very simple terms, you know, sometimes back I saw a Swift with the Suzuki logo and two wings coming out of that, and it was looking like a Mini Cooper, right? So yeah, so with a lot of other statements that I don't want to repeat. But then, yeah, the gentleman, the owner of the Swift, wanted to look like a Mini Cooper. And he could do that without any intervention of Mini Cooper, cause the moment he bought that Swift, that was exhausted. Right? Now, Mini Cooper cannot come and say that, why have you put my logo in a Swift? So, the moment a sale happens and an unconditional sale happens, it is deemed that all the IP associated with that article, not technology, that article is exhausted, right? So an owner or a patent owner cannot keep claiming right downstream. That first it claimed from Suzuki, then it went to that owner and said that you are using Mini Cooper logo, give me some royalty, whatever. So the moment a first sale happens, unconditionally, that exhaustion comes into picture. The evidence is, I think it is pretty clear, should be pretty clear by now. There has to be some evidence of the absolute unconditional sale of the article, that it was sold. We have to be very careful as a litigator that how the sale has been put in place. So the language might suggest it is a sale, but when we look behind the wheel, it is a license, and we lawyers do that. We are trained to do that. So it might look, it says sale, but it actually is a license. So we have to be careful. And otherwise also, it is a license, but it looks like a sale. So we have to be careful about that, and that evidence will have to be analyzed to really see exhaustion is there or not.
Thank you.
Sorry, in which case? The moment you have Swift, you can do anything. You can put Rolls-Royce logo, no problem.
I would just give a disclaimer. Please do not use this advice and put any logos on your cars. And Vivek is not indemnifying you. Neither is is FICCI or Acreer indemnifying you.
Yeah, about indemnity, just one thing I probably missed. Indemnity is something that it is claimed that when the article was sold to us, an indemnity clause was put to us, that if any harm comes to us, then the person who has sold it will indemnify it. That usually is taken as one of the, again, excuses in the litigation. In German courts, I have seen that the indemnity, they have held that indemnity has to come at the time of as a first defense, it should come. It should not come when the suit is being filed. So if you have some arguments related to indemnity, please put it during the stage of negotiation. Let the other side know about it, and then you come. When you are coming in before the court and then putting indemnity clause in picture, then it is a problem.
All right. With that, I will move to Chitra.
Yeah, without being repetitive, I'll just add to how do you actually circumvent the whole thing. You can probably have, if you want to show indemnity that you indemnified, you can just have authentic, validated, back-to-back agreements to prove that, or, documents, as Julian already mentioned, record of the payments, original receipts, and then clean hands. I mean, it's very important to come with clean hands and willingness to prove that, you're truly on saying what, able to prove what you're saying. And then, so we've had instances, of matters that are talking about parallel imports, talking about exhaustion, the receipts are all fabricated, they have wrong stamp, they are again, so it gets messier and messier once you start going on down to that path. I think it's important, okay, you have to prove something, let it be with legitimate documents, affidavits, what you want to say, be able to substantiate that. So, that's all.
Ashutosh?
The question is, what kind of evidence an implementer should bring to prove exhaustion? You can't hear me? You can hear me now? No, he's asking that question to a lawyer who is mostly represented as SCP owners. I have to be careful. I should not end up giving free legal advice to an implementer. But I'll only say what the law, as Julian mentioned, what the law states. So we have judgment of Erickson versus Lava by Justice Amit Bansal, and he has laid down a very clear test for exhaustion. The test is of clear and convincing evidence. Onus is on the implementer, and you have to bring some document which is clearly and can convince the court that there is exhaustion. Now, what is exhaustion? As Vivek mentioned, that this doctrine is based on the doctrine of first sale principle. That the patentee or IP owner has already made a first sale and recouped its reward or the investment from that IP protected product. So you have to bring that kind of evidence. Now, as far as the chipset argument is concerned, as Eric mentioned, that especially in the telecom industry and other industry where we have seen SEP issues, SEP owner, they don't license at the component level. So there is no question of first sale at that level. So,
right. So consider the defense of exhaustion will not be exhausted ever. It will always be a point of argument, but we still wait the day when an exhaustion defense is successful. It has been attempted right from the time of Strix versus Maharaja, which was a dispute in respect of a kettle. So from kettles to mobile phones, the exhaustion is still abated when it will be successful. I would once again move to open house questions, considering we can take some 8 minutes, so perhaps 2 to 3 questions. Questions to be brief, please. We'll have the gentleman at the back.
So basically, my question relates to the negotiation techniques which are being used
Yes.
between the parties when such SAP patents are under disputes. Can you put a highlight to that? What are the negotiations actually happen? And generally, what are the moot points you guys have trouble with? Especially in the Indian domain, please.
Yeah. So I think in the morning Nishant already covered, right? There are two types of licensing agreements. One is the pool, which has already got a lot of players in the for a particular technology. They already get together and then they are offering license via the pool. Or the other type of license is the bilateral, when you directly approach the other party. Sometimes there are technologies where, for certain reasons or whatever reasons, a pool could not be formed. For example, the cellular is one such example where for some certain reasons there was not a pool, the way we have for audio codec or we have for wireless technologies and some others. So in that case, the typical steps are already highlighted in Huawei ZTE, where there's the patent holder, because you hold a standard essential patent, you're obligated to tell the other party that you have such a patent, and when you find out somebody is using your technology, you send them a letter saying that, okay, I believe so and so, you're using these technologies and I believe that, let's have a discussion. It starts from there. Sometimes the parties come and they discuss, and then we're able to reach a situation about how much do they have to pay, how many devices and whatever. That's a part of the licensing discussion. And sometimes if it doesn't go through, then based on the parties' internal decisions or whatever, they may go to the court in that case. But if you ask specifically about licensing, yes, there are a lot of things. The other party will ask certain questions. They'll ask you to share certain information, and these parties sit and discuss together and come up with what seems reasonable in that instance.
Just a small follow-up. Does the position of dominance also come as a hindrance in those negotiations?
Well, it's subject to interpretation. See, the other party might feel you're in a dominant position, but I think everything is subject to how you're able to discuss with each other. You may have a perception, nobody can stop that, but you can seek clarification and ask answers to clarify that perception that you have.
and this issue of dominance, who is dominant, is also debatable.
Yes.
Someone who is already residing in your property and you are standing outside your property asking that person to vacate, who is in the dominant position at that time? The person who has already occupied your property, or you are who is screaming and shouting outside, please vacate?
Because a lot of government intervention is being
there is a issue of this issue of dominance is also debatable, and I'll suggest you to go and read Justice Burr's first instance judgment in Unwire Planet, where he alluded to this point, whether the SEP owners are really dominant, because the only way you can enforce your right by approaching the court, and we all know how long it takes there.
So, I'll tell you one more thing. I'll just add one more thing. See, what happens is, let's look at a hypothetical situation where you have 6 potential implementers. 5 of them have taken a royalty or paying royalties, and the 6th one does not want to pay at any cost. So what this situation does is it puts the other 5 people at an unfair disadvantage because they are paying up, and the last person doesn't want to pay up. So we have a lot of those situations as well.
Sir,
UK courts have actually determined a lot of FRAND rates in a lot of domains. And we did a study on this actually, and we presented it also to the court, that they ultimately what the judge decided was a FRAND rate was found to be 80% less than what the SEP owner was asking. In fact, you will find it interesting that there are very few domains in which two different courts have decided what is a FRAN rate. And that is Ericsson's portfolio, for example, where there is a US decision which has found a particular rate, and there's an 80% higher evaluation of that rate found to be FRAN in India. So it all depends really on the kind of evidence that is led. In negotiation stage, the guiding factor on how parties should conduct themselves is really Huawei versus ZTE. That decision has been unanimously accepted across jurisdictions, where the onus is first on the SEP owner to come and show their bona fides and show that what are the patents that they possess which are essential, and then give a FRAND offer. So there are two assessments that happen in these negotiations. One is a technical assessment that happens, where you technically evaluate whether the patent actually is an SEP or not. Because there is also a problem of over declaration. Obviously, even the UK courts have found this, that sometimes entities, to make it seem like they deserve a lot more royalties than what they can ask, over declare their patents to be SEPs. So that technical assessment happens, and then there is an economic evaluation of, okay, if a sample size is taken and technically evaluated and found to be an SEP, then what should be the value attributed to that? In that, there are two types of evaluation that is done. One is a comparable approach, where you look at third-party license agreements, right? And second is a top-down approach. Top-down approach objectively is the most fair approach, because it looks at the standard, it looks at all the people who have contributed to the standard, and then tries to evaluate the share of that particular SEP owner to that particular standard. So that is the kind of approach that is seen to make this kind of assessment. Both parties have to work in this evaluation, and in an ideal negotiation, if queries are answered by both sides and there is disclosure by both sides, certainly licenses agreements are executed.
Okay. I know that let's not have one question get the abuse of dominant position, but just as a matter of clarification to some things that Julian has mentioned, top-down method versus comparable licensing method, one can say that a top-down should be used, but ultimately it has been relegated to the place of a cross-check. Even in judgments by China, it has been relegated to a cross-check.
In
I don't
India,
think
in India, it is
relegated would be the
compared.
right word. It is basically used as a cross-check.
Cross-check.
So it is
And-
used as a methodology to check whether what is coming out of a comparable is valid or not. Because
yes.
it is to check whether the rate is actually fair and reasonable or not.
Actually, we
Comparables
can
help
say
in the
that it's one of the
non-discriminating
methods.
aspect.
Yeah, it is one of the methods.
Yes.
In India,
I-
the court has held that comparable license is it's a method to adjudicate on FRAND. And see, there is very important factor that we all miss. The top-down approach, the bottoms-up approach, all these are approach which are theoretical in nature. We have a theory, we have mathematics behind it, and we do that, right? When you see comparable license, it actually tells you that what market has decided for you. And that's the reason, in my view, and like Julian said, that personal view should not be overriding. So I'm just going by Delhi High Court.
I'm so
That's
glad.
the reason comparable licenses are the best way to.
No, but Delhi High Court has not rejected top-down approach. All that Delhi High Court said was no evidence for top-down was led in that matter.
Yes, I
So
think
that
we
is the
can.
reason why
Yes,
the court
I'm so
said
glad
that
the panel had been so
we
generous
can
for
go
my
with the
query.
top-down
we
approach.
can
That's what happens
rest
when
on
you
this,
invite
but there
lawyers
is
on the panel, right?
yes, but there is one clarification again that I would want to make is in respect of rate determinations on a similar portfolio by US and Indian courts. The caveat is that the US court, the original decision was, ultimately there was a settlement in that matter which was not disclosed. Whereas in India there was a
No,
post-trial determination and a
want to add,
quantification
clarify that
given.
point and not related to any specific
And we
case.
can just wrap up
Yeah.
in 2 minutes because I don't want the chits from the organizers.
Just want to add one point. We just wanted to clarify on that point of what UK court have done in some SEP cases, not specific to any case in India, but we have in India our own SEP litigation experience, and we have 3 post-trial judgment from Indian courts. And go and check what rates were offered at the beginning and what rates court has determined. It's either the same or the rates have been increased. The latest one by Justice Narula in the Phillips matter, the rates have been increased.
I just wanted to clarify 1 minute, Aman, on the over-declaration part. I think it may be not correct to assume that there is always over-declaration without understanding why does it happen. And because when the standard setting is happening, actually there are different technologies that are proposed. Everything is not adopted immediately. So there is a tendency that you don't know which way the SSO is going to go. And therefore there may be a perception of over-declaration. But it may be wrong to assume that this is the norm, right? Some companies may do it, some may not. Some institutes may do it, some may not, but to assume that there's always over-declaration may not be correct.
So at the end of the day, I do not want the chit, but it has come to me. But the chit is quite interesting. So I have actually been given the opportunity to take more questions, but with the small caveat that the questions could be also from the previous panel discussions, because our speakers are still here to answer them. So, but this will be the last two questions.
If you allow me to ask Mr.
Yeah, I believe, sir, we have taken 2-3 questions from you. So it'll we may have the gentleman over here, because otherwise I'll be labelled as unreasonable. I do not want to take that risk.
We can discuss this later. No problem, sir. I'll answer.
Hi, I'm Sanjeev from Conquer IP, part of Questel Group. So since you have already explained the top-down approach and you have explained the comparable license approach, and Mr. Nishant also mentioned availing services of third-party companies. So I want to ask, like, how do you see the contribution from third-party companies fitting into the scheme of things from government and in future policies? And how do you take that? Like, what is your opinion?
Anyone from the panel? Third-party companies.
I think technical assessments made by independent bodies would certainly help the court in arriving at a determination, because ultimately when evidence happens, what happens is it goes very in depth into the technical aspects. But at least for the interim stage, yes, if there are independent studies being done, either in favor of or against, however it works, and the court is able to then narrow down the questions it needs to understand. Because what happens, you must understand, when a technical problem is produced to the court, it's very difficult to formulate what is the question to be asked to narrow down where the divergence of view is. Because the divergence of view is on very limited aspects, So if the technology is 100, the divergence of view is only maybe 10 or 20% of that. So to understand that, narrow it down, these technical reports would be really helpful, I believe.
Okay. I believe that has been answered quite well, and all the panelists would agree that it serves as a tool. And the last question for the day. Okay. I think we have yes, in fact, I was looking for questions from this side. Okay, we have the gentleman at the back. Good.
Just look for the red light in your mic. It's right at your mouthpiece.
Just don't hold the mic.
Can I ask my question meanwhile? Is it okay?
Perhaps this is a use case for standardization for microphones.
Can I ask my question meanwhile?
Yes, please go ahead, but we will take your question.
Okay, so for startups which are operating in like industries which are upcoming, like solar, robotics, so what is the best approach? So as an engineer, we should have, what perspective we should build in order to have a stronghold? So to be honest, like I maybe learned a dozen of new terms today. So maybe it's a very broad question, but like just how we should align ourselves, because I think robotics is something that is upcoming, and going after these upcoming industries, maybe we can build a stronghold today.
So anyone from the panel would like to give a response in 30 to 45 seconds?
Although I'm not from the industry, I'm a litigator, but I know during this SAP litigation, in my experience, I've seen that Chinese company, they can be the role model. Like companies like Oppo, Vivo, now they built their own portfolio. It's not that they initially incurred the expensive R&D cost. What they did, they bought portfolios from other companies. So there are various patent holders who have patent in their portfolio, but they don't have a commercialization plan for that. So they are ready to let go of that portfolio, and the cost would be won't that much. So if you are in that kind of industry where the technology and the patent portfolio may help your business, so look for those kind of opportunity to build your own IP portfolio, especially the patent portfolio.
Yeah, if I can just add, maybe you can even consider collaboration with some established parties without divulging your own IP and losing your own proprietorship. Try to figure out how it is done and how can you scale up and how can you make it more widely implementable so that you get the support that you need while you can also fast forward your own development of your own technology.
Thank you.
Thank you to the panelists. Now we'll have the last question of the day. So if you could just ask your question.
Thank you so much for such a lively discussion. I feel we can listen you for hours now. And my question is...
Don't tempt us. Don't ever tell lawyers you can listen to them for hours. They will not stop.
And some of us teach also, like Chitra. So it is very tempting.
Vivek sir, you could be a very good teacher. And sir, my question is, it's also directed to Eric sir, if he is available. That in the last few years, especially in the last decade, we have seen some jurisdictions such as China, which has been using their judicial forums to decide FRAN rates which has been lowest in the world. And it has been the case in various MNCs, especially when it comes to the Shenzhen Code Forum. So, when it comes to Indian perspective, the Delhi High Court has taken a quite pro-IP stance, and it has also issued injunctions against companies such as Micromax, which many would argue that has hurt the smaller players when it comes to competition against Chinese players. So, for a growing economy like India, does this stronger IP protection is the right path, or we should lean towards a more protectionist approach that has obviously worked for the Chinese companies in the last decade?
Before Eric answers that question, just one small clarification again, that there was no injunction per se against Micromax. I am sure the counsel from Micromax...
There was an ex parte injunction. There was one ex parte injunction, and then there was an interim arrangement. So he is right that there was injunction at the start. But that trend has stopped now because courts have also realized that
the question is based on the premise that because of some orders, Micromax went out of the business. So just for your information, 2017, Micromax CEO Mr. Rahul Sharma went on record, and he said that it's recorded in Economic Times, Times of India, another newspaper, that Micromax, another Indian company, went out of business not because of SEP litigation, but because of Chinese competition. And the other good news is, Micromax is not out of the business. They have changed the nature of their business. Now they are in the manufacturing like Dixon Technology. And recent interview of Mr. Rahul Sharma is saying that they are making more money. Now it's a 6,000 crore company. So that's a good news. They're not out of business.
Okay, considering the question was for Eric, I would let Eric Stasiak have the last word. And this time the last word is not on LinkedIn, but live in India. I hope that we have Eric sometime in India soon, though.
Yeah, I'm just coming off the back of my vacation, which is why I could not travel to New Delhi. I already have enough jet lag. I don't know how useful I would have been in person today. I think the situation in China is instructive and it's evolving, obviously. China came into the SEP space as an implementer. Huawei and ZTE were essentially implementers. And so they had an interest in low royalty rates as implementers. That has changed in the last decade. Now some of the most aggressive SEP holders are Chinese. Huawei, ZTE are no longer interested in low royalty rates. They want to have the same royalty rates as everybody else in the world because it's their business model has been changing. And I think sort of India needs to take the same long-term view. You don't want to be a manufacturing house. You want to also do R&D and make money from your R&D. And this is the path that China has gone through. They first saw SEPs as something to be afraid of, and now they see SEPs as an opportunity. And I think the same, you have to keep the same sort of long-term view as the Chinese have. I think that's the way to go.
So at the end of the day, think long term is the message that that will resonate from everyone. So with that, I thank every one of the panelists, the audience for sticking around for this well, exhausting session on FRAND and SEP. Thank you everyone for joining in. And as is customary, the organizers will request us to assemble for a photo op. But I would also request Professor Unnat Pandit to join us for the photograph. Thank you very, very much, everyone. And I thank Professor Pandit for joining us for the photo op.
Excellent. Thank you so much.
And with that, I believe I will leave you to the jurisdiction of the organizing committee.
So as we end our panel discussions for today, so we're just waiting for Shri Sanjeev, Joint Secretary, DPIIT, to join us. He'll be joining us in few minutes. Till that time, we can enjoy the presence of our CG sir here and our think tank members, Mr. Suashish Chaudhary and Dr. Rajiv Ranjan.
Hello.
So at the end of the day, we gather for the valedictory session. And as I can see that definitely, yes, there is some exhaustion that has kicked in, but there is also a sense of excitement for the valedictory ceremony. I am so thankful and honored that for the valedictory ceremony, we will be joined by our very own Controller General of Patents, Professor Unnat Pandit, representing the Indian Intellectual Property India office. Along with that, we will have Professor Yogesh Pai, formerly of the National Law University, Delhi, and now the head of the Patents and Treaties Law section at WIPO in Geneva. After that, we will be having the thematic address by Sri Sanjeev, who is the Joint Secretary in the Department for Promotion of Industry and Internal Trade within the Ministry of Commerce and Industry. And finally, the presidential address by Honorable Justice Pratibha M. Singh from the Delhi High Court, who is the godparent to SEPs in India. So considering the time that we have and also considering the constraints of our valedictory members, we shall start the valedictory ceremony by a special address by our very own Professor Unnat Pandit, the Controller General of Patents, Trademarks, Designs. So basically he is IP in India. And the Controller General's office has also been leading a series of panel discussions which have been very rightly named as policy and progress roundtables. And we are very thankful that he will be giving us the insights from those roundtables as well in his special address. So I request Professor Unnat Pandit to come to the dais and give his special address.
I would also like to invite our think tank members, Dr. Rajiv Ranjan and Mr. Subhashish Chaudhary, to the dais. We also have Dr. Yogesh Pai, who has joined us virtually today.
Considering Professor Pandit has to fly to Singapore to attend the IP week over there as well, we'll just slightly rejig the schedule to accommodate him first, and then we could be followed by the view from WIPO. So we will be going from India to the world, over to IP in India, that is Professor Unnat Pandit.
Thank you, Aman. I will be saving some energy speaking from the same desk here. My friend Yogesh Pai, who has joined from Geneva. We have with us the FICCI experts here also on this, Rajesh Ranjanji and Subhashish Chaudhary. And soon we will be joined by Honorable Justice Pratibha M. Singh ji and Sanjeev ji also. The way the discussion which has happened in the previous session, it has ignited the entire thought process, and I have seen the entire day's session also. A very thoughtfully designed agenda, and I must appreciate the FICCI and the other organizing team members for designing such a thoughtful agenda which can lead to some conclusion, or at least a policy paper which is very much in need nowadays. The Office of CGPDTM has also organized series of round table. It requires a much awaited discussion and debate on this SCP. And in those roundtables, we have adopted theme like technology specific discussion, legal aspect of the SEP, the economic aspect of the SEP, the mechanism which is required to be designed or decided for the front terms. So on various themes, we are having a deep diving on each and every such topic on the SEP. If you randomly also see that in this hall also we have a entire discussion which has been, and pardon me all the lawyers, but more inclined towards the legal aspect. And whenever we have to see the complex issue, we primarily require to change our standing position. If we change the standing position, we would be able to see the entire complex issue from the different perspective altogether. And that may be one of the approach to see how this complexity can be resolved. And too much inclination towards the one dimension will not give us the 3D perspective of this entire complexity. I have one question to make it more interactive. Who is the innovation economist in this hall? Anybody? Innovation economist? Yeah. See, such a complex issue which has the commercial implication, which has the IP innovation, and we are not thinking from the perspective of the innovation economists. That requires the change in the dimension. The way entire front terms which is getting decided. नमस्कार संजीव जी, आइए. हमारे बीच में संजीव जी है, जॉइंट सेक्रेटरी DPIIT.
We take this opportunity to welcome Shri Sanjeev, the Joint Secretary for the Department of Promotion of Industry and Internal Trade, handling the Startups Division, which is one of the key driving forces for this event. I think Professor Pandit will will continue his address, and then we can have the felicitation ceremonies.
So this is how we need the entire perspective. Yeah, thank you. So we need the entire perspective to be seen from the applied approach. Too much of a legal aspect may not give us the right direction which is required to address this complex issue. The front terms, which is again bit very complex to derive the things which is applicable for the communication sector or mobility sector, may not be a wise SEP front term for the healthcare sector or a renewable energy sector or any other technology specialty area. Maybe a fintech. The UPI which is being utilized, National Payment Corporation has the IP on this. And more or less, even the multinational companies who are operating into the payment sector, either is the Google Pay or Amazon Pay or even a WhatsApp Pay which is there, or various other mode of payment also. Every such platform is now utilizing the UPI. And National Payment Corporation has designed it in such a way. Earlier it used to be made it accessible through Bhim app. Now also they are offering this solution through Bhim. But more applied approach has been derived, and this has been the standard norm in the fintech sector. So any payment gateway which is to be made accessible Now it has been reached to such a last mile. Even if we have to have a tea at the tea stall, he is emphasizing on payment through UPI. Any small vegetable also anybody wants to buy, the UPI, just to avoid the change or maybe n number of a reason. On a cabs and or auto rickshaw also, people are making such a useful technology intervention. We have never ever thought that this kind of a IP created by this corporate would have established such an SEP. We don't know whether they are getting the real SEP mode of a payment or transaction charges and what is their terms of reference, but the technology adaptation, that is the most essential element. If SEP has to work, then it need to make it accessible to the last mile. Another example, the LED. So when LED started, people were so much having reservation. They used to have a yellow bulb or a traditional tube lights. And the cost of goods were relatively very high. But then initially it was subsidized and people were made aware about what exactly is the need. So for making the SEP successful, we need to address the need of the common people. To ensure that SEP is successful, we need the technology which is universally adopted. And secondly, the way payments are being made by phantoms in a Western world and in India. So we need the India-centric model to decide the sectorial priority, maybe a good framework, or if not single framework, then we can have optional 3-4 models through which the cost can be derived. And certainly it cannot be a top-down kind of a approach. It should be evolved with the realistic implication in the market. And that's why the role of economist is important here. We need to get involved with the economist. In all our roundtables, maybe we are conducting in a very small gathering, but we ensure that there are a few economists in this roundtable, and with each such roundtable we are concluding something which can further take one step ahead to address the need for the country. If we have to make the SEP useful and implementing, and with the growing need, while we have a vision to achieve the Viksit Bharat, and the technology adoption which is rapidly increasing, the way technology adoption which was there in 2005, 2015 and 2025, if we just compare the kind of a technology adaptation, the age criteria and the average consumption of a product from, say, as a 100% population to what is our targeted audience, and what kind of a product consumption pattern in that target audience is there, and how much percentage of that particular product on which the SEP is going to be implemented. These are the essential aspect which is required to be considered. Without considering them, we may debate, we may cite global judgments also, we may refer to best practices, but what is India-centric approach? There is a need for designing such models, such India-centric model, and FICCI has provided such a platform where the policy discussion and debate can happen. And I was really happy with the previous panel also, and have also noted that everyone was a lawyer. No one was the economist there. Economist would have taken the discussion to some logical directions also. Because, and then, of course, the law has the balancing effect, but could not able to see that balancing effect in the previous debate, but it was interesting. And every speaker has really taken up entire discussion to a logical conclusion. But on deriving the mechanism, I think we need to see the other side of the coin also. And that aspect may be a right time to discuss, because if we are going to utilize this SCP as a powerful tool for the technology adaptation, our Honorable FM has in 2022 budget speech, she has mentioned that India has a vision to grow as a technology and knowledge embedded economy, while we are marching towards the Viksit Bharat and the Atmanirbhar Bharat goals, the 5 pillars. Everywhere the technology and knowledge space is going to dominate, and IP is the key to open the doors of this technology and knowledge space and connecting this with the economy. So we need this balancing approach, need to see it from the economic impact of SCP and the consumption pattern also, and the affordability aspect also on the technology and a product, so that we can bring the balance. And more applied approach will be required if we have to see the reality of applied SCP terms and its utilization. Because innovation will find its way, technology will find its way. See the technology life cycle which was there in 2000 to 2010, and each decade the life cycle is shrinking. So what is going to be the impact on that? So everything will be required to be taken up. I have thought of giving a new dimension to the discussion which was happening. So there might be some disagreement with my views also, but certainly the objective is to see the entire perspective from the new dimension. And this new dimension can give us so much of a statement. There are several such unanswered questions on SCP which may be required, and that is something which is required to be considered, and that may be useful for each one of us to consider. With this, I take a pause. Thank you very much.
Thank you, sir, for your thought-provoking address. I would like to invite Dr. Rajiv Ranjan to felicitate our guest of honor, Shri Sanjeev, JS, Startup DPIIT. Now I would like to invite Mr. Subhashish Chaudhary, a think tank member, to felicitate Dr. Unnat P. Pandit. I would like to invite Dr. Yogesh Pai, Head, Patents and Treaties Law Section, WIPO, to address us.
Namaste. Good evening, everyone. I hope I'm audible. Can someone
Yes, sir, you're
let me know if
audible.
I'm audible? Thank you very much. Thank you very much. Namaste, and I thank FICCI and ICRIAR and other organizers of this wonderful conference on standard essential patents, and also the industry partners who have sponsored, including the TSDSI, who is a standards partner, for inviting me to this esteemed forum. I also see that Professor Unnat Pandit, Shri Sanjeev Singh ji, and others on the podium, including, I think, Honorable Justice Pratibha Singh has also arrived. I thank all of them, and I'm glad to see that they are part of this valedictory session. So today my address is focused on some of the international legal aspects and other aspects of standard essential patents. Of course, there is a lot happening in this area, and very recently you might have heard that the WTO MPAI has delivered a decision on the question of legality of anti-suit injunctions in the context of TRIPS agreement. But my focus today is not going to be on all of the international aspects on SEPs, but I'm specifically going to speak on WIPO's role and what the World Intellectual Property Organization has been doing in this area. So most of you may know that the WIPO came out with a SEP strategy last year in 2024. And this was essentially to provide a roadmap for standard essential patents in the context of WIPO's work. And what guided us in this effort were three basic principles. One is of neutrality, that WIPO must take due account the relevance of a wide SEP in order to ensure that an unbiased, inclusive, and representative added value by addressing some of the genuine needs and without replicating what is existingly done in the national or the regional level. And third was part in another part. Four thematic clusters as part of the SEP strategy. One is WIPO as a global forum for dialogue. Second is WIPO as a source of knowledge and data. And third, WIPO as a venue for amicable agreement. And fourth, WIPO as a service provider. So the last among the two, that is WIPO as a venue for amicable agreement and WIPO as a provider of services, is not part of the activities that I work on, but there are colleagues who work on this area. But I'll give you a brief idea of what we do in this. So, as we all know, since 2010, the WIPO application. And in this, we particularly focus on what is called as deal mediation, wherein the WIPO mediation rules are applied and the mediator facilitates licensing negotiations to help parties to agree on fan licensing terms. Apart from that, we also help parties during mediation where parties wish to involve an expert or co-mediator with specific expertise, for example, relating to essentiality or relating to patent valuation. We do help them in making such appointments based on a roster that we maintain on neutral experts for patent standards. So, and it is important to note in this context that these mediation requests are between large SEP holders and implementers in Asia and Europe to facilitate agreement on fan licensing terms. You may also be, it may also be important to note at this point that IP courts, particularly, let's say from China, have referred to referred at least 10 ICT infringement cases to WIPO mediation. That is emerging as a kind of a WIPO as a provider of services. Here we are currently exploring and assessing the demand and feasibility for deploying voluntary essentiality checks using pooled resources of IP offices. And eventually what we are planning is also an AI assisted element for assisting these kind of focus on our work in this area as a source of knowledge and data, wherein WIPO has now a dedicated website on standard essential patents containing wide variety of information which in the areas in which WIPO is working on. Particularly, you may be interested to know that we are working on three key things. One is integration of the patent scope database and trying to verify it with existing standards, and I'll discuss a little bit more about it. Second is the database and the repository that we have developed called the WIPO Lex case law collection. And third is a study that we are currently doing on FRAND determination methodologies. Now, in relation to the SEP case law collection, we launched it in July 2024, and we covered a lot of jurisdictions, including India, in collaboration with the WIPO Judicial Institute. And in many ways, Justice Pratibha Singh was also involved in helping us to navigate through these cases for some specific jurisdictions. And we have more than 100 rulings now in this database collection. And these are, of course, not exhaustive, but these are noteworthy cases gathered in collaboration with national judges and with WIPO Lex country focal points. Now, the other aspect is on patent scope. Here we have partnered with FICCI, IEEE, and ITU. There's ongoing discussions. And the databases that are available, particularly the ITU IPR databases, the IEEE, these are currently being linked to patent scope, wherein you can essentially search for specific information in relation to the patents that are available on the database, wherein any kind of standards related information is mentioned. So there is a lot of information as to who the declarants are and what kind of technologies are being referred in the patent applications, etc. And there is a dedicated SEP tab available on patent scope based on this exercise that we launched. Now, the other aspect in relation to the thematic cluster is the use of WIPO's convening power as a forum for global dialogue. And in this, one of the most upcoming events that we have is the Symposium on Standard Essential Patents. I welcome you all to register for the event and attend in person, possible in Geneva, or webcasting is available on the WIPO website. But apart from this, it is important to note that as far as WIPO's role as a knowledge source is concerned, you may also want to look into the work of the Standing Committee on the Law of Patents. Most of you may know that the Standing Committee, launched in 1998 by the member states of the WIPO, focused on the progressive development of patent law, global patent law. So historically speaking, in the context of SEPs, WIPO was one of the first forums to launch kind of a document on standards and patents in 2009. And subsequently in 2018, WIPO also conducted an independent study on practical aspects relating to patent quality in the context of SEPs. Furthermore, in 2020, there was a proposal made by Canada on standard essential patents, wherein they wanted to discuss certain agenda items under the cluster of technology transfer. And since then, we have had sharing sessions by SCPO observers, intergovernmental organizations, and relevant stakeholders like FICCI, IEEE, CISWEL, MNC, and LESI, ICC, etc. Similarly, there were sharing sessions organized by the member states on this topic in 2024. And in 2025, we are coming up with a compilation of legislative and policy measures adopted by member states relating to SEPs, including some notable case laws based on the information provided by the member states. And there is going to be a dedicated web page available. So I welcome you all to, the symposium on standard essential patents, which will figure a variety of stakeholders. And Justice Pratibha Singh has kindly agreed to speak as part of the judicial panel. There are other panels also that would be very, very interesting in terms of bringing together standards, development organizations, industry players, SMEs. We are also going to discuss new use cases and various other aspects of standard essential patents, including the new dimension that was discussed by Dr. Unat Pandit on the economics of FRAND and FRAND determination and other issues in relation to the broader innovation ecosystem, including a global economy panel. So I look forward to having some of you to discuss and to deliberate as part of that symposium, and also invite you to join. Thank you very much, and I look forward to further engagements. Thank you so much.
Thank you, Professor Yogesh Pai, for that very insightful address and the invitation to Geneva. I would now request the chief guest for the valedictory ceremony, Honorable Justice Pratibha M. Singh, to come up to the dais. As is customary, it's more like a standard essential practice. We do have to introduce the chief guest. Thank you, Honorable Justice Pratibha M. Singh, for joining us for the valedictory ceremony. I would just give a short introduction of Justice Singh. Her bio is available on the website of the High Court, but for all of us IP practitioners, she holds a special place in our hearts. So Justice Pratibha M. Singh is a living legend of IP law in India. She has shaped India's jurisprudence while setting global benchmarks on the IP landscape. She graduated top of her class in Bangalore University, then received the Cambridge ODAS scholarship and did LLM from Cambridge. She curbed patent evergreening in the pharmaceutical industry, setting up her own practice, chaired the formation of the Intellectual Property Division of the Delhi High Court, and established path-breaking leadership in the Delhi High Court for IP dispute resolutions. And under her leadership, the IPD has done path-breaking initiatives such as the first court-directed patent grant and summary patent trials in court using live transcription. So some of the discussions that we were doing of what to adopt has been done by her court already. Her book, Pratibha M. Singh on Patent Law, was launched in March 2024, and the launch event was attended by all legal luminaries from across the world, and the introductions were given by Lord Justice Colin Burse, who is going to be the Chancellor of the UK High Court, Klaus Grabinski, the President of the Unified Patents Court, and Annabel Bennett, former judge of the Australian High Court. For her unparalleled impact on IP law, academia, policy setting, we are very fortunate to have her on the dais. And for me personally, it is quite an emotional moment, because from this dais, she announced that the IPD will be having technically qualified law researchers, a position that I applied to, and I owe my whole career to her from this stage. So with that introduction, I would now request Sri Rajiv Ranjan to felicitate Justice Singh. Now, before we have the presidential address, there is the short thematic address that will be given by Sri Sanjeev, who is the Joint Secretary for the Startups Division within DPIIT.
Thank you. Respected Honorable Justice Pratibha M. Singh ma'am और स्टेज पे बैठे सभी गण्यमान्य व्यक्ति और हमारे सामने प्रस्तुत जो श्रोतागण हैं, मुझे ये कहने में कोई संकोच नहीं है कि यहाँ जितने भी लोग हैं उनमें सबसे पेटेंट के बारे में शायद मैं अज्ञानी हूँ, और जब मुझे बताया गया कि यहाँ आना है तो आई वॉज एक्चुअली क्वाइट परप्लेक्स्ड कि वाई शुड आई कम, but then I thought that I will have the pleasure of listening to ma'am and Unat Pandit sir, so I decided to come here. और ये पेटेंट जो आता है बेसिकली DPIIT मिनिस्ट्री के अंदर आता है, एंड आई हैव ग्रेट प्लेजर टू से दैट उन्नत पंडित साहब के आने के बाद से ये पेटेंट ग्रांट की प्रक्रिया काफ़ी अच्छी हुई है, और उसके साथ ही इवन इन स्टार्टअप्स जो मैं देखता हूँ, और प्रोबली जो कारण था मेरे यहाँ आने का कि इनोवेशन और पेटेंट में बहुत ही क्लोज रिलेशनशिप है, दोनों एक दूसरे के बिना अधूरे हैं। और जैसा कि आप में से कुछ लोगों को पता होगा, आज स्पेस डे है। मैं बस ये कहना चाहूँगा कि जो 1962 में तुम्बा में जब पहला रॉकेट चलाया गया था, तो एक छोटे से साइकिल पे रॉकेट को लोड करके ले गया था, और उसके बाद से अगले करीब नेक्स्ट 50 इयर्स तक केवल एंड केवल इसरो था, एंड वी हैड हार्डली एनी पेटेंट्स और एनी थिंग्स टू बोस्ट ऑफ। बट इन लास्ट 5 इयर्स हमारे स्टार्टअप्स ने एक तो दबा के खूब सारे पेटेंट्स लिए हैं, एंड जो ऐसी टेक्नोलॉजीज आई हैं, जैसे मैं आई विल लाइक टू गिव एग्जांपल ऑफ वन ऑफ आवर स्टार्टअप्स हु हैव मेड 3D प्रिंटेड सेमी क्रायोजेनिक इंजन फॉर द फर्स्ट टाइम इन द वर्ल्ड, एंड all these things have led to creation of lot of patents. और अब हमारी जो जिम्मेवारी है, मैं क्योंकि स्टार्टअप इंडिया देखता हूँ, पेटेंट बनने के बाद मैम पेटेंट को आगे कैसे ले जाना है, ये हमारी गो टू मार्केट कैसे हो, ये हम सभी लोगों का एक दायित्व है कि सारे हम लोग मिलके इस पे सोचें और विचारें। इनफैक्ट 2-4 दिन पहले ही एक मैं मीटिंग में था जहाँ DRDO सेक्रेटरी बता रहे थे कि DRDO का एक अपना IPR सेक्शन है उनके वेबसाइट पे, जिस पर ऑलमोस्ट 30,000 पेटेंट्स हैं, और एनीबडी इज़ फ्री टू यूटिलाइज दोज पेटेंट्स एंड मेक प्रोडक्ट्स, बट अनफॉर्चुनेटली वी hardly anybody knew. मुझे ही नहीं पता था, and I think many of you would not be knowing that. So the question is, how do we take our patents to market? कैसे हम उसको, एक मैंने टर्म भी कभी सुना था अखबारों में ही कि पढ़ा था कि पेटेंट स्क्वैटिंग, इंस्टीट्यूट्स में पेटेंट हो जा रहे हैं, बने हुए हैं, प्रोफेसर्स ने बहुत अच्छी रिसर्च करके पेटेंट क्रिएट किए हैं, पर वो पेटेंट मार्केट में नहीं जा पा रहा है। हमारे स्टार्टअप में बहुत सारी स्कीम्स हैं जो हम लोग, एक तो पेटेंट रैपिड फास्ट पेटेंट ग्रांट कराने के लिए एक रनवे है, एंड आई थिंक मेनी ऑफ यू टेक बेनिफिट ऑफ दैट, बट आई थिंक वी शुड ऑल वर्क टुगेदर टू हैव many more पेटेंट्स। और मैं आप लोगों से रिक्वेस्ट करूंगा कि आप अपने नेटवर्क के थ्रू इस चीज़ को भी फोकस करें कि अमेरिका में लास्ट ईयर में जितने भी पेटेंट्स हुए हैं उसमें 10% पेटेंट्स चाइनीज़ लोगों के द्वारा किए गए। तो कोई रीज़न नहीं है हम पेटेंट को रखें इंडिया में, बट वी शुड रीच ऑल ओवर द वर्ल्ड and we register our patents also, so that our product and services have a global market. और इसके साथ आई विल नॉट टेक मच टाइम एंड आई विल लव टू हियर टू मैम एंड मैं यही कहना चाहूँगा कि DPIIT में पेटेंट से रिलेटेड कोई भी मुद्दा हो या स्टार्टअप रिलेटेड इनोवेशन से रिलेटेड कोई भी मुद्दा हो तो वी आर ऑलवेज देयर एंड वी विल फील very happy to assist any one of you in any kind. Thank you. Jai Hind, Jai Bharat.
Now I would like to request Honorable Justice Pratibha M. Singh to deliver the presidential address for today.
Very good evening to all of you. Namaskar. To all the dignitaries on the dais, off the dais, lawyers, friends from the IP fraternity. Since I've become a judge in 2017, my only connection with IP has been 2 stints in the IP division and then through seminars like this. So I don't say no to these events because these connect me to the IP fraternity, which is, if I may say, my home for the last 25 years before I became a judge. तो मुझे ऐसा लगता है कि IP division या IPR एक मतलब it is not just a subject, it is part of the way that we've lived, and at least the way I've lived for 25 years from 1992 till 2017 when I became a judge. इसमें हमने पूरा एक एवोल्यूशन देखा है इंटेलेक्चुअल प्रॉपर्टी का एंड दैट एवोल्यूशन इज समथिंग विच आई फील वेरी वेरी प्राउड ऑफ एंड टुडे इफ आई लुक बैक आई कैन टेल यू वीव अचीव्ड एटलीस्ट 10 times more than what I would have dreamt of that we would achieve as a country, and that makes me very proud of being part of this system and having had the opportunity to contribute in some way. So since this conference is only about SEPs, I'm going to focus only on SEPs mostly and maybe a little bit of general patenting. 2012 में अगर हम rewind करके जाएंगे, I can tell you that nobody knew what the word SEP even meant in India. No one even knew it. When I was told about SEP, I remember 2012 was the time when we were fighting the Novartis battle in the Supreme Court. The judgment came in 2013, April. So, patents का मतलब pharmaceutical था at that time. No one knew any other form of patenting which was being enforced in India. So, 2012, when we started filing cases for SEPs, even this was like, I must tell you, if we go back 2002, 10 years before that, when the internet started, I had filed a case for a company called Bisleri, and somebody had registered the domain name bisleri.com. And I'll tell you, I had briefed one of the topmost senior advocates in the Delhi High Court, and we appeared before a very, modern, tech-savvy judge थे वो, Justice Vikramjit Sen करके. उनके सामने हम appear हुए. So when the matter came up in the morning, so Justice Sen looks up and he says, Mr. So-and-so, what is the meaning of domain name? And this I'm talking in the Delhi High Court. So the senior advocate coolly then says, my lords, even I don't know, only she will explain. So 10 years from 2002 to 2012, we had all the internet law, the online law, the online IP laws issues, everything settled, and we were moving very fast. And sometime in 2008-9 came the big pharmaceutical cases, because that is the post-TRIPS regime which we got into, where we gave product patents on pharmaceuticals. That was what saw the pharmaceutical patent growth. Whether it was Roche, Cipla, Merck, Glenmark, all of these big matters. And I can actually draw a timeline and tell you that in 2012 was like the first time a telecom SEP case came. And it was a breaking point, and a big journey started after that, that India is now where it is in SEPs. So let us just go back and see what happened in SEPs in the last 10-12 years. First of all, none of us knew as to how to explain SEPs to the courts. It was not easy because we all were using 2G and then maximum 3G at that time in the phones. We had to connect the 2G, 3G aspect to the unified license which the government used to enter into with telecom service operators. And that agreement has a reference to 2G, 3G global standards. I mean, there was no other way to connect it. So we connected it to the 2G, 3G global standards. That's how we brought the whole concept of standardization into Indian courts. Courts were really appreciative of it. And I can tell you, within the first 1 year itself, there were so many orders which came from India and from the Delhi High Court that people started looking and saying, this is impossible. How is this even happening that there are so many interim orders where defendants are being made to pay the rates at 1.2%, 1.4%, or whatever is the standard rate which was being asked. People were asked to deposit monies, people were asked to pay monies, customs wouldn't clear the phones if the payments weren't made. So India started applying the normal patent law rules to SEPs. And I think that was the game changer. Because we did not consider SEPs like one alag breed or something like that. We said they are patents because in our patent statute, there was no difference between a normal patent and a SEP patent. So the law then started developing. It was pretty hazy initially, and then came the change with the creation of the IP division in Delhi High Court in 2021 when the IPAB was abolished. Till then, there was no standard for how to draft a plaint, how to draft a written statement, how to file these cases in court, how to get an expert affidavit to show the court, what are similarly placed agreements. Nobody knew all this. So the rules then, we decided to capture all of the SEP related issues into the IP division rules, which now form the template for the entire country literally. So 2012, 2021, and we are there in terms of SEPs. The way I look at it, we've been able to do a lot of innovation in IP litigation in India. There is case management, there is pro tem arrangements, there is interim orders which are passed, securities, bank guarantees, some way or the other. But at the end of the day, the key word in IP SEP litigation is balance. The court is trying to balance between the IP owner's rights and the IP implementer's right to sell as well. You will hardly see any case where an injunction is granted stopping the defendant from selling the phones or from selling the product, because the court feels no, there should be more products in the market. But yes, there should be money and royalty paid to the patent owner. So the key word has been balance, and I think in SEPs, the balance has been kind of achieved with different types of orders which have come out from our courts. We've also been able to, have growth of implementation patents during this period, which is like supporting the SEP jurisprudence, and lot of tools like confidentiality clubs, live transcription, etc. have been used, and therefore SEP litigation has been a very big success in India. And I can tell you a couple of instances, and you will realize how India has been really a leader, if I may say so. So there was one litigation where a patent suit was filed in the Delhi High Court. There was a patent owner on one side and an implementer on the other side. And the implementer in its own country of origin filed a suit saying that the patent owner should not proceed with the patent suit in Delhi High Court, like an anti-suit injunction. So then came that court gave an injunction telling the patent owner, you will not proceed with the Delhi High Court suit. So the Delhi High Court then passed an order, passing an anti-suit injunction, saying, of course not, nobody is going to tell us what we are going to do. This will be the cost that you will pay, and this will be the manner in which it will work. So the Delhi High Court suit went ahead. This had never happened globally, anywhere. This was the first time in India that happened. And the first time I remember pro tem payments were made to defendant in India at an interim stage was from the Delhi High Court again. And slowly, the SEP jurisprudence has really, grown to a very great extent. And we've been able to not just have 1 or 2 judges dealing with IPR matters. At least in the entire country, I can tell you very, very confidently, there are 20 to 30 to 40 very IP savvy judges in different high courts who are rendering judgments on IPR right now. And the Madras High Court has set up its IP division. The Kolkata High Court has also set up its IP division. The Himachal High Court has its own IP rules which have been framed. I think most of the law firms now have offices in Shimla, I'm told. Or they are contemplating having offices in Shimla. So these are the kind of things that have happened in terms of SEP litigation and how it has grown in India. Just coming back to the IP division itself, earlier I remember when we used to practice in the field of IP, there was hardly even 1 or 2 suits in the entire year in patents. Now we have at least 60 to 70 patent infringement suits in the Delhi High Court, and the majority of them are either pharma or SEP. And this is true even in other courts, but Delhi definitely has become a leader in terms of how SEP litigation is going. 2 or 3 important features of our High Court. Of course, what Aman said about law researchers. We have technically qualified law researchers now who help the judges. So as judges, we are quite confident when we have our own law researcher who can come and tell us, just explain how the standard works. What is the meaning of mapping of a standard to a patent claim? How is a claim written? So these things which many non-IPR judges, I think Justice Amit Bansal was here in the morning. He was a completely non-IP judge who's now become a IP savvy judge after having sat in the Delhi High Court IP division. So IP is nothing to be, patents are nothing to be worried about. As long as judges have that judicial mind and the judicial dispensation to be fair, it's easy because the bar is it's very qualified bar. We get a lot of good assistance and good, help from the judgments which are passed in India and abroad. So let me give you a couple of anecdotes. I remember just before the vacation, or maybe on the last day of the vacation, one of the firms had organized a seminar on SCPs. I think Sai Krishna had organized it. And there was a judge from UK who was speaking at that seminar. So we were 2-3 judges from the High Court and some industry people as well who were there. And I remember the judge had joined online, the UK judge. And he actually said, since morning, I've been reading the Delhi High Court judgments on SCPs. And at the beginning itself, he said, I can tell you, you are far ahead than us. For a sitting UK judge to acknowledge it was actually, in my own view, a very big compliment to how SEP jurisprudence has developed in India. And as Yogesh Pai just said from WIPO while he was speaking, WIPO-Lex is a global database of SEP cases. And WIPO had to, make a lot of effort to make sure that Indian judgments are on that database. And through the government and through Unad Bhai's intervention, we've been able to have all the main landmark judgments on SEPs in the WIPO-Lex database. And there are only 100 judgments or 200 judgments in that. You can imagine if 10 to 20 judgments are Indian judgments, you can actually imagine how India is breaking the barriers in SEP. Whenever now SEP seminars are held anywhere in the world, India's presence is a must. Because without Indian presence there, they know that there's a big gap. Because India is such a major jurisdiction, because the owners, IP owners feel it's a kind of a neutral jurisdiction where there's a big market And the implementers can't avoid India because again, it's a big market. So both ways, India has become economically and on legal forum wise, one of the most sought after jurisdictions in India. Now, having said all of this, we've patted our back enough. So what do we do now in the future? That's what I want to say. That firstly, as Shri Sanjeev said just now, there are a large number of startups which are there in India who are doing a lot of innovation. But they do not have the economic muscle to be able to either obtain licenses or negotiate fair licensing for their own patents. So that's where we need to kind of beef up. Secondly, insofar as our MSME industry is concerned, they definitely need a lot of support on licensing of patents. So the bigger players are all negotiating in a competitive and an equal manner. So we do not need to worry about the bigger players in the market. But yes, at the startup and the MSME level, there is a need for both sides, protection of innovation and licensing of innovation, licensing of patents. One of the best ways to do it, which is a time-tested manner globally, is to have an India patent pool. Create an India patent pool where for startups and for MSMEs, there is some legal, knowledge and support which is provided, so that on that pool, you can actually have patent owners license it to MSMEs and to startups, and startups can give licenses for their technology as well. Because if that pool is strong enough and it becomes big, then the negotiating capacity becomes big. Instead of individual startups and individual MSMEs trying to do their own work, starting of an India patent pool is a good idea at this stage, only meant for startups and MSMEs, so that we do not remove the competitive advantage of the bigger players in the market. Let them negotiate on their own. Because India should not become a compulsory licensing kind of regime. No, that is not good. You should have a free market kind of place for all the big players, but some patent pool for the smaller people who need to be kind of given a little bit of support. Apart from that, I do feel generally on patents, we need some India-specific technology to be made available. For example, for climate change, for green technologies. We do not have, a large number of startups have done a lot of innovation, but it is from the lab to the market, it is taking time and it's not happening. So patent pool created with all MSMEs and startups there, with subdivisions of industries, should make a big difference. And if it is supported by the government and the industry bodies, it will be really a big step to go forward. The second thing is, I do believe that startups and MSMEs also need legal help. So therefore, some part of licensing royalties could be created as a support fund or something like that, as part of this patent pool, for them to litigate as well, because lawyers are very, very expensive. So we need to have a support system for them. That is the second thing I would like to say. And thirdly and lastly, I would like to say that India is now a very SEP confident country and patent confident country, IP confident country. We don't need to shirk and think about, oh, do we need patents? All those debates are all over. We are now the innovators. We are now the creators. We should now move forward like a leader, rather than thinking of, what do we do in IP? We are not sorted in IP. We've now created a large IP community in India. There were just, 1 or 2 or 3, 4 lawyers earlier, even when I joined the profession. But today we have hundreds and thousands of lawyers who are practicing in this area. There are a large number of lawyers who engage only in IP technology licensing, IP licensing. They are able to draft agreements quickly. Of course, there is the use of AI, which can be used, but I'll tell you, there's a lot of risk in it. Use of AI is not going to be so easy in this area because it is very, very, very specialized. And specialization You can use AI only for procedural things and not for the substantive things in AI, because generally in law itself there is a lot of risk in using AI. AI can only be like a tool. It can never be the ultimate decider or the negotiator or the drafter or the litigator. You can only use AI as a tool and not in any other manner. So I think the takeaway from this seminar is I congratulate ICRIER and all the office bearers of ICRIER who are here and who have taken this effort to organize this seminar. And of course, FICCI has its own commitment to IPR. It has its own IP division. There are so many of the people whom I am so closely aware of who worked towards creating this this platform in FICCI. And I congratulate FICCI and ICRIER. And I think that in SEPs, there is no more any doubt that we need to move in the right direction. And as they keep saying, to go towards Viksit Bharat, SEPs are very, very important, but standards need not be the same in every industry. Standards can be different. India can create its own standards for different products, so that within the country, at least, whenever products are manufactured, maybe you need to tie up with the Bureau of Indian Standards. I don't know. That could be one way of doing it. So if you tie up with Bureau of Indian Standards, standards can be prescribed in almost all areas of products. And if you prescribe standards, then you will have a kind of a uniform system across the country, which will also lead to more and more innovation. The gaps will be filled without much difficulty, and India can be an SEP leader, and I have no doubt that India will be an SEP leader. Thank you so much.
Thank you, Your Lordship, for that powerful and inspiring address. Your words have not only concluded this conference on a high note, but also given us a vision to carry forward. Thank you. May I now request our esteemed think tank member, Dr. Ranjan, to give a vote of thanks, please.
Let me begin by thanking the Honorable Justice Pratibha Singh, who's given the presidential address, and it took me back to the old days and nostalgia, because 25 years back I used to be very active in this field, and then at that time she had said she was one of the most prominent lawyers, and we used to, I was then at that time where Sanjeev is now, in the Department of Industrial Policy and Promotion, and the Second Amendment Act was getting amended. And as you know, there were a lot of issues. The Basmati patent was getting litigated in the Supreme Court. There were Haldi patent, Neem patents, all kinds of issues, and patents were all over. And the problem was that not many people understood what all this IP is about. So we had a very big issue at that point of time, and we were very defensive. So I'm very happy to hear now what Justice said, that we as a country have achieved 10 times more, because in those days, they were the dark old days where we all thought that we are the receiving end of the whole system, because India was not considered a country where we are confident of generating IP. So we were very defensive. We were only looking at how compulsory licensing provisions should be strengthened, and again it was dominated by the pharma, because the product patent on pharma had to come in the Second Amendment. So from those days to now, when we are discussing SEP, we are discussing licensing, we are discussing what we heard just now, that we are not only confident, we are now taking a leadership position where a lot of innovation is happening in India. And we are not only patenting, and thanks to Professor Unnat Pandit, you see, we heard him speak, giving the special address. And I was again involved in the modernization of the IP offices. In fact, the logo of the IP offices, all those things were done when I was handling that 25 years back. So that is a time where the modern offices in all the 4 metros were conceived and constructed. So I was part of the, I was actually heading the IP administration modernization project. So let me share, and I'm very happy to hear now the fruits of all that. We can see now that 1 lakh patents given in a year. The number of patents increased. The time taken in fact examining the patent and having a highway to expedite some of the patents. So all kinds of things have happened which has streamlined the whole system, and that is a very big achievement in itself. So we are very happy to hear the Controller General of Patent, Design and Trademark give his address today, so I'm thankful. Dr. Yogesh Pai, Head of Patents and Treaties Law Section in the WIPO. In fact, last time I was here, I was sitting in a panel along with him, so I'm very happy to hear now that he's in WIPO. And WIPO, as we all know, is a very important body as long as we are discussing the intellectual property patents in particular. So I'm very, so just to, I don't want to take too much time, it's been a long day. And from what I had seen about the previous few panels, it has been very engaging, very interesting. It has given us a lot of food for thought. And with this, especially the presidential address of Justice Pratibha Singh has given us so much of, in fact, confidence in not only the litigation aspect of it, which is very important, but also to see that India as a country has how it has evolved. And I've seen it, I've been a bystander, I've been a participant. So FICCI is, in fact, let me remind that at that time, as she was mentioning, not many judges were very familiar with this whole area. So FICCI was roped in, FICCI, CI, the industry body, were roped in to have interaction with the judges. And this started with the Supreme Court judges. So all the Supreme Court judges were very, very eager, and there was a symposium in Bhopal. And I was at that point of time honored to be speaking in that on the patent law changes. This is many years back, and this we did for many other High Court judges all over the country. So this is very important, that how the importance of IP, the knowledge, awareness of it, and not merely among the scientists, but this is again very important. This is a technical subject. So during the Act changes, we also had the then Law and Commerce Minister, Mr. Jetli. We had gone to him and said that, look, a lot of patent lawyers are there, and the earlier system did not require a science student to be a patent lawyer. So that was changed. At least a rudimentary knowledge of science is required to understand what a claim is or what a system is. So I'm just saying that some of you would be here, realize that how it's a very complex field. And because we were dealing with at that time things like the Basmati patent and all that, we realized the rice cake patent, some of you may realize, that anyway, let me not get on with all that. It's been a very interesting day, and at the top of it, after the presidential address of the Justice, I'm sure that you are very enthused that we have come a long way, and the future is very bright for not only patent litigators but also for people who protect the patent, the innovators. And the SMEs have done very well. The Startup India, I must say, Shri Sanjeev has been leading that. In the last 5 years, they had 310% increase in patent filing by SMEs in India. As I said, that this has happened. The Controller General of Patents has given has done many things to streamline and hasten the whole process. And that is how there are large number of benefits which now come for startups and small SMEs to generate IP, and that's happening across many fields. It is no longer only the domain of pharma or only few. And that is why it's very good that we had this kind of a session on SAPs. So let me thank all of you for your participation. DPIIT, Department of Science and Technology, CDOT, WIPO, ICRIER, and FICCI, obviously for having the platform and giving us the opportunity to interact. Thank you.
Thank you, sir. May I now request a group photograph, please?
I'll request all the panelists to join us for a group photograph, please. All panelists जो भी हैं अभी उनके साथ में